Good morning, everybody. Welcome back. Just waiting on final moments here before we go into court in Boise with the Bryan Kohberger case. Boy, it's been a minute since we've had something on this case, and then we got absolutely flooded. Oh, 100 some filings to catch up on, starting from back in February when I was still down in South America. Awful lot to catch up on. So things are a little bit, I mean, it's morning. It's always a little chaotic. It's not super early, but we have a little bit of just added chaos around here this morning to alert you guys to. First off, you may have heard we are working with a new live stream system from the Idaho 4th Judicial District. They are no longer live streaming to YouTube. They've set up their own website for purposes of streaming these hearings. So I do have that ready to go, but it looks a little bit obnoxious because it seems to be one of these things where we might just have to keep refreshing and refreshing and refreshing and refreshing until it gets started. So I am going to keep an eye on that, but just be aware that if I'm a little distracted, I'm probably having to check in to see if anything is going on in the courtroom yet. As usual, because this is a new system, we may have to play with sound levels and things like that to try to get a good, balance and quality and stuff out of the courtroom compared to the stream. And lastly, I am doing this on my own this morning while we get started because Jeff is off on a chicken mission. I don't know if any of you guys are trying to buy chicks this year and are having the enormous amount of difficulty that we are. People must be getting really sick of egg prices because you can't really buy chicks right now. They're selling out like instantly. I mean, hundreds of them within, an hour or so. Lines that are 100 people deep. I mean, it's been something real wild to see. So anyway, we have a place close to home that is supposed to get a shipment in today. Some nice Americana chicks, which I've been looking for a long time. So Jeff has to go down to be in line to get a number so that he can go back when the truck arrives and hopefully be able to get us some more chicks for our flock. Because of that, like I said, I am a little bit disoriented trying to get all this sorted on my own, and I don't have my help over in the private chat. So hopefully that gets wrapped up, and Jeff can get back here soon and make sure that we're on track with everything. Well, I know I said I was going to try to do a bonsai video to go over these motions in limine, and guys, I really tried. I did. It was terrible. It was absolutely appalling. It was just too much divided attention for me. Got real rambly and off track. And then like halfway through, of course, somebody starts running a chainsaw in the background. So just, no, threw my hands up. That wasn't going to work. I will do a different bonsai video some other time. We're really at the tail end of the repotting season here. But I got a big old juniper that's going to take a lot of my attention. So I will try to get something that I can share with you guys out of that. But in the meantime, I went ahead and wrote up my analysis of kind of what's going on with emotions. Not a like deep legal analysis or anything like that, but just kind of a quick reaction and how I'm predicting the rulings on these motions are going to go. That's up on Substack in two parts. The first part is looking over at the state's motions. The second part is looking at the defense's motions. Of course, I, as usual, got my tons of notes on everything that got filed. But I do kind of have a top 5 of what I'm interested to hear about today. And so let me go ahead and share that with you. The number one thing I am most interested in hearing about in this hearing today, I want to hear more about this advance timing report issue. This is the situation that produced that really scathing affidavit from Cy Ray, where he's not holding back. He is overtly accusing the prosecution of misconduct, of being misleading to the court. He is very strongly insinuating that the FBI has materials that they are withholding, that they are not disclosing from the defense. The problem, from my perspective, just based on what we have in the record so far, is that it is so far kind of just an insinuation. The state has responded to the defense's arguments by saying, here's this global legal demand center process that you have to use to get these records from AT&T. They only retain them for 7 days. The process changed in 2023, but back when we were looking for these in 2022, that's not how it worked. The defense has already substantially rebutted a lot of those claims by pointing out you got timing advance data before 2023. You use this backdoor method that Cy Ray, being the 99.9% of the time working for the prosecution guy, is going to know about. So he described that a little bit in his affidavit as well. So Global Legal Demand Center is not the only way that these records can be available. Cy Ray has pointed out that you got them. It's clear that they're in your work product, that you've relied on them. You talk about them, but he's not real specific about those details. He makes it very clear that they got timing advance data for some of the victims, one person of interest, and at least one cell tower. And so when he says it's in your work product, I can see that you had it, it's not clear that he's talking about Bryan's timing advance data. It's not clear to me that that's what he's saying, or is he just saying timing advance data generally? I really wish that had been more specifically spelled out. Same thing with the GLDC and kind of the implications of having this back door, because it's a really important point that the state has made, that these records were only retained for 7 days at that time. But it's not clear, was that only through the GLDC process, or is that also apply to this backdoor that the feds were able to use before it became generally available to other law enforcement? So those are just some details that are kind of hanging out there that makes it very, very difficult to pin down exactly what is going on here. What do they have? What are they relying on? And of course, Judge Hippler ruled that no, we're not going to take live testimony on this issue from Cy Ray, that the defense specifically asked to, but we're not going to do that. We're just going to have them kind of on call in case he wants to bring them in by Zoom to give more testimony. But he's going to make that decision, I guess, once the argument gets underway. So I really do hope we hear more. I'm just not necessarily that confident that we're going to. My concern is that, it looks like the court is maybe going to make this easy. Here's what they're showing us now. So that's a positive sign. No more refreshing. So we'll have that ready to go as soon as they go live. My concern is that the court is just going to look at the affidavits and say, well, you didn't rebut this point. You haven't met your burden. You haven't given me anything I would need to be able to find that there has been a deliberate withholding here, that the state has misrepresented something. And if you want a court to find the prosecutor has been involved in shenanigans, you really have to make it an unavoidable conclusion. So very intrigued by this motion and to see how it develops. The fact that Cy Ray is the 99.9% works for the prosecution guy carries huge weight with me, because I just find it very hard to believe that he would be cavalier about throwing out an accusation like this when it concerns his bread and butter. These are the people he works for. So it's a really strong call out. I It makes me inclined to think he knows more than we're being told in the written documents for some reason. But I just don't know. And so unless we get more information through this hearing, I'm not sure we're going to get that answer, at least until we get to trial. Second thing I'm very interested in, boy, that Amazon click data. Okay, this is the motion that has information in it suggesting the state is going to be able to prove that Bryan Kohberger bought a K-bar knife sometime in January of 2022, along with a sheath, along with a sharpener. And then after the time frame of the murders, was shopping for a replacement. This is not a good fact for Mr. Kohberger if this can be substantiated. It doesn't look good. Okay, it doesn't look good at all. It's a coincidence. Could it be just a coincidence? Absolutely. But the problem is, once coincidences start to stack, that becomes circumstantial evidence. That gets a lot harder to convince a jury to just write this off as, lots of people buy K-bars and things happen to them and so forth. When you have the K-bar combined with a sheath at the scene that's got his trace DNA on it, that's a hard circle to square. So this is very intriguing information, but it's also a little bit ambiguous because it seems not very straightforward. It isn't a situation apparently where they have a record from Amazon that shows a knife being purchased by Bryan Kohberger, and that's that. They have a range of dates where they knew that he purchased a knife. It's not clear if that ever led them to something more definitive. The defense is referring to a household account. This is apparently done on the family account back in Pennsylvania. Certainly it was before he came over to Washington to continue his studies at WSU. It's also really unclear how the prosecutor claims to know that he bought the K-bar. They say they have a witness who knows. Well, if you're going to have personal knowledge of something, that's a pretty narrow window of people. It suggests somebody in the family, suggests somebody on the account who's familiar with the use of the account and who got what and so forth, is the one who told the prosecution, hey, when this K-bar knife got sent to our house, that was Bryan. That was Bryan that bought it. If that is the case, then that takes me to the third issue. I'm kind of interested in seeing whether or not Bryan's family is going to be excluded from the courtroom. Because boy, what an absolute asshole move. If they provided this testimony, if they're going to be the ones to say, Bryan bought this knife, that is potentially evidence that will get him convicted. And that's how you're going to repay them, is by booting them from the process where you want to have their son executed. That's wild. That's wild to me. Just wow. Just wow. So hoping we get some clarity about exactly what this information is. Is it the same knife? Is it the same sheath? What exactly is it based on? If they can prove that, same knife sheath, same style and shape of knife, things like that, serrated blade versus straight edge. If they're able to make that determination from the knife, from the wounds on the victims, that's going to be bad. It's going to be very bad. And he's going to need to have a very good explanation for what happened to that knife, because they sure didn't find it when they searched his apartment. They didn't find it when they searched his stuff in Massachusetts. They didn't find it when they searched his car. He's going to need to explain what happened to it, or that is going to look really bad. And I think it would probably get him convicted. Fourth thing I'm interested in this hearing today, the alternative perpetrator. This was not real like extensively briefed or fleshed out. It was very general. The defense just said, well, we should have an opportunity to be able to make a proffer about third-party suspects. The state is saying, there's nothing non-speculative. We cleared all the tips, so you shouldn't be allowed to point the finger at anybody else. Now, Idaho is one of these jurisdictions that has a little bit more of a relaxed standard for admitting alternative perpetrator evidence. Some courts put this high bar on it, saying, it needs to meet these extra levels of reliability or whatever before it can be admitted into court. And there have been arguments as a result of that this is unconstitutional. This is impairing the right to present a defense, because the general standard for evidence to come in court is simply relevance. And so for you to put these additional requirements when it comes to a defense being able to present a defense, what you're really doing is you're just making it harder for them to be able to present a defense. And so Idaho, perhaps in response to that or just on its own accord, does generally evaluate these types of defenses through a relevance-based lens. So nothing as complicated as will we ever be able to establish a nexus in Judge Gold's court? It's not that bad, but it does have to be something more than just, well, somebody else could have done it. This person could have done it. They live in the neighborhood. It could have been them. You gotta have a little bit more than that, because pretty much anybody could have done it. There's probably hundreds of people that could have done it. But it doesn't mean that it is likely that they did, or that it's really helpful to the jury in evaluating if they did or not. So it is a little bit more than just, possibility, but the bar doesn't necessarily seem to be that high. Are they going to be able to point to other people that may have motive, to other people that may have had opportunity, people that they had recent contact with, people that they had conflict with, anything along these lines? I'm just going to be interested to see how that unfolds. And there's a little bit of overlap between that and the motion that has to do with the DNA comparisons, specifically the DNA from under Maddie's fingernails, because the prosecution has said, we tested it against all of these different people, including Jack DeCoeur and Cole. I think his name's Brandenburg, something like that. And so, the defense can just cross-examine on this. It's not something that we need to have. We need to have an evidentiary ruling on one way or the other. We just let the evidence develop at trial. Well, the problem, though, is that in this this alternative perpetrator motion, the state is specifically asking that the defense not be able to do that it not be allowed to name specific people. So are they able to cross-examine on these names or not? Why were these names in particular, used as comparisons? What's the relationship between them? What was the contact between them? Why might we be thinking that it's these individuals? We know some of this from public reporting, but it hasn't come out in the trial process yet. So I'm just going to be interested to see where exactly that line is drawn. I was also a little disturbed. At this defense suggestion that, I'm okay with the idea that there's alternative perpetrators all over, because it's kind of like Richard Allen, where the evidence is not particularly strong when it comes to him. And so you can look at other potential suspects as well and think, there's probably at least as much evidence against, say, a Ron Logan, an Elvis Fields, or whatever, as there is against this individual. I could certainly see that being the case in this case as well, just because it is not overwhelming. Okay, it's not zero, but it's really not overwhelming. They don't have the blood connection. They don't even have the social connection, as far as we know. So, yeah, just interested to see how far they're going to be able to go with this, and who, if anybody, they're going to be able to name as potential other people for whom there might be just as much reason to suspect their involvement as there is for Bryan. The blood, the unknown blood. This is a whole other wrench in all of it as well. We got the 2 unknown male DNA samples that we know about that were blood samples. One from the banister in the house, a different one from a glove outside. We don't know who those people are, though, but that is certainly evidence that gives them a good basis to point at a potential alternative suspect that should have been more thoroughly investigated by law enforcement. But there's also another fact sort of implicit in the filing about the testing on the sheath. And that is the fact that apparently there is mixed blood-sourced DNA on the knife sheath. It was compared to Bryan and he was excluded. Why is this important? It's important for a couple reasons. One, I think everybody would assume, and probably fairly, that a mixture of blood on the knife sheath, given the circumstances in which it's found, probably at least some of it came from Maddie or Kaylee. That just seems quite logical. But if their contributions could account for the entire mixture, we wouldn't be comparing it to other people. So that very strongly suggests it's either not a 2-person mixture containing both of them, or it's more than 2 people if it contains both of them. The other piece in it that's really important is that you wouldn't have any reason to compare it against a male unless there's Y chromosomes in it, right? If you have nothing but X chromosomes, you can typically assume, if it's a decent quality sample, which blood usually is, that you're dealing with females. It's the presence of the Y chromosome that tells you, oh, there's a male in here. So if that is the case, if the reason why they tested Bryan against this mixture is because there is male DNA in that mixture as well, boy, that sure doesn't make it look like him, does it? Blood versus trace, That's a very different story. That's a very different, much more limited range of possibilities for how that blood DNA got on the knife sheath than how the trace DNA ended up there. The last thing I'm interested to see if we learn a little bit more about is this vehicle identification process. The defense is arguing this shouldn't even be allowed to come into court. It's so speculative. They just looked at photographs that were like screenshots from surveillance footage from all these different places all over town. They collected white cars. There's no proof that they're the same vehicle because the footage isn't continuous. So we're just guessing that these are the same vehicles. And you didn't even identify the 2014 to 2016 Hyundai Elantra from the surveillance footage at King Road. You just found another white car over on Ridge Road, which is like a quarter mile away. And you said, that's it. That's the one. I don't know how all of this is going to flesh out from a standpoint of like, how is the state going to explain? What did you do? How did you determine that these are probably the same car? Like what was your thought process? What were you relying on? What did you look at? But also, of course, the defense is going to be highlighting what didn't you look at? Are there going to be other potential sources of video here that don't help your claim that these vehicles can be connected? We already have seen the defense making arguments about that when it comes to the location, the tracing of the path of the vehicle that the state has alleged was taken by Bryan, their allegation by Bryan from his apartment in Moscow or his apartment in Pullman to ultimately ending up in Moscow. We've already seen the defense argued you had to ignore, certain video that would have shown his car if it had been there, if it had taken this route, but you don't have that video. We need to assume that's for a reason. So I do have to wonder if there's going to be analyses and explanations kind of like that with respect to what the state is claiming here as well. We did get through this motion at least a small look at some of what the FBI was looking at. And I got to tell you, I'm not super impressed. I'm not super impressed. There's kind of this idea that the FBI has some, greater ability to be able to make these types of comparisons than lay people do. And that may be correct. They may have tools that will help them scale these images to each other, that will allow them to compare things like proportions, the relationship, racial relationships.
31665. We have representing the state, Mr. Thompson, Ms. Jennings, and Mr. Horowitz. And for the defense, we have Ms. Taylor, Ms. Massoff.
Let me see if I can boost the sound a little bit.
Welcome to the fray. I think I saw you back there. And
let me know if that sounds a little better, guys.
For missing either, Mr. Nye. All right. Today we have a number of motions to get through.
27, in fact.
Get through today, we will take up tomorrow. You should have received by email a listing of score sheet of the motions and a rough order that will take those up in, separated into groups. Within the groups, we may not stick exactly to order, and we may take up several within a group if they're related at the same time. So,
okay, I turned my volume down a bit. Let me know if that's better.
Defendants' motions in limine regarding inflammatory evidence, use of the term murder, and use of the term psychopath or sociopath.
So we're going to be grouping these motions.
Thank you, Your Honor. I'm guessing from the court's comments, the court wants me to address all three of those. I'll do that then. Your Honor, the motions are brought to the court based on Mr. Kohberger's constitutional rights and the rules of evidence and relevant case law. With regard to the inflammatory evidence, that is requesting that the court issue an order preventing the state from trying its case with an emotional appeal or an excessive use of emotional phrasing or an excessive use of repetitive photographs. Certainly, we understand that there will be photographs that we may not like that come in, testimony that we may not like that will come in. But what we're talking about is an excessive use of emotional appeal. That the examples that we've seen in relevant case law come from State versus Ellington. In that case, the prosecutor repeatedly used a phrase that was inflammatory about the defendant having run over the wife of a witness who was testifying. And that was found to be inflammatory because of the excessive use of that phrase. Additionally, in that case, there was an appeal to juror emotion when the state sought testimony from a witness about why he might have left his job. Those are examples of what we're talking about. The court has to do the rules of evidence balancing test, and to do that after the state has elicited inflammatory testimony is difficult to undo and puts Mr. Kohberger in a position where the jury's already been inflamed. And so we're seeking to prevent that. Your Honor, I will move then to our motion regarding the murder term. This motion is also based in Mr. Kohberger's constitutional rights to due process and to a fair trial. This is not a motion to ask the state not to use the term murder. That's going to come out when the court reads to the jury the charging document. That's going to come out in jury instructions. This motion is about the state, through its witnesses, labeling Mr. Kohberger. That invades the province of the jury. Mr. Kohberger sits here today. He's innocent, and it's up to the state to bring evidence and a jury to decide if that's different. The state, by using that kind of term as applied to Mr. Kohberger, gets in the way of what the jury needs to decide. Back when we were looking at a change of venue in this case, we worked with a social scientist named Dr. Amani El Aleli, and she talked a lot about how bias is made in people and how we think about things and how we remember things. And one of the things she talked about, and her report is in the court record, one of the things she talked about is the influence of people in a position of authority. And for the state to come in and label Mr. Kohberger in their position of authority, or ask a witness, especially a witness in uniform, to do so, is very detrimental. It's inflammatory to Mr. Kohberger, and it would—
Outside of opening statements, perhaps, where the state might say, we intend to prove the defendant murdered the victims, perhaps in reference in voir dire, that, you know, in this case, the defendant is accused of murder. I'm having a trouble understanding how this would come up during the evidence phase of things.
Your Honor, that's why I'm asking the court to—
It's
issue an
when the
order to
witness says,
prevent it from
after we
coming up.
determined that Mr.
Sounds like
Kohberger
you're asking me
murdered
to
the
issue an order that
victims.
says the state shall not commit prosecutorial misconduct, or the parties will follow the rules of evidence.
Your Honor, I would like an order that the parties will follow the rules of
I'm
evidence.
sure the state would like one too.
I'm not going to oppose that, Your Honor. We'll get to the state's motion.
I don't think I need an order because, as the name implies, they are rules, which means they will be followed.
Your Honor, in an abundance of caution, we bring these motions, and that's based on review of case law and based on years of experience when things happen in trial. I found, and I believe, that it's relevant to bring these kinds of motions before the court now and have all of the parties aware of—
I think there's maybe a difference between bringing them to make sure that the issues are highlighted and the parties are vigilant, versus perhaps entering sort of prescriptive orders that are so broad and vague in nature that they are essentially meaningless.
Your Honor, this
It's
is
a
my
fair point.
opportunity and the place that is reserved for the defense to bring these motions. I think that they're important motions, and with court's orders, it makes it more clear. Even if the court order isn't spelling out, you can't say this, you can't do that. I think there's an awareness, and I think it's relevant to have that order. I think it's important to have that order. And most of all, I think it's protective of Mr. Kohberger's constitutional rights to have that order. That's our request with regard to—
Address sociopath or psychopath. Doesn't
Yes,
seem
I'd like
the
to
state
address—
was intending to go there, but you're welcome to address it.
Your Honor, if the state is stipulating not to use those terms, I don't need to make a full argument on that, but I'm prepared to do so. I'll be brief. Then with that, we brought this motion again under Mr. Kohberger's constitutional rights to a fair trial and due process of law. This motion is really spelled out in Dr. John Eden's affidavit when he talks about the unreliability of tests that might label somebody in that particular way, and the danger of having that label applied to somebody. If that's allowed to happen, then Mr. Kohberger is colored with an opinion or a way the jury will view him that is unfair.
Yeah.
And
It's
our request
pretty
is that the
negative
court not
characterization.
allow the state to label him in testimony as a psychopath or a sociopath, because any kind of testing is unreliable. that would relate to, or that would become problematic within the rules of evidence to do so. And the inflammatory nature of those kinds of labels would.
I'm not aware of any testing that has been done that has reached that conclusion. Am I missing something?
You are not missing anything. There has not been any testing. There has not been any labeling. This, again, is my opportunity to bring a preventative motion to protect Mr. Kohberger's constitutional rights. And that's the purpose of that motion. Thank you.
Already great signs of consent from Judge Hippler here, right? Body language.
And as the court is aware from the responses that we filed, Mr. Nye and I actually kind of divided these motions up. We didn't realize they would be heard together. But as to the inflammatory evidence, what the court has noted is exactly what our concerns are. In the defendant's filings, he doesn't specify what inflammatory evidence he's concerned about. He doesn't define the phrase exceptionally inflammatory, nor are we aware of any definition of that. The words just seem to be used loosely and freely here. And in fact, in the defendant's reply, he acknowledges at page 2 that he really doesn't even know what he's trying to object to. He's asking the court to presume that something's going to happen or anticipate something without a basis for it. We don't see any basis for the court to enter an order. We intend to conduct our trial professionally. And we anticipate that if there are questions about anything that we do, that there will be a timely objection and the court can address it in that fashion. So our prayer to the court is the court deny the request for orders that the defendant has made and simply preserve the defendant's opportunity to object if something of concern comes up in the future.
That's what he's going to do. He's not wrong that these are kind of motions that say, would you follow the rules of evidence, please?
The purpose of using exceptionally inflammatory is used in conjunction with our recognition that in case law, photographs that we might not like will come into evidence. Exceptionally is to define what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
All right, the standard for motions in limine, which I'm about to set forth, applies to most motions today that we will address today, and I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning.
Yep, that's true.
Because of the breadth and lack of specificity of the motions. With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence, and I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things, but for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms where they're equivalents. If something happens where you believe a door has been opened before launching into that in front of the jury, you are also required to bring that to my attention outside the presence of the jury. With respect to the term murder, well, let me start with the term murder. So I don't, obviously the jury is going to be charged with what the charge is or our charges are in this case, which include first-degree murder.
Yes,
I don't
primarily.
think there's any problem in
murder.
using the term murder as it describes the charges and the allegations. Testimony or statements by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it, because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder.
Please now apply that to touch DNA.
Prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury. And that's obviously important. Both of those are important to make sure your witnesses understand as well. With respect to inflammatory evidence, I don't know what that is until I see it. Certainly there are rules regarding prosecutorial misconduct. I think counsel is likely well-versed in what those rules are. I'm not one that says I'm going to order that you follow the rules. You are counsel licensed professionally by the bar, admitted to this court. Your obligation is to follow the rules. And that is what I expect of counsel. And so any attempts to skirt the rules without a good faith basis to do so will be problematic. In terms of, and I think really where there's some potential gristle, meat on the bone here, I should say, relates to, I suppose, the photographs or videos of the decedents and the state of the crime scene. This, I would imagine, from what I've seen, some of those photographs are particularly graphic, but make no mistake, these murders, whoever committed them, were brutal and were horrific. And so I suspect that the evidence will reflect that. Now, if it comes to cumulative evidence, or perhaps some that are unnecessarily graphic, we can address that on a case-by-case basis. And so I think the idea is before you show the evidence to the jury of that nature, that counsel be given a copy of that. Obviously, if you're going to be seeking to introduce those, they will be given a copy, and we can have a discussion outside the presence of the jury about how many, which, et cetera, will be presented. But I don't feel it's really does anything it doesn't advance the ball for me to abstractly say, don't use inflammatory evidence.
I think all
So
this
I'm
is
not going to do
very
that.
fair,
I will
very
rely upon the
reasonable.
obligations of counsel as
He's
professionals
basically saying,
to understand
and you're
their
right,
responsibilities.
if it
And when it
happens.
comes to the specific actual evidence, then we can review that before it's presented to the jury.
So I have no issue with this. It's appropriate to raise it so everybody's on the same
Next,
page that it's an issue, but not a good
Is,
thing to issue an order in
unnoticed,
advance on.
404B evidence and evidence regarding the, and the 404B evidence that was noticed in this case, which is the traffic stop.
I'm prepared to address that, Your Honor. I do note on the court's list, state's motion regarding improper death penalty comments is actually next in order, but we'll take it in whatever order the court
Well,
prefers.
Yes,
Let
you
me,
will.
let me, if you want to address that, let's do that first. I apologize. I should have included that within the group because I think it kind of falls within the same category. I think you understand what my rulings are, but I can address it specifically if counsel would like me to.
Ms. James was going to handle that. We're happy to just submit it to the
I
court
think it's
on
the
the
defendant's
files.
motion, so if they want to argue it, they can.
Your Honor, it's the state's motion.
Oh, is it the state's
It is the
motion?
state's
I apologize. Oh, that's right. I was thinking of it in the opposite terms. That's fine. This, if you want to, Ms. Jennings, address that briefly, you may.
Thank you, Your Honor. I will.
And this relates to the concerns that the defense may say something like the state's trying to kill Mr. Kohberger or something of that nature, as I understand.
Yes, Your Honor. There has been a history in this case of that mischaracterization of 18-4004A. We're just hoping that that mischaracterization is not made in front of a jury.
It's not a mischaracterization. It's just a
considering the court's
characterization you don't like.
Comments this
And it
morning,
probably is
as well
improper in
as
front of a
defense
jury.
counsel's comments that there shouldn't be statements made whose sole purpose is only for an emotional appeal. I think that this is settled. And defendant replied basically saying the same in their response, that they suggest to use phrases that comport with existing language and statute and jury instructions. And that's what the state is asking for. Thank you.
Any response?
Briefly, Your Honor, we're satisfied using language that's already spelled out by statute, by jury instruction, and that sort of thing.
Death and
So,
death penalty.
With respect to this motion, I think the ruling is really sort of encompassed within my, for lack of a better term, ruling or instructions about argumentative comments or statements of counsel. The example spelled out by the state, I think, would fall within that category of being argumentative and would be improper by counsel. And so obviously that shouldn't be done. And so they should comport with the language and at the appropriate time and in the appropriate way that is not argumentative to address that issue. And so they are so ordered. All right, let's take up 404.
Good morning, Your Honor.
That's all.
Your Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, one of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that would fall under 404B as other act evidence. It's a 2020.
It's a bad act?
It's the rule says other acts to show knowledge or plan. And so the state has expressed that they plan
That's
to use
how you
that
can
paper.
use it. It's.
I'm sorry, I can't hear you.
That's how you can use it under 404. The way you can't use it is a prior term of colloquial term is
Her point is
a
they
prior bad
haven't
act
announced it,
to
noticed it
show
as
that
404B.
the party acted in conformity with that they have propensity to commit bad acts. For example, as it relates to the traffic stop, I suppose the
The
concern
notice
is,
isn't saying,
well,
I'm going to introduce
he
propensity.
committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene. So our position is that we don't want to make sure that there's not some sort of in-run. The same example that I will give you has to do with the Amazon records.
I don't think that we're reading the rule the same is the concern I have. And so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is, in essence, trying to anchor it to a bad act without giving notice of that.
Well, I just don't think your understanding of the rules comports with my understanding of the rule.
All right. Well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
But it's not a bad act to purchase things on Amazon.
Well, they're certainly
But the
trying to
state
argue
is
it's a bad
using
act.
it, Judge, to show, using it as other things to show a plan or knowledge or intent.
But that is not what 404 precludes. 404 precludes a bad act, a prior criminal act, a prior, the best term
Well,
is bad.
technically, it's evidence of a
something that
crime,
would
wrong,
suggest
or other
that
act.
it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
404 isn't limited to bad acts. It includes any other
Our
act.
position that the state is trying to do an in run on that with this evidence. And that's why we raised the issue of
404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice. They should not be able to argue evidence is a prior bad act or make any attempt at an in run on that rule.
So I'm not understanding what you mean by an in run on that rule in this context.
The rule says if you want to
By
use the
saying
other
that
act,
the argument about the Amazon
this,
purchase
you have to notice.
is that was prior to November 13th,
Correct.
2022, for the purpose of making a plan. And that's the argument that the state will make about that.
I mean, I think I understand what you're saying. I just think we're
So I think,
completely missing
okay,
each other's understanding of the rules of evidence.
well, I still stand by my position that the state
Ms.
should not
Mathis,
be able to in run that.
read him
And
the
I'm
rule.
hearing the state say that they have no intention of doing that.
just read him the rule.
Well, I'll hear what they intend to do in terms, because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence. But I will
Let's
listen
get
to
the
their-
language of the rule
Okay.
in front of the judge.
Do
we
you
have
want me to go
record
to the 404B on the video or
on
keep
the
it separate?
video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car that is not just the make and model. It is Mr. Kohberger's statement that he doesn't think state seatbelts provide much in the way of safety. Mr. Kohberger's question about why they need his phone number. Mr. Kohberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of this traffic stop.
Pardon?
Remind me of the date of the traffic stop.
It is on August 21st. So it's
What year?
of 2022. So it's remote. It's
Before the murders.
yeah, yes.
2 months
Before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Well, yeah, that's proof.
Exactly. And so it's
I mean,
different.
the point of it being, as I understand it, is to show that the defendant owned a white, well, I can't remember the name, the maker.
Hyundai
Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records, and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. The state
Sounds like that makes the evidence of, I guess I'm just not tracking again under 404 how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy. How can you make this determination of what the automobile is, et cetera? It, to me, is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is kind of what you were talking about, which is 403.
It's the
I
other
haven't heard
stuff
anything that's 404, but
that's in this
Okay,
video.
well, they've noticed it as 404B evidence. So I'm arguing it in that context and what other things can be drawn from this video that make it overly prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Kohberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
it makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. It's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity,
But you don't get
his
to, and
phone
I don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course, I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence.
I'd
And
like
when
to
we
know
think
that
that
too.
evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument. We ask that you exclude this video, which I will ask that it be, that the marshal provide that to you, and that the state use a different method of proving identity.
Thank you.
I understand what she's getting at, I think, but this was very disjointed. It would have been a lot more systematic to just give him the rule and explain. Part of the rule
I think
is determining
after what we just heard,
it's
we can
more
cut to the
probative than
chase.
prejudicial.
The defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, that's all incriminating evidence. That's why the state is offering it. The defendant doesn't like the fact that it's incriminating, but that's not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Just because it's prejudicial, and just because the defendant doesn't like the fact that we can prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask that the court deny the defendant's objection to the admission of this evidence.
What about the concern within the video, as I understand it? First you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another of violating the traffic laws in some way, including by not wearing a seatbelt. And so can you address that part of it, the prior bad act, and how the court should deal with that?
Pepper is
And then
smarter
also
than
I am
everybody else
concerned
in this courtroom.
with the issue raised about the communication
He
between the
understands
officer
what the
and
problem is.
Kohberger, for example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
And I appreciate Your Honor's comment. I think when you review the video, you can the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Kohberger and Deputy Duke somehow showed that Mr. Kohberger was a bad criminal type of person. We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt somehow means that he is guilty of murder. I mean, that's a preposterous concept. And the defendant seems to have backpedaled from that
but it
before
can
Your
mean
Honor
he's
just
got disregard for laws. He's
the state's
antisocial.
purpose
He doesn't
is
care
to
about your
elicit
rules.
the vehicle.
He's a
and
bad
connect the
guy.
defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety of the relatively brief traffic encounter, we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different. But we don't see that as being prejudicial. We certainly are not trying to argue some sort of propensity that because he questioned about, why do I need to give you my driver's license, that all of a sudden that makes him a murderer. I mean, that's beyond a stretch of imagination. Does that answer Your Honor's question?
Thank you.
The point is the video
Thank you,
can
Judge.
and perhaps should be sanitized. You just cut those pieces out
Response.
because they don't help for anything. They aren't relevant. The state
Judge,
doesn't.
there is a
need
way
them.
to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, the make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case. And so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity, but to add all the other components that you will see in the video do much more than just prove that he's Bryan Kohberger with a phone number in a Hyundai Elantra. Thank you.
All right, with regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e.
This is the relationship between the rules, guys.
Unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or of a type that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the DeSales paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the examples raised as a quote unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so I don't think we can say that the shot clock has run out on that at this point, but certainly as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. And so as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related, well, let me go through the 404B analysis. It is technically a prior bad act, which is the sort of colloquial terms used by the courts in describing 404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case, there clearly is a other purpose besides that, which is identity, which is ownership of the automobile that is alleged to be a suspect automobile and control over that automobile. And so I think there is a relevant purpose for it. And the next question is that relevance substantially outweighed by unfair prejudice? The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the evidence unfairly prejudicial. It just makes it more effective. And that is not the type of unfair prejudice that the rule contemplates. And I don't, frankly, track the defense's argument with respect to that. And so I think as a general matter, the traffic stop is relevant. It's not I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion. And certainly the jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control. There are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404 or notwithstanding 404B and 403. I do want the video potentially, I'll look at it and it may change my mind, but just from the description, I am concerned about some of the interactions with the officer that was mentioned that, that Mr. Kohberger questioned why the police needed his phone number. That the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant. And it does potentially create some unfair, some danger of unfair or unnecessary prejudice. So I think it needs to be redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that he, his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
We'll talk about this one at the break. This one is a little complicated and messy. I don't entirely agree with the judge on his interpretation of when 404 applies, but I do agree
All right,
that
let's
as far
talk
as
about who
this
is going
video,
to be in the courtroom
it's a 403
amongst
issue.
the victims and the defendant's family in general, in terms of a reserved seat. I'm not as concerned about the reserved seat part. We can address that at the pretrial conference down the road. I'm more concerned about the ability to be in the courtroom, notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Yeah, Ms. Jennings, let's justify that. Explain your asshole move
Your Honor,
here.
the state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1953-06-1B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being immediate family. It's my understanding that defense has stipulated to that list, and we would just ask the court to issue an order to that effect. This takes care of the issue that the state raised. I don't know if you have any further questions.
Well, there is the issue of
wanna
the defendant's
justify
family, but that's, I think, the defendant's
his family?
motion, so I'll let them address that first.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further that they may call family members. I want to note that they have not subpoenaed them. The state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping him, in helping them. They also know from watching all of Mr. Kohberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years. And by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date. Sequestration of witnesses under IRE 615 is discretionary. The language in the statute is that they may be excluded by the court. This means that there's court discretion in that decision, and there's a reason for that. The reason is that the court must balance Mr. Kohberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in 1948, the court stated, without exception, all courts have held that an accused is at very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged. The Tennessee Supreme Court recognized the same precedent in State v. Sams in 1990. In that case, the prosecutor subpoenaed all of the defendant's family to keep them out of the courtroom. In reversing the case over this issue, the court held the assistant district attorney's blatant abuse of the trial court subpoena power for the exclusive purpose of removing the relatives from the courtroom constituted egregious prosecutorial misconduct. The state action violated the constitutional right to public trial, as well as the constitutional right of the relatives to attend the trial. In a more recent case in Iowa in 2022, State versus Bremer, a conviction was overturned when the accused family was excluded from trial due to COVID-19. The court pointed out even the defendant's mother was excluded. The purpose of the witness sequestration is to prevent a witness from tailoring his or her testimony. In this case, all of Mr. Kohberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped.
They are.
There's no tailoring of testimony to be done. Add to that the evidence that the defense has disclosed to the state in discovery and expert opinions, which the court has had the ability to review. Those provide an even more narrowing, who it would be even rational probably for the state to actually call. At best, there's one potential family member that they may see a reason to call. The state knows that Bryan's family has no desire to be used as witnesses against him. From the minute this trial begins, the jury is going to study Mr. Kohberger, and they are going to figure out who is in this courtroom sitting behind him to support him. Weeks into the trial, the jury is going to know who's in the gallery. That's why there is a constitutional right to a public trial, so that what happens here is not done in a star chamber. And for our client, the jury will know that he has people there to support him. Mr. Kohberger needs his family to support him. As the court knows, we have several motions that we will be addressing regarding his autism spectrum disorder. He needs to have his family here to support him, and they need to be in the courtroom supporting him. These needs are constitutionally protected rights. We ask that you enter an order making it clear that the state does not get to put his family members merely on a witness list and keep them out of the courtroom. If they want somebody in court, there needs to be an out-of-state subpoena issued. They need to provide witness travel funds to be here and make their intentions very clear. And then this court, we ask, exercise its discretion and allow whoever of those family members the state may actually subpoena to be in the courtroom, because there's no need to worry about how they may tailor their evidence, because it's their testimony, because it's all video recorded. And the court could also order the state to make it those witnesses, if they do intend to call them, immediately call as witnesses early on in the case, so that if there is for any reason going to be exclusion, that exclusion would be there for a very short period of time. But we do ask the court to consider how important in opening statements, when that jury walks in and they're making that immediate first impression assessment, how important it will be for Mr. Kohberger to have his family sitting behind him. We've also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-firing squad. There's no place for that in this courthouse at all during these proceedings. There's no place for that in this courtroom, and we'd ask that the court issue an order that spelling out very clearly that that will not be allowed. Thank you.
Your Honor, the state trusts that this court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Kohberger's family from the courtroom. The state's not aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your discretion to allow certain immediate family members in the courtroom to support Mr.
reason you
Kohberger.
can't simply take up whatever family members you may need to testify in your case in chief right at the beginning. Other than, obviously I know you have a narrative on how you want to lay these things out, but what I will tell you is both sides ought to get used to the idea that with a 3-month trial, the trial schedule will not be held hostage to your narrative. In other words, we'll be taking things out of order, stopping witnesses to put another one on to make sure we get them through them and picking them up again. And so is there a reason you couldn't call whatever family members you need right away?
Well, I will say, we have no intention of calling all the family members. We have the intention of calling a few of the family members who serve certain purposes. I can't think of a reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo. You are going to put all the pieces that go into the pot. And at the end of the day, the jury's going to decide whether it's a good soup or not from the state's perspective. And so I think we get too obsessively stuck on the idea of exactly the order these things need to come in, right? And so I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have the defendants support family here in the courtroom.
Why don't we think about them as well for like half a second
and
here?
I guess my preference would be for that, even though it would be out of context and interfere with the state's
Because they've done nothing wrong and their son might be killed in this
preference of
courtroom.
how to present its case. And I think I do take issue with the defendant being able to direct how the state presents its case to a jury. However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Judge, I knew that the state's position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public. And there are cases, as I referenced.
Constitutional right is not absolute and gives bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says that court can't use the exclusionary rule where in good faith a person who's otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I
Thank
hope
you.
that you take to serious heart for his family, who is absolutely devastated and
Thank you,
dealing with
Eliza.
things like headlines that they're going to be called to testify against their son with these types of communications that are happening. And so we're asking that you use that discretion and that you find that humanity. Thank you.
Thank you.
Yeah, they've done nothing wrong.
I'm going to take this matter under advisement. The defense raised some cases. I want to read those. Though I don't think they were precedent on this court setting. I have reviewed the U.S. Supreme Court opinions cited, but in terms of other states, I'll look at those. I do think, and I'm asking the state to think about to use counsel's word, the humanity. I think that,
Yeah, think about
I
it.
can only imagine the family of Mr. Kohberger is devastated
Look at that
by
glare on Ms.
these
Jennings.
things. That's nothing that they did.
Don't give a shit. These are prosecutors.
And I think their ability to be here to see the trial is important.
Yeah, you're trying to kill their
to the extent
son. They
possible,
might like to see
while
why.
also preserving the state's right to a fair trial should be something that we seek to do. And I think calling them out of order is one way. Now, I know that there is, I don't know why the state would want to call them. I haven't, reviewed their interviews. I don't know anything. I do know there's been an issue raised by the defense relative to purchases on a alleged family account that could be an issue. And so I do see some issues where family members may be important. And so I think there may be some need for exclusion, but I think the best way to handle that is to get them on and off as quickly as possible at the beginning to deal with that. I'm reserving ruling on that. I want to look at it, and I will issue a written order on that in due course.
I mean, we just heard that they have not been interviewed. They have not given information other than at the time of the raid of their house. I don't think it would be inappropriate to require the state to tell
Right,
you
let's talk
what do you
about,
need these people to testify for. It could be in
The
camera.
defendant's motion regarding
the value
conditions as an aggravator, and this is the concern about using
Is a consideration.
defendant's alleged autism disorder diagnosis as a aggravator during the penalty phase of the trial, if there is one.
Thank you, Judge. You summarized exactly where I was going to start. This motion is brought in case there is a penalty phase. If there is a penalty phase, Mr. Kohberger has a right to present mitigation evidence. That is State versus Payne, and Roper versus Simmons tells us that mitigation evidence cannot be used as aggravating evidence. This is something that we talked about several months ago when we had our motion to strike the death penalty and ask for trifurcation with the death penalty, and that was denied. But we're bringing it back up because it's really important to make a distinction between things that exist in this case, Mr. Kohberger's autism, something that he didn't ask for. It's a condition that he has, and it'll need to be addressed, but also to prevent the state from using his characteristics of autism as aggravating evidence against him. The state has, and the court has, our expert analysis from Dr. Orr that talks about how autism manifests in Bryan, the things that people might see. And these are things that we've read a little bit about in the media over the course of the case. Bryan's physical body is more stoic, how he sits in one place. And he will look for a long time. Sometimes he'll hold his hands in a rigid position. And that means nothing. That's just how Bryan is. We seek to prevent the state from using those kind of characteristics against Bryan. We seek that in the way of testimony they might bring. Sometimes Bryan will talk longer than maybe other people want to listen, and that doesn't mean anything.
Well, I
That-
assume he's not going to be talking in court unless he's testifying, so.
That's exactly right, Your Honor, but that doesn't stop the state from bringing a witness and using that as aggravating evidence against Mr. Kohberger, and that's what we don't want.
He went on and
We
on and
want
on and on.
To be able to
I was trying
present,
to get away.
if we
He
get
wouldn't
to a
listen.
mitigation
He was
phase,
so pushy.
his autism and how that works and how he's learned to live with the conditions that he has and to prevent the state.
Reading the defense's, pardon me, the state's response, it doesn't sound like they disagree with you that it shouldn't be used as an aggravator. And so I think that in terms of what counsel's arguments are, we can control that. I think apart from a jury instruction, I'm not sure what we do with, how we deal with that with the jury in terms of the penalty phase, right? If you present evidence of the disorder.
Your Honor, the court can do what we've requested and prevent the state from using Mr. Kohberger's conditions of his autism as aggravating evidence. I think a jury instruction helps the jury to understand how to use mitigating evidence. Our purpose here is to ask the court to take the step of an order. I don't think the state opposes it.
What would that order say?
That order would say that the state would be prohibited from using as aggravating evidence Mr. Kohberger's autism characteristics.
How would they use it as aggravating apart from arguing to the jury that, well, because he has this condition, it means that he is, I'm just making this up, obviously, is inclined to not follow the norms of society and presents a greater danger or something like that.
Your Honor, the order would prevent the state from, on the front end in presenting their aggravation case, from using the conditions, the way autism works for Bryan against him to say that he does things that are consistent with autism and that that's an aggravating circumstance.
I'm just having a hard time envisioning what that would be, how it would be presented in a way that is.
He ignores
making it
people's
an aggravator.
boundaries. He makes
Well, I would
them
hope that it wouldn't be
uncomfortable.
presented that way. But Your Honor, when
doesn't
I
pay
look
attention to
through
their
the
feelings.
mounds of discovery, there are probably 100 hours of interviews of people that Mr. Kohberger went to school with at WSU. And of course, those interviews come just hours and days after the headlines hit that Mr. Kohberger's been arrested in this case. And people that he went to school with, that he interacted with, had unkind things to say about him. And a lot of their unkind things, when you understand them in the context of autism, the way he may stand in a room near a doorway, the way he may look too long at a person, their interviews are different when you know he has autism and you know the characteristics he displays. But those awful comments, those mean comments about him, if the state uses those as aggravators, that's using his autism characteristics.
How do I know, and I don't know that this is a real thing, right, in terms of actual evidence. Let's say there's evidence that he harassed other young females. Okay, and I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this as an example. And let's further assume that that in and of itself is somehow relevant to in a mitigation aggravation penalty phase. Your position is that's due to his spectrum disorder, whereas the state's view may, no, that's not. That's his view of women and goes to motive, etc. and goes to his
Dangerousness.
aggravation of the crime in some way, not because of Asperger's, but because of his views, his dislike, and how he responds.
The
That's
creepy
exactly the
insult
problem,
theory.
Your Honor. If the state, and
Do you want me to,
I wanna
you want
be
me to weigh in and
clear.
say what the factual findings are, that it's this and not that? And I'm not sure I can do that short from a jury instruction that, you cannot use mental health conditions as an aggravating factor.
that's an appropriate jury instruction. And if we get to that phase, my guess is that we'll have one of those jury instructions. But if it's an appropriate jury instruction, how is the jury to understand and properly respond to that instruction if the state has been allowed to run over the top of that during the presentation of their aggravation case? It's that I want to limit. Once we present
There
mitigation,
may be a dispute about the reasons for his conduct, a factual dispute. And that then ultimately is for a jury to determine, not for me.
Your Honor, I believe the court is envisioning a problem that does not
I
exist.
hope so.
I think that the court will not find that
How the
that
tables
comes up.
turn.
I think the court can issue an order to the state that would be not to use his conditions of his autism as an aggravator, his diagnosis of autism as an aggravator. That's going to be very similar to the court's jury instruction, and that keeps the trial process clean, and it allows the jury to draw the distinctions and properly use mitigation as it's supposed to do. This is a protective measure to be sure that case law is complied with and that Mr. Kohberger's constitutional rights are protected.
Thank you.
Morning, Your Honor. So the court is correct that I don't think there's a whole lot of room between the state and the defense in terms of what the law says here. But there are maybe some practical problems in what the defense is asking for from this order. And the court has already nailed this, if the court is to issue an order that says the state can't rely on his autism as an aggravating factor, then anything we try and present, they're going to argue, well, that's a symptom of his autism, and therefore the court's order says you can't use that. I don't think that's an appropriate approach. What I can tell the court is the state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on students from the university to talk about their personal views of this individual. To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism. So from the state's perspective, this falls largely into one of the categories the court mentioned earlier in a different motion, that it's just really not necessary here. We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to if the defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we've put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination. And so the state does not believe that this order is necessary or appropriate, but also has no plans of using this as aggravation.
I believe it
Thank you,
is Joshua Hurwitz, who just put in his notice of appearance.
We understand that the state can argue the weight of the mitigation evidence. That's not why we brought this motion. As far as what the conditions of autism are and the way it works in Bryan, the state has received through our expert disclosures reports that describe that. So there's some guidelines for the state there to understand what we are talking about with Bryan's autism. The state will present its aggravation evidence first. The protective order that we're seeking from the court, the order to say you can't use his autism and the conditions thereof in your aggravation case, is easy, it's protective. And if we get to a penalty phase, it is imperative that we protect the rest of the trial. Certainly, if the state thinks it needs to present something in aggravation and there's a question, they could ask the court to revisit the order. This is just a very good, clean way to protect Mr. Kohberger's constitutional rights, and we ask that you enter an order.
I forgot about Jeff Nye. Haven't seen that much of him.
I don't, again, from a legal perspective, I don't think there's a disagreement about the use of the autism spectrum disorder as an aggravating factor in the penalty phase. You know, the state certainly shouldn't make those arguments and are instructed not to do so. But how that comes up factually, the fact that your expert says that this is one of the symptoms of this, that the state can't put on some evidence that they may disagree about, I'm not in a position to make that sort of blind statement or blind ruling. I think we need to get closer to trial and see specifically what we're dealing with. And so I'm not inclined to issue such a broad order in terms of the actual evidence, the presentation of evidence. I think I can certainly say don't make that argument that the fact of the diagnosis is somehow an aggravating factor. And we can deal with the symptomology that the defense contends is part of the diagnosis that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor.
That seems reasonable.
Why don't we take the morning break? We'll take 10 minutes and be back at about 20 till.
Morning break. I'll leave the sound on so that when they come back, it will alert us all. Well, this has been quite interesting so far. I like the judge's take on being argumentative in your use of language. He's not going to allow the parties to implicitly make their case that way. They need to keep it to the facts, just the facts. And so I really want to see if he keeps that same energy when it comes to that term touch DNA. Touch DNA, that very suggestive term that implies this random DNA that isn't associated with a body fluid or any other particular source that would tell us how it got deposited here. It's there because somebody touched it. And that is simply not the case. There have been many studies where you can sit in a room and have conversations with people and never touch them, and your DNA ends up on them. You can cough from across the room, and your DNA will end up on people. The problem is with how sensitive the detection technology has gotten, it has just revealed that unfortunately humans are a little bit more like Pigpen from the Peanuts than we maybe would like to think. We are just surrounded by a miasma of our constantly shedding skin and sweat particles. Biological beings are gross, guys. It's just kind of how it is. It's just sort of how we are. And so when you call it touch DNA, you're implying it came this way, and not because somebody sat in a room with a knife sheath and had a conversation and they happened to be a shedder. So they tend to shed a lot of DNA that ends up in the environment. You know, you don't think about that possibility if you're already building in that term touch DNA. So I really hope he keeps that same energy. I'm kind of guessing he won't. Just because of the fact that he broke it out. He didn't consider that motion in this grouping of ones that are dealing with the quote unquote argumentative evidence, but that it very clearly seems to me to apply. It's the same basic line of reasoning. Now, there's more to it than that, of course, because they're also getting into Riley Nowlin's qualifications to be able to give opinions about DNA transfer, the basis, the validity of the opinion, the reliability of the opinion that she wants to offer, that even though the science pretty clearly says we're not at a point where we can say how a particular piece of DNA, trace DNA, came to be deposited on an item, she wants to say it anyway. So maybe that's why we've broken it out. But wonder if we're going to see that same energy when it comes to touch DNA. Very interesting on the issue of psychopathy, that there there's no evidence. Of course, we already know there's no evidence of that type of diagnosis. The state acknowledged in their pleadings they haven't evaluated him. The fact that he is submitting an autism diagnosis as mitigating evidence, that opens the door for the state to have the opportunity to evaluate that. So they will be able to do their own evaluation if they want to, and they follow the process to. And I would fully expect that they would do that. I mean, maybe not. It's possible they could just take the information they've already been provided, show it to their own expert. Their own expert concurs. Then there's no need to do a full formal separate evaluation. But they might. We don't know. But yeah, those are pretty bad labels to affix to somebody. Psychopathy is no longer a formal diagnosis. It used to be, but it has not been for several versions of the DSM now. What has conventionally been called psychopathy is now characterized as antisocial personality disorder. So that would be the formal diagnosis that you can look at the clinical consensus. That would be the appropriate way to diagnose somebody as a psychopath. At the same time, there is still this idea of psychopathy that floats around in psychology and in various settings, and it comes up a lot when you're dealing with risk assessments, things like prison settings. People will typically, when they go through their initial classification, when they're being considered for parole, things like that, it's common for there to be a risk assessment of the person. Because they want to look at, what's the likelihood that this person's going to reoffend if we let him out? Is this a more dangerous person than average? And so the classic Hare's psychopathy scale is one of the tools that's sometimes used for that. But I'll tell you, this is a rabbit hole I've gone down a couple times as far as this distinction between psychopathy and sociopathy, and what's the difference between them. There does not seem to be a formal consensus on any of this. So I think it's appropriate for the court to not allow that type of language. It doesn't sound like the state wants to use it anyway. So I'm not really sure why this was brought up. But if there's some reason why that would be pertinent, okay. But you got to get to that bridge first. I do have to give Judge Hippler some credit, because I tend to agree. I hate motions in limine that are basically just order the party to follow the rules. It's really annoying. It's really annoying. They are already under the obligation to follow the rules. It doesn't change anything. I think his point is very generous, that the purpose here is to draw everybody's attention to things that you anticipate might be an issue at trial, and to let everybody know you're going to be alert to them. But it doesn't mean that those types of things warrant an order. You don't need an order. There's already a rule. So I appreciate that he kind of, shares my thinking about that. It's not that they're, these motions are necessarily a waste of time. It's just that they're not really appropriate for an order. So it's not something that you need to spend a lot of time on or trying to substantiate. The point is, you've raised it. Everybody knows that you're thinking about it now. Everyone's on notice, and let's move on. The 404B argument, that really was kind of a mess. It really was kind of a mess. Nowhere in the defense's briefing, as far as I remember, and obviously not in their argument here in court today, did they give the court the language of the rule. And the language of the rule is really critically important here, to the point that Ms. Massoth was trying to make. I feel like it could have clarified things so much had she just done that. Let me go ahead and read it to you. Evidence, Idaho Rules of Evidence 404, character evidence, crimes, or other acts. Subsection A just tells us you can't use any of this stuff to prove character. The reason why I think this is really important is because Judge Hippler has an idea in his mind about what makes a particular piece of evidence subject to ER 404B and other evidence not subject to it. But it's really not clear from anything he said where he draws that line. He's like, well, a traffic stop is obviously a bad act. Okay, but what is the basis for distinguishing between that and allegedly writing a paper about how to cover up a crime scene? The way I look at 404B is that what triggers it is the potential for it to invite this type of bad character or propensity or something like that type of evidence. That if a person acted consistently with this act that is being proffered, on the occasion that's at issue, it makes it, more likely they're the kind of like bad person who would do this, or it looks like the kind of thing this kind of person would do. That's my view on what triggers 404B. But let's again look at the language itself. Crimes, wrongs, or other acts, subsection 1, prohibited uses, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in conformance with the character. And exception 2, rule 2, permitted uses, notice in a criminal case, the evidence may be admissible for another purpose, such as motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. And in a criminal case, the prosecutor must file and serve reasonable notice of the general nature of any such evidence the prosecutor intends to offer at trial, and B, do so reasonably in advance of trial or during the trial if the court, for good cause shown, excuses lack of pretrial notice. So I think the language here is so important because it does tend to undercut Judge Hippler's analysis of the rule as applying only to like other crimes, only to other bad acts. Bad is in the eye of the beholder, and bad is very contextual. What's going to be a bad type of character inference in one case could potentially, be very, very damaging or helpful in another one. And so I would give an example. Let's say you have a case where a criminal grooms their victim, or kind of gets close to their victim by giving them lots of flowers, and then you have a lot of evidence that you want to put into trial about this defendant, that they have bought a lot of flowers on different occasions. Is buying flowers a bad act? No, it isn't. But the risk is you might infer something about this defendant's conduct and its relationship to the crime if this defendant like routinely buys his girlfriend a lot of flowers. Maybe you bring in somebody to testify. Yeah, we dated and he was bringing me flowers all the time, and seemed maybe a little over the top. That's kind of the issue, and that's why it's a case by case determination. So that's how I see it and how it got a little bit messy. Now, again, I'm going to give Judge Hippler some credit here for, I think, really cutting to the point, the real issue here. What Ms. Massoff is trying to say, first off, is that there is other evidence that would create this type of character or propensity inference. And that is what she wants the state to not be able to present, because they haven't given notice of it. Not because it isn't otherwise admissible, not because it doesn't satisfy Rule 403, which is the balancing test of is it more probative than prejudicial, but because the rule says if you want to use this potentially character type of stuff, you have to give the notice of it. So it is technical and it can be excused by the court anyway. It's not the best argument ever for excluding something. But what I think she's highlighting is that there's a risk here that we're not all on the same page about what is subject to ER 404B and what we aren't. And I just don't feel that this argument that we had today did a real good job of sorting out that disagreement. So that is a bit unfortunate. But with respect to this actual video, I want to give the judge a lot of credit for, I think, cutting through to the point, seeing for himself, okay, this is what its issue. It's not necessarily the fact of the stop and the fact that he was in this car. And I'm kind of with him where I really don't know where the defense was going with that. They get to prove that, this is Bryan Kohberger and that Bryan Kohberger was associated with this particular vehicle. Bryan Kohberger was associated with this particular phone number. That's all perfectly valid. That's just evidence. But it's the other stuff in it that's extraneous, that doesn't tend to prove that, doesn't tend to help that, and it just tends to make him look bad. He's a guy who doesn't think he has to wear a seatbelt. He can break the rules. He's somebody that wants to, pick the police's brain about lying to them. Maybe he's thinking about lying to them, all of that type of thing. That is not assisting the state's proposed use here. So I want to give him a lot of credit for seeing right away. That's what the issue is. And maybe he'll change his mind after he reviews the video and sees exactly how this conversation went. But in general, yeah, that's the appropriate remedy, is to sanitize it. You can present it through a different witness if it's going to be too, messy to do that. If it just takes too much out of the video and it sort of makes it confusing, or you think it isn't going to look good to the jury. They're going to wonder why these big chunks are gone, or whatever. You don't have to do that. You could just, like the defense suggested, present the testimony from the police officer who did the stop. But you can. I think this is the alternative. You can just redact that stuff that is not helpful and that does run the risk that the jury is just going to look at it as tending to prove, oh, this is a bad guy or a guy I don't like or a guy who has these particular tendencies that he may have also acted on when it comes to making a decision to commit murder. I think it's a little bit trite to characterize it as, well, just because a guy commits a traffic stop, therefore, he has a propensity to commit murder. I think that's really trivializing what the issue here is. The concern is the defense thinks, or the jury thinks he's a bad guy. The jury thinks he has disregard for rules and authority. Therefore, what does he look like? Maybe some kind of psychopath, And who do we think probably, committed murders like this? Probably some kind of psychopath. I mean, that doesn't seem like a particularly big leap to reach, given the nature of these crimes. So that's the issue. And at least with respect to this video, I'm glad that got sorted out. But I think, unfortunately, the kind of disorganized presentation and the inability to really drill down on where exactly is the judge interpreting the application of Rule 404 differently than I am, so that I can address that to him and make my record of that. That's how I would have argued it, is that it's not because there are things that are objectively bad acts or not. It's all contextual, and it depends on what is the inference, what is the risk of that type of character inference being drawn from this type of evidence, given the circumstances of the case. That's what tells you whether 404B needs to be evaluated.
All right. Let's talk about what I hope we have come to an agreement is not an issue, which is the IGG stuff.
If I may start, and they're battling.
Yeah, I think there are three motions. One is the improper expert testimony of Middleman, who's related to the IGG. The defense, and that's the defense motion regarding IGG evidence generally, and then the state's motion regarding IGG.
Yes, good morning. You're right, Your Honor, that we have essentially, I think, an agreement with the state as to their position, and our position being equivalent at this point for different reasons. And I believe that the state is willing to proceed without Dr. Middleman, therefore making that motion moot, and that they will proceed with using the generic term or the generic evidence of a tip leading to the identification of Mr. Kohberger. The only issue that we have is how that tip will be presented to the jury. The one thing that the defense is concerned about is exactly the testimony and the witness who will be testifying to the tip. And we want to make sure that nothing that is said by that witness implicates another source. And by source, I mean someone like a witness who called with a name or some other way of identifying Mr. Kohberger by name as the possible suspect. The state, in their response to us, said, well, we have lots of other evidence, and they have lots of other evidence they intend to produce. But the only thing that identified Mr. Kohberger, that set them on a train or a trail to charging him, was the genetic genealogy. So we just asked.
Well, I don't know if that's a fair statement. I think the thing that led to
I think
them
it is, and they admitted it.
investigating him was the investigative genealogy. I don't think that's what led to, the only thing that led to charging him.
I apologize. You're right. It was what they led them to investigate him and ultimately charge him. But I think that the court could issue an order or at least require the state to make a proffer exactly how they're going to do this. The reason I'm here is because I've done a lot of cases with DNA evidence. And the last thing I want is a repeat from a case I tried many years ago, which was a cold hit, where the state simply introduced a quote tip through testimony of a police officer. And the first question the jury asked was, what was that tip? And that is not, we do not want the jury to speculate. It's not our job to tell them how to do that, but I think the court has to be vigilant.
Well, I certainly could anticipate that being an issue in terms of the jury's curiosity, right? Depending upon how compelling or not compelling the other evidence may be viewed by them. And so it may be that you want to come up with some instruction to the jury that basically says, we're not going to tell you what that tip is, and you don't need to consider it, or something like that.
They're going to anyway.
Is that an invitation?
It's an invitation for you, two sides, to work together to try to solve this conundrum in a way that you both can live with.
Okay, well, I accept that invitation, and I assume the state also will be willing to do that. I don't know if anybody has any comments.
I mean, we see this sometimes, not in the context of DNA, but we will have, as an example, a probation officer who does a home visit and searches somebody's property without a warrant or other right, because they have that ability on probation, because the defendant will have waived their Fifth Amendment rights as a condition of probation. And sometimes we want, we'll have to have the probation officer testify in a way that doesn't necessarily tip the jury off that the defendant was on probation, which would be a 404B issue. And I have seen, without some explanation to the jury, when we use those sort of generics or whatever regarded the search, that can cause curiosity with the jury and they can get sidetracked. And so we will frequently use an instruction to the effect of, law enforcement's search of the backpack has been found to be lawful, and you should not consider or concern yourself with that. Okay. Right. And so it's basically telling the jury, don't speculate about this point or how we got to this point. It's not important, and you're not to do
How
it.
can
And I
they
think
not?
That generally causes them
How can
to
they not? If they're just
back
like, they
off
got a
that.
tip
And
that
so
it was
that's what I'm
Bryan?
suggesting that you try to work through.
Okay, will do. Thank you. That's all I have to say.
I didn't mean to cut you off. If you have
No, that's all I have to say. That was the only concern that was left for us.
Sure. All right. Thank you.
Judge, I think that fairly states where we are. I was curious what the defense meant in their reply, where they said that the testimony about the tip should not falsely suggest other evidence, and I still have no idea what that means. But we are happy to engage in discussion about a jury instruction like the court outlined.
It needs to not imply
I
there's
will
some
comment
evidence that
that
doesn't exist.
it seems like it took a long time to come full circle, because we're right back where the state started a long time ago, with a lot of court effort invested in dealing with hearings in the interim. I appreciate the court's diligence with that. And I think also, for the record, there were some pretty serious allegations, ethical allegations, made by the defendant in its motion in limine number 11. Those were factually rebutted very clearly in the state's response. And I just want the record to reflect that the state maintains we did nothing ethically wrong with this, but we're satisfied with where we are right now.
I forget which one is number 11.
Sometimes we litigate issues for purposes other than evidence at trial, right? We do it in terms of constitutionality of searches and other things, and that's all okay. I certainly have not made any finding that the state has done anything inappropriate, and so nor have I seen anything to suggest to me that that is the case as of this moment
that
right
was
now,
the,
at least.
Misstating what they had.
to me, this is a practical problem, regardless of the reasons you are in agreement. The important part is that you are in agreement. I suspect what the defense is suggesting, I think, trying to read the tea leaves, is they don't want an implication that there was some other evidence related to a tip or specific to Mr. Kohberger that
Yeah.
put him on the radar, right?
You know what the risk
And
is?
so I think that's just
An
where you come. I don't
accomplice.
think
The jury's going to think,
with those purposes, we're
other
suggesting that the
person.
state can't present its evidence about the car, suspected
the
car.
other person
about
told
the,
him it was Bryan.
uh,
That's the risk.
the defendant's whereabouts on the night, et cetera. Those are things that were discovered and put together after the fact, right? I think it is important to develop a narrative that doesn't suggest, for example, there's some fact witness who may have heard a confession from the defendant or have witnessed the defendant that led to the tip, right?
This judge is
And so
sharp.
I think it's
He
important
gets
how
it.
that's presented, and hopefully you can work that out. And if you can't, we'll revisit how to address it.
Yes, Your Honor, I appreciate that. And the state's intent, we've already spoken with the investigators to develop this, is to have probably Detective Payne, who is one of the leaders and lead investigators,
Oh,
to
no,
simply
nothing
testify that they've received a number of tips, that around December 19th, they received a tip. Following that tip, they took these steps. That's what we're contemplating at this point. Thank you, sir.
And so we have a pretrial in next month. And so hopefully you can come to an agreement on how this is going to be handled specifically by that time.
Yes, sir. Thank you.
Anything to respond to, Ms. Barlow?
No, nothing on that.
All right, thank you.
the 11 dealt with the state saying they didn't have
All
certain
right, that leaves
records,
in category A by my
and it turned out they were wrong.
score sheet, the alternative perpetrator evidence, which is the state's motion limiting.
It's the state's motion. Do you want to sit here? Oh, I didn't see that one. Why do you stick that one in there?
I just forgot it.
Thank you, Your Honor. And this is actually a very convenient transition. We're looking at the history of this case and investigation. Of course, we, the investigators, and the state went probably some 6 weeks following the homicides, and during that time received thousands of tips and tried to substantiate or discount whichever we could. Where we ended up is the investigators were unable to substantiate any tips until they received the tip regarding Mr. Kohberger itself. The state's concern in bringing this particular motion is that the defendant is going to try to offer alternative perpetrator evidence based on what we would call mere inferences that another person could have committed the crime. And the case law in Idaho says they clearly can't do
So
that.
for purposes of your motion, are you talking about the defense's allegations of specific individuals? I mean, obviously, the defense claims the defendant didn't do this,
Thank you,
which
Judge.
would suggest that there was an alternative perpetrator.
Yes. And the state's concern is about the defense focusing on specific individuals without making a threshold showing of connecting that individual to the homicides itself. And our concerns actually are reinforced by the defendant's response to our motion. When we're looking at pages 2 and 3, at the bottom of the page, the defendant says, "This case is full of alternative perpetrators. There are many alternative perpetrators." That suggests to us that the defendant is going to shotgun any variety of people's names, and we think that they can't do that without making the threshold connection first. Based on the case law, based on rules of evidence 401, 402, and 403, State versus Meister is the most applicable case. We're seeking an order prohibiting the defendant from offering specific alternative perpetrator evidence without first having an offer of proof to the court that specifically connects this third party, this alternative perpetrator, to the crimes themselves. And then we would also ask that the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof, so we don't have to encounter this in the midst of trial, that we can prepare adequately for it. So that's the nature of the state's motion, Your Honor. Thank you.
This is kind of another follow the rules of evidence.
Your Honor, we do, as the state indicated, plan on providing offers of proof regarding alternate perpetrators. There's nothing about our approach that would be a shotgun approach, throw a bunch of spaghetti at the wall and see what falls. We understand that it requires the conditions of Meister and that we need to provide that information to you. We are still in the process of doing investigation, as you know, with the amount of evidence in this case, and there's been a lot of briefing. There's going to be a motion argued about that. We are working as quickly as we can to put pieces together that make sense under the terms of Meister to present to you for that consideration with an offer of proof. So we understand the obligations. We won't be taking a shotgun approach. I would hope that the court would see that we are calculated and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
I don't believe the state has anything further on that point.
All right. I think the parties are both correct in that State v. Meister is controlling here, where the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person, rather than just throwing names out or arguments or theories out without evidence to support that. I don't want to do that at trial. I think that's not enough time for the state then to investigate that. And I don't think it's enough time for the court to respond to that. And I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers and go from there.
I look forward to that.
Things may, I'm not discounting the fact that things may unexpectedly happen after that, but in terms of what we are or should be aware of at this point, I think we need to flesh that out before we go down that road. And so I will probably reach out with your calendars and set a date sometime around that pretrial, maybe even during that pretrial, since you're here to take care of that.
Thank you, Your Honor.
All right.
That's next month.
And I want to be clear, I don't view Meister as controlling. For example, I know this defense has suggested that they believe the evidence suggests that there was more than one perpetrator. From presenting that sort of a generic, unknown, unsub, to use the part of the
Good.
Of the craft involved. This relates more to allegations of somebody more specific, identifiable. All right. Let's talk about DNA, which is the
Yes.
inconclusive data, the statistical analysis, and the reference to touch and contact DNA. Let's take up the first two, and then we'll take up the third. I think the first two relate to the kind of the same thing to a degree in terms of the science of statistics and probabilities and all that. there are really three issues, as I understand it. One relates to how to convey the statistics that DNA analysts use to more real world comparisons to, for example, planetary population. The second deals with DNA that was found under one of the victim's fingernails and by the DNA analysts as to whether or not Mr. Kohberger could or could not be excluded. And then the third really deals with more sort of this labeling problem that we've already addressed in some fashion in
Same
different
energy.
contexts of what labels can and must we use as it relates to the quote unquote touch DNA that was found on the knife sheath.
Yeah, yes, thank you. That's a great summary. And I'd like to start with the first point that the court noted, which was motion in limine number 14, which was the relationship of the world population to the statistic generated from the sheath evidence with Q 1.1. And I think we are in agreement that the state is not going to address that kind of question in front of the jury because their own analysts during the grand jury essentially told them that you can't do that given the statistic that we have generated.
I understand the state's response is that they will present the testimony consistent with the way that the witness presented it at grand jury.
Correct. And it was my
Not in
understanding.
the way in which the question was asked that the witness sort of corrected the attorney about.
Correct. And the objection from the defense was simply, and I think the witness explained this very well, was that the statistical analysis that the state's experts have engaged in does not allow that kind of comparison. It's not the standard statistic that we're used to anymore. And so by asking that question, you're triggering, you're conferring or not conferring, you're
confusing the jury.
speculating, essentially, put in front of the jury. It's a question that presents a false premise to the witness. And so we just ask that the state refrain from that and simply ask the questions that elicit, the testimony as laid out in the grand jury proceedings.
Okay.
Excuse me. The inconclusive data, I don't know if the court has seen that late, I apologize, all of a sudden my voice is
All right,
just
we can get you some
disappearing.
water.
Oh, I feel her. I get that a lot.
I don't know if the court has seen the latest filing from the state.
I did see it.
Okay, so they filed a new expert disclosure on Monday from an expert who went through and analyzed the data at issue. So as
Response to the defense's having retained an expert who discussed whether or not you could exclude Mr. Kohberger from the DNA found under the fingernails.
yes, and what triggered that was the grand jury testimony where questions were asked of the analyst regarding the meaning of a conclusive versus an inconclusive data result. And the analyst testified as to 13.1, the fingernail swabs, that their data was inconclusive. And to the defense, and that means that you cannot draw any conclusions. So the defense retained cybergenetics, which uses a different statistical tool than the lab here, and generated a statistic which is strongly exclusionary of Mr. Kohberger from that particular sample. And while that doesn't preclude the evidence from the state lab, it adds additional information to the picture, the overall picture. And
It's just a question for the experts to testify about and the jury to make its conclusion.
well, I think that allowing the type of questions, and apparently now the new conclusion that was in the state's response to our motion would be inappropriate and prejudicial and should be excluded under and you have
Do
to.
you want me to believe your expert and not their expert?
No, I'm not asking you to believe anyone in particular. However, what I am saying is that the amount of time and energy it will take to explain what inconclusive means is essentially far greater than should be the job of the defense to do. Inconclusive means inconclusive.
His
No,
sound
I'm not
is out.
saying that. I think it can be presented, and it can be presented in a fair manner that is consistent with due process and the right of Mr. Kohberger to confront it. The new disclosure from the state is an expert who went through in great detail. We have a 27-page report from him where he not only reanalyzed the data visually, but he also used another statistical tool. And he stated in his conclusionary paragraphs, and it's a very long report, that first he looked at the data using the lab's protocols and doing some validation himself, essentially looking at their validation studies. And he found that just visual examination of the data excluded Mr. Kohberger. He went a step further and he said, I'm going to use this new third tool called LR Mix Studio to generate the same statistic or similar statistic that the lab did, the state lab did, as well as True Allele Cybergenetics did in their analysis. And he came up with a strongly exclusionary statistic. So we have now before the court, as he describes it in his disclosure, a statistic from the state lab, which means that it's 25 times less likely if the DNA originated. I always have a hard time with these numbers because you have to be extremely careful how you say this because it can flip the meaning. So let me just double check. His statistic, I'm sorry, I'll start with his. It's 5,000 to 100,000 times less probable that a coincidental match would be made to an unrelated person. In other words, what he's saying is that Mr. Kohberger is not included, and that's a strongly exclusionary statistic. And I'm not saying this very well, Your Honor, because these likelihood ratios are hard to explain. So that's a 5,000 to 100,000 times less probable that Mr. Kohberger is present. In other words, it's much more likely someone else is there if there's someone else there. Then the cybergenetics came up with a number that is in the range of 2.8 billion times less probable that he is there than some other unrelated individual. And this expert then relates that even the state lab's number is 25 times less likely
So you gotta
that Mr.
litigate
Kohberger is there than
how
some other
improbable
unrelated
it is
person. So
that
all
it's
of the
Bryan's
numbers
DNA.
point to exclusion. The numbers, the question is really the weight of it. And the way that the state intends to present it, and they presented it in their reply to our motion, was they should be allowed to say that this means that Mr. Kohberger cannot be excluded. And that is just a misrepresentation of their own data. None of the data that's presented to this court at this moment in this motion supports that statement or that conclusion. And it's unclear to me who is going to say that because it's not in any of the disclosures that have been produced so far. The first time we've seen it is in this reply brief. So I think that rather than having a battle of the experts, right, where you're going to have all three of these people testifying before the jury.
It's really probably not him, but how much?
And to allow that just one question is going to subsume an enormous amount of time in explaining why it's not in it. why it's inaccurate. And while it might be technically true, it's not an accurate statement for the jury to consider, and it's just going to confuse them. And it's highly prejudicial to Mr. Kohberger. So we would ask the court to, if it's going to allow this in, and we haven't asked to exclude the evidence, we simply asked the preclusion of this kind of questioning, that the state be precluded from inferring or asking a question to elicit some kind of inclusionary statement.
He's going to let the experts battle it out.
I hate these numbers.
Thank you, Your Honor. So let me just explain a little bit about the state's position. The state has no intention of suggesting to the jury that, oh, maybe this is Mr. Kohberger's DNA. We just don't know. That is not what the state is trying to accomplish. What happened is the Idaho State Police Lab tested this DNA and they came up with their likelihood ratio. And that number fell within a buffer zone. And under their policy, that buffer zone, generally speaking, with a likelihood ratio, anything less than 1 suggests exclusion, greater than 1 suggests inclusion. But they had done their own internal validation studies and had found that they were getting some false positives and negatives when you're close to that 1. And the range that they came up with was 0.01 up to 100. And so their policy is, if it falls within that range, 0.01 to 100, we report it as inconclusive, not just meaning you can't, uninformative. You cannot draw one way or the other, whether it's exclusion or inclusion. And so that's what we had from the Idaho State Police when we went to the grand jury. We thought that it was important. What we were trying to portray to the grand jury was that there was the only DNA that connected Mr. Kohberger to the crime scene was on the knife sheath. But the analyst wasn't willing to just make that general statement because there was this issue, this inconclusive.
Actually, it's not the state's position that that DNA is or likely could be Mr. Kohberger's under the fingernails, that it's unknown people from however the victim lived her life in the hours, days before this event, and whoever was the perpetrator may have been clothed in a way that fingernails didn't contact skin. I assume that's the state's position.
That is exactly correct, Your Honor. The state's theory here is that one would not expect the perpetrator's DNA to be under her fingernails, given the eyewitness account of what the perpetrator was wearing, the complete lack of any defensive wounds on this particular victim, the toxicology report. All of that suggests you wouldn't anticipate this to be the perpetrator. And so we have no...
So does that mean the state's not going to present this evidence in a way that would suggest or argue that it could be Mr. Kohberger's DNA?
So some trace
Absolutely
matters,
not, Your Honor.
some
No, and that
doesn't.
was part of that rather lengthy, I admit, report that was submitted on Monday was to demonstrate, yeah, when you know, the other issue to keep in mind is the Idaho State Lab uses a different program than the True Allele program that was used by the defense experts. So the Idaho State Lab pointed us to someone else they were aware of that used the True Allele program and said, why don't you speak with him? We spoke with him and he came back with the same result, exclusion. Nevertheless, given their policy, the ISP analyst is not willing to say he's excluded because their policy prohibits her. But the plan for the state, to the extent it addresses this, is for all of that information specific to her about the policy, and it fell within the policy. And that's why I'm saying that's what the state would present. And of course, she's open to cross-examination. Of course, the defense can put on theirs that can say, no, we can say he's excluded. The state has no plan or intention to in any way ask questions, imply, or certainly argue that this DNA belonged to the defendant. That, again, we will actually be arguing much different than that you would not anticipate the perpetrator's DNA to be under the fingernails. And so that's where that is coming from with the inconclusive data. On the issue of the statistical analysis, that we agree. I mean, we're not going to ask that question. The only kind of remaining issue we have is I think their motion specifically asked for an order excluding that question or other questions like it. I'm not a big fan of that language because it's just kind of vague and we're not entirely sure what that means, but we'll stay completely away from the population of the world or a country or a city or anything about population. That's all. Thank you.
Isn't it funny how sometimes trace DNA
I would
matters?
just like
and
to say,
sometimes
Your
it
Honor, that
doesn't?
I guess we're in agreement. And as in an abundance of caution, I might ask the court to issue an order just that if things change, that the state has to come to the court before even trying to present such evidence.
Thank you. It sounds like, and I'm not trying to tell either side how to present their evidence, that the state's not intending to present the fingernail evidence as somehow being inculpatory. I could see, based upon cross-examination, et cetera, the defense questioning the lab person in an attempt to maybe attack the credibility of the lab, which then may require the state to put on its rebuttal expert that it's identified as to that issue. But I think we're at this point safe based on what you've said, that the state does not have a good faith basis to suggest that the DNA, to make an argument that the DNA could be Mr. Kohberger's, that they not do that without first talking to me outside the presence of the jury based upon what the state of the facts on the ground may be at the time. As to how you question with respect to statistical analysis, I guess as guidance, it seems to me the answer that was given to a question that the analyst kind of rejected is probably the way the state ought to approach it, but I'm not going to tell them exactly how they have to ask the question. What I will say is I will make sure I'm aware of the way that it was asked in a way that was concerning. And certainly if a question is asked in a way that is concerning, the defense can object and I can respond accordingly. All right. All right. Next motion to limine is defense 12 regarding the make and model of the suspect vehicle. Oh, I'm sorry. Did I miss one? Oh, you're right. Within the group I identified before was
Yes.
the touch DNA. I'm
Touch
sorry. I
DNA.
apologize.
Still in DNA.
Yeah.
Your Honor, this is basically a two-part motion.
bring the
One
same
is to
energy,
exclude the use of
Judge.
the term touch or terms touch and contact, and the other is to specifically exclude an opinion of Rilene Nolan regarding the sheath DNA and her conclusions as to the how, what I call the how and the sort of when of when the DNA that was determined to be on that sheath, item 1.1. And I'll start with the touch and contact language. Admittedly, that is language that has been used for a number of years in the
Your own expert used it.
Yes, she did. And we would be fine with the court precluding her from using that term. I think what is happened in the world of DNA, having been doing these cases for unfortunately 30 years, is that there's been an evolution. And we laid that out pretty well, I think, in our papers, an evolution of DNA testing, where people started realizing the sensitivity of this methodology allows you to pick up DNA from objects that have no visible stains, like no blood, no saliva, no semen. And that led to the use of the term touch or contact, because the implication and the theory behind it was that people who touch things leave things behind, leave DNA behind. We've now moved into a world where we know that not only can people touch something and leave their DNA behind, but for instance, Mr. Nye was just standing up here. He was touching the podium. I've now placed my hands on the podium. His DNA is probably on my hands. And when I sit down and pick up my phone later, I could transfer his DNA to my phone.
In the short room.
Nobody's going to
Probably also include your DNA too. Right?
Of course, but not always. And The problem with the use of those terms is that it essentially allows a conclusion to be presented through a description. And there are many, many, many ways to describe touch or contact DNA. And Ms. Nolan illustrated that in the second disclosure that was produced. And I have copies if the court does not have them. If you would like to review those, I can have them marked. And she goes through her entire discussion of transfer, which is the question here, transfer. How does DNA transfer? And how did it transfer in this case? And she does not use the word touch in describing that process. It's not essential to the description of the process. It's not essential to the explanation of how DNA moves in the environment, because many of the things she's talking about with transfer happen with any biological fluid, not just skin cells. It happens with blood, saliva, et cetera. So it's essentially allowing the state to prove something, a very important fact in this case, simply by asserting that the term touch DNA is usable or acceptable in the forensic community. We presented at least 3 sources that say, and these are reputable people who are publishing in reputable journals, saying that this type of language is misleading, and it can lead to a misunderstanding of the evidence itself, because touch DNA does not mean now that someone touched something. It simply means that in some mechanism, DNA from
touched it.
a person has gotten to an object, whether that's through direct or indirect contact.
I assume your expert's going to tell the jury all that.
I'm sorry?
I assume your expert's going to tell the jury all that.
Yes, and Ms. Nolan will be telling the jury that as well if she testifies.
So what are we worried about?
What we're worried about is that it's confusing to the layperson to hear an expert use a term that is essentially a description of activity.
It's conclusory.
I'm not very good at grammar, but I believe that's an adverb. And it is not one that is useful for a jury, and it will be misleading because ultimately the experts will be discussing a much broader source of what we might call contact or touch DNA, which is anything that comes from a human being, including saliva or blood. Just because you don't see it, just because you can't see a blood stain doesn't mean it's not that stain or that area that is sampled doesn't have some other biological fluid. So it's very misleading. And it's just not necessary. And there's a paper that was presented as a human factors report that was published last year, where the consensus, although there were 2 dissenters, is that analysts should not be using this kind of language and not proffering, and this goes to the next question, not proffering opinions about this, but that the language itself is extremely misleading. There are other ways to talk about it. Ms. Nolan rejects the term trace. That was just one expert's opinion in one article that was cited to the court. But it's very clear she doesn't need to use that term in her description of how DNA moves in the environment. So we would ask the court to prohibit her or any other witness, frankly, from using those terms in describing any DNA sample that's been collected in this case. As far as Ms. Nolan's opinion, again, it goes hand in hand with this idea that touch DNA or the contact DNA is not what it used to be thought of. And there's a number of publications, scientific journals, where the scientists have reviewed vast quantities of scientific literature. I think I counted up over 300 articles in the 2, were reviewed by the 2 articles that were cited in the moving papers that say that there is really no way for a particular analyst in a particular lab to determine how and when DNA was placed on an object when you don't have any facts behind it. In other words, unless you see something or you know something, you have facts of the method of transfer, it's not possible. So first of all, Ms. Nolan is not qualified to offer such an opinion. It's very clear from the growing consensus in the community that transfer in and of itself, how things get places, is a separate expertise, which requires separate training. And a DNA analyst working in a laboratory does not have that kind of training. And in fact, it's not really provided in the United States. There is a paradigm in Europe that is being used, but has not been accepted or used here in the United States at this point, which is the concern from some of the experts who were on the human factors report. But Ms. Nolan is not at all qualified. If you review her CV, which was part of, I think, the first disclosure in December of last year, going through the list of courses that she's attended, none of them are specific to transfer. And in her affidavit that was supplied to the court, she discusses attending some presentations at a recent meeting where there was discussion of transfer, where some unnamed individuals disagree with this idea that it's not something that should be testified to. But I think there's that her presentation, and this is what the court has to consider, the facts presented by the state in support of their opinion, is not supported by anything other than this vague statement, well, some people don't agree with this position. We don't know who those people are. The state and Ms. Nolan have presented no particular scientific articles that support her opinion. And she has presented no specific training to take her from an expert around DNA testing, which no one is suggesting she is not, to an expert on the how and the when of transfer in this particular case. Then when you look at her opinion, I think the court has to exclude it because it's highly speculative and it's incredibly confusing. She first states that the consensus in the community is that you cannot determine when and how DNA moves onto a particular object. She says that without any qualifications, that the science doesn't support that. She then proceeds to say the DNA on the sheath could have gotten there through indirect transfer, meaning it was not placed there by direct contact of a hand, for instance, with the object. And then she goes on to say, but because of two facts, the quantity and the fact there's a single source, I believe it got there through direct contact. She offers this court absolutely no information to support that. She doesn't.
Other than those two things.
I'm sorry?
Other than those two things.
Those two things aren't validated
yes, those are two
as
facts.
proving that, Judge.
But
that's the point.
those facts and the meaning of the facts are relevant.
Not a
We
methodology.
cited a
That's it.
number of cases that talk about expert witnesses and speculative opinions. And our position is that this opinion is so speculative and so confusing that it shouldn't be presented to the jury, in great part because Ms. Nolan does not present this court with anything to support her conclusion. She's basically saying the science says I can't do this, but I think I can.
Methodology that's validated.
If we were in a different place where we had some articles to support her conclusion, if there were articles to support the fact that the amount of DNA or the fact that it's a single source sample is probative of that the scientific principles and methods of DNA testing support that, then we'd be in a different place. But that's not where we are. We're here with a naked opinion with no foundational facts to support it, other than Ms. Nolan's training and experience.
Methodology.
And while training and experience is a relevant consideration for this court, we don't even know what training and what experience she's relying on. We don't have any indication that the lab has done any studies internally about this question. We don't know what literature she's been reading. And frankly, even though she attended this meeting that was held in February, where the proceedings are online and available, she didn't bother to let the court know who spoke and what they said. So I think The reason is because she doesn't have any support for this. And it's going to be incredibly time consuming, not only to cross-examine her, but to present evidence to rebut her opinion. And given the speculative nature and the sort of both sides of it nature, I think the court has to exclude it.
Junk science and a party arguing that's junk science, and then the jury gets to decide if it's junk science or not, is really not the way science should be litigated in court.
Thank you, Your Honor. I'll start where she left off. I don't think she's accurately characterizing what the opinion that's been disclosed. Ms. Nolan did not say, I agree that the science says you should not opine on this or that you cannot opine on this. All she says is that the science does say you can't conclusively establish it. But there are factors, she lays out a lot of those factors that you can look at to decide, to indicate how it ended up there. And she's very forthright. She says, look, it's possible that this was secondary transfer, but based on the fact that it's single source and the amount that was transferred, in my opinion, it was primary. I think under the Idaho Supreme Court's test for expert testimony, that passes. She's acknowledging the limitations and she's giving her opinion, which is going to assist the jury in reaching their conclusion, because the jury's not familiar with any of these factors that she's laying out for them. So, and then as to this idea that she's not qualified, so Ms. Nolan, as disclosed, has been at the ISP lab for 2 decades. She's a forensic scientist. She specializes in biology and DNA. For the last 10 years, she's been the lab manager and overseeing all of the biology and DNA. That includes instructing, as indicated in her CV, law enforcement and others on the collection of DNA. What we're discussing is a critical component of all of that, which is how does DNA get from one place to another? She has plenty of experience to talk about that while admitting that she can't conclusively say one way or the other. But as laid out in the brief, that's never been the test for expert testimony, that you have to be able to say to a scientific certainty that this is in fact the case.
That's the unfortunate reality. It doesn't actually have to be
on
scientific.
The issue of the touch DNA and just the label itself, I don't know that I've ever litigated a case where a party has come in and moved to exclude a phrase used by their own expert in their report. And she didn't just use it, she used it specifically in reference to the DNA on the knife sheath, the exact same way that our expert would use it. And now you have an attorney before the court. She used to be an expert in this case, but now she's an attorney saying, well, you shouldn't do that. You shouldn't, even though both the experts in this case use that phrase, the court should step in and say, you're not allowed to use this phrase that's commonly used in your field because it might mislead the jury. Whatever risk there is of misleading by the phrase touch DNA is easily dealt with on cross-examination. There's a definition that Ms. Nolan provides for that. I assume, though it's not given, that the defense's expert has a definition for that, and they can explain what they mean by that. I don't think it's outside the bounds or intellectual capacity of a juror to understand that sometimes in particular professional fields, there are phrases used that may not mean exactly what they sound like. I think we can expect jurors to understand that and to understand the fuller meaning that's given to it. Part of the problem with the defense's motion at this stage is by asking this court to limit not only our expert, but their own expert, they're admitting that there's something there to be cross-examined. And so if this court orders there can be no statement or no mention of touch DNA, then I think that cuts off a very legitimate line of cross-examination from the state.
So I'm not particularly fond in general of proscribing phrases and words that can be used by parties and witnesses in cases. I think it just creates the potential that you're going to have problems because people slip, and particularly when you're using phrases and words that are commonly used within the field, right? We see that all the time with the use of the term victim, right?
Yep.
In cases, and the Supreme Court has recently weighed in on that issue. There's actually an ICHE instruction that deals with the use of the term victim, because it's just, it's hard to police phraseology. On the other hand, if what we're talking about is an agreement that, this term may be implying something that we all agreed isn't necessarily true in all cases, mean, we could call it blueberry DNA for all that matters, right? And
Magic DNA.
your experts are going to explain what it means otherwise. What's the concern here if we say, let's try not to call it this? Other than accidental violation, and now somebody's asking for a mistrial, right? I mean, that's one of my concerns.
So in reality, that's really the state's only concern is we don't want to get in a situation where there's a word that's off limit. And because she uses it, the defense expert uses it, it slips out at one point that suddenly we have a motion for a mistrial because there was a violation of this court's order. As defense counsel mentioned, Ms. Nolan didn't rely on this word heavily much at all in her opinion, and I don't anticipate her testimony to be anything different. But if at one point in the back and forth, either with us or with the defense attorney, she slips and says the touch DNA on the knife sheath, I don't think that that's a problem.
Travis,
I don't
prefer
think that it's
accuser
something that this court
myself.
should restrict. I think
My
both of these
briefing, I used the
experts felt
term
comfortable and wanted
accuser.
to use that phrase. That's why they used it. I don't think it's superfluous. I don't think they just said touch to say touch. I think to them it means something, and it's accurate to use it in this case with respect to the sheath. But certainly the state has no problem encouraging Ms. Nolan to avoid that word to the extent it's possible.
Thank you.
Thanks, Your Honor.
Just a quick response. Language is important, and language in science evolves and changes. Ms. Nolan and Dr. Ballard, our expert, are scientists. They present themselves as experts. And I think that scientists should be held to a slightly different standard than the average witness. And the use of language, as this court pointed out to me early on when I first stood up here, is really, really important. And I am confident that Ms. Nolan can restrain herself from using that language. And I'm confident that all of the parties can ask questions that do not elicit that kind of information or use those words. And I would encourage the court to restrict the use of those words for this proceeding. As far as Ms. Nolan's opinion, no one is asking for certainty. Nobody expects scientific certainty. That is not our position. The question is it supported by the science that Ms. Nolan is essentially testifying about? And the answer to that is no. Her personal opinion is not science. It is a personal opinion.
Thank you.
And if
You're relying on a scientific report to which there were dissenters.
Yes, but the dissent was not about the content of the recommendation. The dissent was, we don't have any options, and maybe we shouldn't be requiring trainings that are not particularly available in the United States. That is the nature of the dissent. And
But in support of the idea that this testimony shouldn't be precluded by these people.
I'm sorry, I couldn't.
But in support of the dissent, in support of
Yes.
opposition to a scientific consensus that this testimony should not be presented.
That's correct, but I don't think that the court has to rely on a 100% consensus of the community. I think that the evolving understanding of the science and the scientists in this area and of the people who are actually publishing work is highly relevant to whether or not that kind of opinion is actually acceptable anymore. And I suppose that the question of admissibility might revolve around more like a Daubert standard. But given that we have not had the opportunity to see these opinions until so recently, that was not something we were able to do.
The Supreme Court has specifically rejected the Dover standard.
Well, I'm new to Idaho law, Your Honor. That's why I suggest Daubert. But that kind of analysis, I think, is the same type of analysis that this court has to do, as sort of essentially a gatekeeper
analysis
to make sure the jury is
Is it
hearing
helpful or
reliable
not?
evidence. And I think that if you read closely, in particular, Ms. Nolan's second disclosure, which I believe came out in February, or was given to the court in February, she lays out a whole series of things that affect transfer. She makes one statement about the quantity of DNA being higher with direct transfer, but that's not elucidated in any way, and doesn't talk in anywhere in that disclosure or any other disclosure why a single source profile would support her contention. And I think because of the complex nature of this, that we can't speculate as to why. It may make logical sense, but I'm not sure it makes scientific sense to speculate, which I think is what we are prone to do. And as I think the Idaho courts have said, the court's not supposed to substitute its judgment when for the expert's opinion, but to consider it in the context in which it's presented. And here, there is nothing to support her opinion, absent her assertion of training and experience. I'll stop with that.
Right. I'm going to take under advisement the issue of Ms. Nolan's testimony about her conclusion of the likelihood of direct contact of the DNA.
It's neither.
As to the use of the term touch DNA,
It's a helpfulness
I'm not
standard.
going to preclude it. As I indicated, I think it's a discretionary matter. There's science in that area uses the term to have a particular meaning. That meaning can be explained to the jury through the experts. In addition, much as the term victim, there's an instruction for. I'm not opposed to giving an instruction to the jury should that term come out, that the court is not intending to, by use of that term or by any of the attorneys' use of that term, making a conclusion. On the other hand, I do encourage the parties to not use the term as much as they can. I think we underestimate the intelligence and reasonableness of jurors, having presided over, I don't know, well over 100 jury trials. I think that we worry about things that they are more than competent to
Oh boy,
understand
Judge.
and not jump to
Yeah.
a conclusion simply by the use
I've
of
read
a
about
word.
400 trial transcripts. for
Particularly where there's
appeals.
scientific testimony around
Sure, I'm going to agree with you about
explaining
that.
what that word means in context. And so I'm not particularly worried about it. I'm not opposed to some kind of instructions if the parties can agree on one. I would suggest the parties come to an understanding of what a term they should, as a counsel at least, try to use. I'm not going to try to police the experts within their own field who use that term as part of their expertise, as both experts did, state and defense in this case. But certainly would encourage counsel to try to avoid it as much as possible. All right, now I think we're on the make and model of the suspect vehicle.
Enjoy your seatbelt. Your Honor, this is a motion where the words do matter. We're following up on that one. This seems appropriate. This motion, we're talking about the phrase used by the state, suspect vehicle number 1. First, this motion is grounded in Mr. Kohberger's rights to due process and a fair trial. Thinking of why we have this motion, we have to remember this is a highly circumstantial case. That's what this case is about. And one of the pieces of circumstantial evidence that the state will use is a video from a house on King Road, 1112 King Road. And that video depicts a vehicle. There are several views of that video with vehicles in it. The state will also use other videos that depict vehicles or a vehicle in surrounding areas. as they said in their response briefing, they do not have one continuous video loop. So the state's piecing together several videos and calling them all suspect vehicle number one. That invades the province of the jury to make that determination. The state has Special Agent Immel, who will testify and identify a make and model of a vehicle from one of the many clips of videos that the state will use. That make and model cannot be identified from other than one view of that. This motion is not asking the court to prohibit the state from producing the videos or producing Agent Immel insofar as his testimony matches his expert disclosure. But this is about preventing the state from saying, this is suspect vehicle number one. This is the same vehicle in all of these video clips. That's something that the jury will have to decide after they hear evidence to make that determination. This motion is important because that has been referred to, suspect vehicle number one has been referred to by the state in their affidavits for search warrants and other pleadings that they've written where the state has made this connection and they can't do that. This is up to the jury to make the connection if this vehicle in 1112 King is the same one that was in 1125 Ridge Road and other various places that the state intends to show. We're asking the court for an order prohibiting the state from making the reference of this as suspect vehicle one to state that as a fact, not to prevent them from presenting evidence in the way of video clips or expert testimony, but just to prevent them from invading the jury box when that's up to the jury to decide if that's the same vehicle, if it's a Hyundai Elantra, and if it's consistent with one that Mr. Kohberger drove at some point.
No interruptions that time. I think that's a decent argument and a good way to characterize it. They can make their case. They just can't use the conclusory and argumentative language that tells the jury what they should think about it.
Your Honor, it is our expert opinion, who is a vehicle identification specialist, Anthony Imel. It is his opinion that the suspect vehicle captured on various surveillance video shares similar class characteristics to a 2014 to 2015 Hyundai Elantra. He specifically relied on certain video, while some are better views than others, but he relied on all video from 451 Paradise, 1125 Ridge Road, 1112 King Road, and all the WSU surveillance to come up to his opinion. His opinion is based on logical inferences of review of the surveillance and footage, including observed traffic flow, the time of night, the direction of travel, and the camera timestamps. The jury should be allowed to hear his opinion, weigh that information with other testimony and other admitted evidence, and decide if they believe that that vehicle is a 2014-2015 white Hyundai Elantra. Of course, the defense will have the opportunity to cross-examine S.A. Imel. That's the process, and that's the process that should happen. There are no legal grounds to exclude this opinion or to limit it. Thank you.
Our request is not at this stage to limit Agent Immel's opinion that's consistent with the timely disclosed report. It's our request to have an order from the court preventing the state from referring to the vehicle as one vehicle in all of these clips. Agent Immel can talk about the clips, we can view the clips with the jury, and he'll be subject to cross-examination. The motion is wholly about.
We'll say that this is the same vehicle on each of the clips that
No.
his expertise.
No, I think he'll testify that it could be consistent. I think he'll testify he could only identify a Hyundai Elantra from the 1125 Ridge Road video. And I think that he will agree that his original opinion was that it was a 2011 to 2013 Hyundai Elantra. And I think he'll testify that only after Mr. Kohberger was identified.
Not actually true, as I understand it. It was expanded before the 19th.
Let me back up. The email that I think was disclosed in the Frank's motion to the court was that he preferred a 2011 to 2013 Hyundai Elantra, but open up the search through 2016. Moscow Police Department set out their Be on the Lookout flyer for a 2011 to 13 Elantra, and that's what was sought for a long time. Agent Immel in that email did say expand that year. The change that there's a vehicle, a Hyundai Elantra, that's a 2014 to 2016 came later, and that came after Mr. Kohberger was identified on December 19th, and in looking at WSU footage of a different vehicle. That's putting a vehicle together much later after Mr. Kohberger's been identified, not back in November of 2022 when they're trying to identify a vehicle.
We'll look at this.
I don't think that's consistent with the facts, but okay. I think the facts are
It is, Judge.
in the email. It was originally, let's look at this date range. And then he said, well, you know, I'm more comfortable with an expanded, or we need to expand the range through 2015. And that was well before Mr. Kohberger was identified. Now, what BOLA went out, I don't know. I think it may have gone out in two different forms at one point, but the opinion that it could be was before that time, at least as evidenced in the emails.
I agree that in that email, he said expand the search to 2016, but he was more comfortable with a certain year.
Okay, so
I'm trying to explain to the court where I'm coming to my request to the court. I was asked what Agent Immel would say, and I'm repeating it to the very best of my ability. The motion is not about Agent Immel's testimony. I will be able to cross-examine him. He can talk about the videos. He can talk about moments in time where he made certain identifications and why he said what he said in emails. I can talk to him about when the focus for 2014 to 16 changed. What I'm talking about in this motion, what I'm asking the court to exclude is the prosecutor from standing up and telling the jury that this is the same vehicle all the way through these videos.
that would violate what I said earlier about argument before closing. They may say in opening, the testimony of the FBI specialist you will hear is that this is the vehicle that is seen on the various surveillance cameras. That's different.
I agree. The phrasing the prosecutor has used for a long time in this case is to call the vehicle suspect vehicle 1. And so that's the purpose of the motion. This is my opportunity to ask the court for an order, and that's what I'm doing. Thank you.
Right. So I'm going to write a little something on this issue, but what's that? Did the state not respond? That was rebuttal, wasn't it? Good.
Yes, it was my motion.
Yeah. I tracked there. My inclination is certainly the state should not be making conclusions outside of closing statement. I don't think calling the vehicle suspect vehicle 1 is making a specific conclusion. It's again using a term that is used within the investigation, but specifically making an argument that the various vehicles or the various images of vehicles on the various surveillance cameras is the same vehicle. Making that conclusion is an argument, and so that wouldn't be appropriate. I think in opening, for example, you can say that the testimony will be right. As to the agent's ability to make that conclusion, I don't believe that is an ultimate opinion of that is taking the ultimate conclusion from the jury. I think that's right within the province of expertise. And I don't believe, based on the evidence, that it is speculative, such that the agent shouldn't be allowed to offer that testimony. But I will write up further my analysis on that. All right. With that, let's take a lunch break, about
Gonna go to lunch.
45, 50 minutes, and then we will come back. We will shortly before 1, but no later than 1.
All rise.
Well, while we're at it, let's just go ahead and take a little look-see at that, shall we? I am going to go ahead and oof. Uh-oh. Try to bring us to something else over here. Just trying to hunt it down here. Okay. Why does StreamYard not want to let me share that? Okay, here it is. Are we all seeing this? No, we are not. Why did the stream? Okay, yeah, we did. Okay, so this is the email, right? This is the description of what we know about the email that came from Immel. He felt more comfortable setting the year in the range of 2013, and it's based on the email chain that describes. He told them to open up the search. He says he wants a better shot of the vehicle's front fog lights, and then says rather not leave anything out. And he says, I'm really not a fan of the 2014, much prefer the 2011 to 2013. So this is what Immel does early in, November 26th, early in their review of all of this suspect video. He basically says, well, we don't want to leave anything out, but I would like this additional information, vehicles, front fog lights, and rear reflectors, before he would be confident saying it's a 2014. Otherwise, he prefers a 2011 and 2013. And so what does the Moscow Police Department do at that point? They issue their BOLO based on the preference, the 2011 to 2013. They never once issue a BOLO for the 2012. So now let me hang on a second here. Blow this one up. Will it let me? Yes, it will. Here is what we know. Okay, there we have this. Okay, expanded. They expanded it. Did they? I mean, we just saw that. He said, well, maybe, but I really don't prefer it, and I'd like more information to be able to include it. When did they get to the 2014 to 2016 Hyundai Elantra? That whole issue that Ashley Jennings was saying, that's the key finding they want to go with. On December 20th. On December 20th. That's when they got to it, the day after they identified Bryan Kohberger. So what does this sound like? What's the implication here? She even just said, oh, it was based on all the video, including stuff they went and got from WSU. They just found some other video after they knew it was him and knew what kind of car he had, to be able to say, oh, it was this specific one, it fits his. That's when they narrowed it down to 2014 to 2016. So yeah, that is 100% correct as far as the timeline of exactly how this vehicle identification went. So just wanted to share that to make sure that we are all on the same page about exactly what the basis is for that particular claim. What do we have to say about this whole touch DNA, trace DNA thing. Bicka Barlow was doing that thing that Hank Brennan does that I really hate. It really annoys me when you say they don't have anything, and that's just, it's so imprecise, and it just creates an opening for the judge to reject your argument, like he did by saying, well, but they have these two things. The point isn't they have these two things. The point is, scientifically, they can't establish the significance of these two things. They can't establish that these two things mean, therefore, it's probably a direct transfer rather than an indirect one. They don't have the substantiation of that as a methodology, as being able to go in and identify these specific factors. And if these specific factors are present, therefore, you can reach this particular kind of conclusion. So I don't like that was kind of imprecise in terms of how it was presented, but I think that is ultimately the underlying problem here. She admits, they don't have a way to be able to reach these kinds of conclusions, but she's gonna have an opinion anyway. Based on factors that may or may not be significant from a scientific standpoint. Oh, this one is really frustrating to me, in part because, I don't know, maybe I'm just very cynical now. Like, I'm very aware of how low the bar is for junk science. It's low. And it's just that when you're dealing with something particularly like DNA, that it's very weighty. Jurors take it very seriously. They give it a lot of significance, but at the same time, it is probably one of the most rigorous types of methodologies that we have going into the courtroom right now. The evaluation of the, developing of the profiles, and the comparisons, and the reporting, the way they report it as the type of statistical report that they use. It's very precise, very rigorous. It's honestly some of the best science that's in court. And so to have that tainted and distorted, and that strength implicitly carried over to this type of thing, which is not that at all. That's where I really have a problem with this. I don't like it. I don't like it at all. Not everything to be counted as science in a courtroom, or expert opinion in a courtroom, has to have a statistical probability. It doesn't have to have an error rate, a known error rate. But the thing is that good science does have that. DNA identification, DNA analysis, it does have that. They can tell you very specifically, how probable is it to randomly generate this DNA profile given the different characteristics that are observed in it, and what are the error rates associated with the different testing processes and stuff that are used to be able to generate that statistic. You don't have anything like that with an opinion about, I think this might be trace DNA. Maybe the science will get there at some point. It's certainly going to need to, I think, if we're going to continue to rely on trace DNA and not be running the risk of massive amount of wrongful convictions and so forth, because the significance of trace DNA is overstated in court. But maybe that's just what's going to happen. It doesn't seem to have been a real impediment to junk science in the courtroom in the past. So I don't like that at all. It's not an opinion that is scientific. It shouldn't be allowed, but I also expect he's going to, he's going to say, well, this is just something for the experts to sort out. And, they can put on theirs and you can put on theirs and they can argue about who's wrong and who's right. And it'll be up to the jury to decide. It shouldn't be the jury's job to litigate science. That's the problem. It shouldn't be the jury's job to litigate science. They're not equipped to do that. They don't have the background to do that. And it's like asking the jurors to litigate the law. It's not their role. Their role is just to decide what happened. What are the facts? They shouldn't have to decide how do we interpret the facts and what are the valid ways to interpret the facts versus the invalid ones. That's not what they should have to decide. So I find that type of thing very, very frustrating. But it is just kind of the reality. Science in courts these days. Talked a lot of times, as you know, about the wrongful convictions. You can go into the National Registry of Exonerations. You can look at folks like the Innocence Project, the Marshall Project, that do evaluations of that evidence, and look at how many wrongful convictions are associated with junk science. Junk science. It's a big problem. And there just does not seem to be much of an appetite to correct it. Since we're here at lunch, let's go ahead and catch up on some of your questions and comments that have, some of them, unfortunately, already several hours old. Sorry about that, guys. We had a very short break last time, so didn't get a chance to get to anything before. Hank's gaslighting methodology. Can the defense test and identify the other DNA samples from the crime scene through IgG? Potentially. Yeah, potentially they can if they have the resources and the expertise to be able to do that. If they can hire a lab like Othram, obviously not Othram, that would probably be some type of conflict. But a lab like Othram to go in and develop the SNP profile, use the same types of research tools that they have. Now, any exclusive law enforcement databases they aren't able to use. It's part of the problem. The defense can't put it in CODIS, for example. It's not SNP, that's STR. But that's why they would have to use IgG instead of the traditional tools. I just vaguely remember from the testimony that we had way back when we were hearing the motion to compel on the IgG information. We heard about the different databases that law enforcement has. I vaguely remember that one of them was exclusive to law enforcement. It just wasn't very big. But I'm also not 100% sure they'd be able to use the law enforcement portal, right? They aren't law enforcement. If folks like JEDmatch or whatever provide, a specific mechanism, a specific access for law enforcement, I'm not 100% sure that they'd open that up to a defense investigator. They might, but they might not. I'm really not sure. So barring some kind of practical implication like that, yeah, I'd expect that they could. Takes time. If they were going to do that, I would think they would have probably needed to start that a while ago if they want to have, some hope of narrowing it down to somebody, feasible that they could identify as an alternative perpetrator. But I don't see any, there's no legal reason as far as I know why they wouldn't be able to do that. Let's see. Tilly T, sending lots of love from UK. There is still some good in the world. We care. Big hugs and thanks for being here, Nicola. Yes, always thank you to Nicola and the rest of the wonderful mod team. I really appreciate you guys very much, especially this morning when I'm stuck here without my chief mod, Jeff. It just gives me a lot of comfort to know that you folks are out there keeping the chat tended, making sure that everything is still in good working order. So appreciate that, Tilly T. Thank you so much for your support. And I agree 100%. Thank you, Nicola, for being here. Tilly T. Andrea enjoyed Bones Ice stream, but laughed at you in orange prison garb. Sorry, very sorry. Oh, my mother gave me such a hard time for how grubby I was in that particular video. Guys, it's a garden video. You get so dirty. I'm not going to wear something nice. I'm going to wear my grubby garden stuff. Oh, my mom's like, "Can you at least put some makeup on?" Oh boy. That'll teach me. That'll teach me to try to be casual and stuff. No. I honestly, stuff like that, it's not particularly important to me. Um, you know, I don't wear makeup all the time, and so I don't have a problem with making a video without having makeup on and stuff. But yeah, I'm glad that you enjoyed that. I probably won't wear the prison orange again, but we'll see. Tilly T, Jeff and Andrea, I just want to say you got a great mod team and great chatters here. Love from UK. I could not agree more. We do. We've got a wonderful chat, lots of different opinions, lots of different areas of expertise. I notice sometimes it's a little bit of a surprise to people to come in and kind of get the mood of what happens here. Yeah, I think probably like most places, you'll find that opinions tend to coalesce, especially like the longer you've been here, you stick around because you understand and appreciate kind of the way that I look at things, the way that maybe most of us look at things. But it's not like a rule or anything. We don't ban people for having, a wrong opinion. Like, no, there's no wrong opinion. There are wrong ways to express your opinion. But people are respectful and people are focused on the merits. People are good debaters. We love good debate. We're lawyers here. We love good debate. There's nothing better than a solid argument where we can point to evidence, point to rules, all that type of thing. So we absolutely welcome that type of thing in the chat, and it is a wonderful chat. Pine Rider, which Washington Superior Court or appellate panel judges would you argue and defend a case like this? I'm starting to form my opinions locally. This is a difficult question. On the Washington Court of Appeals, now my practice is mostly limited to Division 3. I'm not super familiar with the appellate judges in the other divisions, so bear that in mind. I'm going to go with some Judge Lawrence Berry. I do like me some Judge Lawrence Berry. I've litigated many appeals in front of him for a number of years now. I'm actually it made me realize how long I've been doing this. When we reached the point where I realized I have been appearing in the Court of Appeals for longer than any of the current judges have been on the bench. So I was there before Judge Lawrence Berry. But I find that he has a good mind for technical issues, which are really, really important here. I did a presentation a little more than a year ago now. I was invited to speak to the Appellate Judicial Committee, which is basically like they put together the continuing legal education for the judges, for the appellate judges in the state. They held a big conference over in Walla Walla, and I was invited to present on that on hot legal topics. And I actually chose to present on investigative genetic genealogy, based a lot on what I had learned from Mr. Kohberger's case. But so part of what I talked about with the court was this issue with the statistics and what they actually mean and how that gets misinterpreted, and how that can relate to what had come up during that IGG hearing back in 2023, where one of the experts had suggested there may be a way now, because you have more population-based information from consumer IGG databases, that may be able to help you translate some of this information more into population-based statistics. So not just what's the odds if we randomly put pieces of a genetic code in a Yahtzee cup and roll the dice and get it. That's not really very helpful, because that's not how human reproduction occurs. That doesn't determine how genes appear in the environment. How genes appear in the environment depends on how many people are spreading those particular genes. And that's the information we haven't had conventionally. But we are starting to get more of that with these consumer DNA databases. So that had come up in the course of that hearing. I brought all this type of thing up with the court, and I just remember, looking over and I see Judge Lawrence Berry like nodding his head, I'm talking about this stuff. So I'm like, yeah, this guy gets it. He gets it. On the Washington Supreme Court, I'm going to go. I mean, you could always make this sort of political argument, right? You can pick the judge that has the defense background, the one that likes to rule for the defense, things like that. But I'm going to actually go with Judge Deborah Stevens on this one. And Justice Stevens, the reason why is because she's not necessarily pro-defense at all. I certainly would not characterize her that way. She actually terrifies me because she is probably one of the most intelligent people that I've ever had to argue in front of. And so she has a way of just being able to refine an issue down to pure simplicity. And if you are on the wrong side of that, it can be very devastating to you to be on the wrong end of a question like that. But these are complicated issues. These are nuanced issues. And I do think that, intelligence is important for that, and not just understanding what exactly are we talking about here, but why is it important from a large scale kind of perspective. So those are my quick answers to you on that one, just, off the top of my head. Young Black economist, seems like prosecutor rely on bias to win often. For example, prosecutors allowed to ask how much defense experts are paid, but cops for the prosecution just given expert status. Same with touch DNA bias. Yeah, I think this does make a pretty good point. Maybe it's just because people assume that the bias is kind of implicit, like you don't have to call it out with law enforcement because everybody kind of knows they're there on the prosecution side. And the defense simply doesn't have those types of resources. Of course, they have to hire somebody to say something. They don't have an ISP to do the work for them. They don't have an FBI to do the work for them. So it is a little bit of a double standard that you don't get to call out, well, hey, you FBI, how many times besides the Karen Reed case have you gone through and sided with the defendant? Unfortunately, there's just far too many examples of situations where, the FBI is so aligned with a prosecution theory or a prosecution mindset that they'll make stuff up, lose things, lie about evidence, do, misconducty types of things in order to get the result that they want to reach. So it's very, very common, yes, for prosecutors to, we just heard some of these examples here today. They try to build in the conclusion that they want the jury to reach with the language that they use. Calling people victims is a very, very common one. Washington, the courts say it's not a violation. It's just not preferred. But so what does that mean? It means there's no consequence if you do it. And so people, generally do it. And a lot of courts will say, I don't care if you do it or not. And people can have different opinions about whether that really matters or whether it doesn't. But if it's a fair fight and we're all here for the truth, why would we not just give the jury the facts, find a different way to refer to the person, and let the jury decide, is this person a victim or not? Is this person an accuser or is this person a victim? It's just, it's just a little trick that they use. So yeah, I would have loved to have seen the same energy brought here to touch DNA. I mean, it kind of was, I guess it kind of was. But he sure didn't tell us he doesn't want to police language when he was saying, and especially the language of experts when he's saying, we're not going to use the term psychopath. I don't know. I mean, I guess that's because he's saying, well, there's no evidence that would support it. And that is a good concession. Appreciate that. Maybe there would be at some point. At that point, revisit it. But there is not right now. So not going to call anybody a psychopath in court. But, touch DNA. It's just, it just does. It's requiring a trial of something that doesn't really need to be at issue. So I do appreciate that he's saying, I'm discouraging the use of this term. I don't really want you to use it. I'm just not going to create an order where if you do, it will create a mistrial. Mr. Nye, from my perspective, seems like one of the most reasonable and least combative of the attorneys on the prosecution team. He does not get all, in a hissy fit if he thinks the defense is implying something he doesn't like. Yes, I'm looking at you, Mr. Thompson. What was the need for that sir rebuttal? That sir rebuttal on the use of the tip? Well, I don't know what they mean. Well, we all knew what they mean. We knew that they meant you can't be implying here that police got some kind of information that they didn't, that led them to Kohberger, because that's the risk. If the jury just hears tip, they're going to think from who, based on what, and they're going to try to start solving that problem. And especially if the defense is presenting a theory that this wasn't one person. This could not have been one person. This was multiple people. Then the logical place for the jury's mind to go is, oh, this must have been one of the conspirators. This must have been one of the co-perpetrators. And it's not. So that's the risk. That is really not hard to foresee or understand. But Mr. Thompson is clearly very, very touchy about accusations of misconduct, which makes me real intrigued to see who handles and how they handle this issue with the advanced timing. Really looking forward to seeing that. So I'm kind of suspecting that's going to be Mr. Thompson, but I guess we'll have to see. So anyway, yeah, I mean, I agree. It's just part of the tools. There's inherent bias in the process anyway. There's bias against the defendant as soon as the jury walks in and they see him sitting at the table. Every single person, very rare exceptions, they walk in and they I wonder what he did. Wonder what he did. You automatically assume he did something. He did something. There's a reason why he's here. Police didn't just make it up out of thin air. That's the assumption. So you always have to overcome that in a criminal case. And it's just part of the process. Kimchi, certified dog bite expert in Canton, Massachusetts. Why are alternative perpetrators contested like this? Isn't it inherent in the presumption of innocence that if the defendant didn't do it, somebody else probably did? Well, yeah, and I do appreciate Judge Hippler making that distinction, that there is a difference between the defendant saying, I'm innocent, I didn't do this, therefore somebody else necessarily did it, and what alternative perpetrator kind of standards are getting at, which is, do you need to have some basis to throw somebody else's name out there? The whole justification for having a slightly different standard for alternative perpetrator evidence is that it can be very damaging to that person. In a high profile case, this case is going to be watched all over the world. And so if a name is thrown out there as a this person could have done it, that has the risk to be very, very damaging to that person and their reputation their standing in the community and so forth. There's likely to be people who would go along and think, oh yeah, it probably was him, even if there isn't necessarily a good basis for thinking that. So that's generally why they require something. It's phrased in this, at least in Idaho, relevance and connection, and more than just could have done it, because lots of people could have done it. It's not particularly helpful to the jury to point that out. So what's helpful to the jury is if there are specific reasons to think that this person that you want to name did do it. That's really all the standard requires. And so it can be, this person could have done it. They had the opportunity to do it. They also had the motive to do it. If you can present through evidence those types of things, that's going to tend to make it relevant. I would expect something like that to clear the bar. Somebody could have done it, and somebody said things that suggested that they did in fact do it. I'd expect that might clear the bar. So we'll just have to see. I'm very, very, very intrigued at this idea of having a pretrial hearing where there's a proffer on third-party culprit stuff. It should be public. Judge Hippler is, I think, doing a very good job of just improving the transparency of this case as we're getting closer to trial. Not that things aren't still being, sealed and kept from public view and stuff like that, but yeah, quite a bit less, quite a bit less. And like I noticed his own order, he's not necessarily taking care to not mention certain things that the parties are redacting in their own briefing. The IGG, motion to exclude, I think is a good example. A lot of that was under seal. And he just goes ahead and puts in his order, here's what happened, and it led to these 4 brothers, and they were approached for DNA. Like all of that stuff had been redacted in the pleadings. But he'll just go ahead and put it in his order and let us know what's going on. So I would expect that hearing is going to be public. He seems to appreciate the value of that, and I am definitely interested to know what else is there, If not Bryan, who? It's a natural thing to wonder. Obviously, the defendant doesn't have any burden to prove that. But it's very, very normal to wonder that. I certainly wonder that. I'm very interested to know what else did this investigation prove that could lead us to, wonder if maybe it really was. Maybe it really was somebody else that did it. What are the bases for that? So that's a general answer to your question. It's to make sure that it's helpful and that we aren't damaging people's reputations without at least some basis that's more than just, speculation. Angel Wintrode, off topic, and I know you're busy, but please, in between Bones Eyes, Kohberger, Read, Dog, Substack, and I don't know, eating and sleeping maybe, please view Delphi interrogations because we need your commentary. Well, thank you for bringing this up, Angel. See, the thing is, I already watched these interrogations. I watched them in court, and I already talked about them back when they happened. So I don't really have anything new to add to what I said at the time. These pissed me off. I mean, this was probably the most angry I've been when I have, when I did a recap during that trial. It made me extremely angry watching these techniques, and particularly seeing how Rick held up under them. How he presented under all of them. People can have all kinds of different opinions and interpretations and stuff, and I'm sure that we'll see that in the reactions as more and more people come to watch this now that it's finally, 6 months late, publicly available. To me, that does not look like a guilty person. Does not look like a guilty person. I have said, many times, watched a lot of interrogations. I've seen the transcripts. I mean, hundreds, if not thousands, seen how people behave. If I'm going to characterize how does a guilty person who's maybe still denying, still maintaining their innocence and so forth, how are they going to behave in an interrogation like this? It's way more slippery. It's way more making excuses. It's way more coming up with explanations. The flat denial, just the flat denial. No, you're wrong. You're wrong. It didn't happen. If you got your bullet saying I was there, it's wrong because that didn't happen. That's really not how guilty people behave. They try to explain their way out. And I didn't see any of that. I didn't see any of that type of behavior from Mr. Allen. That's just me, just one opinion. Everybody else is entitled to theirs. So anyway, I would encourage you, go back through the Richard Allen playlist and watch that if you're interested. Hang on one sec. I'll go ahead and pull out the note stash because I'll be able to direct you to what day that was. That was day 11, which was Friday, October the 25th, I believe. I think I got that right. I might not have that right. It was day 11 when Lieutenant Holman presented the second interview. Let's see. Do I have the first? First interview was on day 9, the one that Mr. Mullen did. So day 9 and day 11 are the days to look at for where I commented on those particular interviews. I just don't really have anything else to say about it. You know, I said it then, it hasn't changed. It's still a disgusting tactic, the Reed technique. It is one of the stains on the criminal justice system. That it's still done is kind of appalling, you know, but it is. And all I can really say is that it is well past due for the public to be able to see all of this stuff for themselves and make their own decisions about it. So, Isabel Justice Rankin with a triangle. Thank you. Duncan, Idaho. Are there states in which being admitted pro hac vice is basically a given or reciprocal? I know Washington, Idaho, and Oregon are generally buddies. Does that extend to recognizing bar qualifications? So this is a little bit different than pro hac vice admission. Reciprocal admission is full admission in the bar. So yeah, we do, and various states will have agreements for reciprocal admission. Alaska, for example, will recognize, or at least used to back in the day, would recognize almost anybody by reciprocal admission because they just had such a need for lawyers to want to go there that they would open their doors to pretty much anybody who had passed the bar in another jurisdiction. Washington has reciprocal admission with Oregon, and I have reciprocal admission in Oregon by virtue of being a Washington, having passed the Washington bar. And that means it's full. Like, I don't have to do the pro hac vice, ask for permission to appear. I don't have to have a local counsel that sponsors me. I am considered, well, except I'm not active right now, but I'm considered, fully able to go and appear in Oregon court by myself, and never did much, but on a couple occasions did do that. And so to do that, what did I have to do? You have to, it's mostly money, of course. You pay a fee. You have to submit an application. I have to submit a certificate of good standing from Washington. I have to pay a fee. And then I had to go spend a weekend over, somewhere south of Oregon or somewhere south of Portland to basically like watch a bunch of videos about some Oregon specific, legal things. basically a CLE type of requirement, an initial training type of requirement. And that was really it. Once I was done with all those things, you're admitted, I got a bar number there. And so I can file things, sign things, appear in court, whatever. So, yes, there's a lot of reciprocal admission all around the country. Who recognizes whose is entirely up to that state. So you would just check, whatever state you're in, you want to see if they have reciprocal admission. There will be a record of that somewhere. It'll be somewhere in their bar admission rules is where I would look first. So hopefully that answers your question. Guys, I am going to take a very quick step away here because it is the lunch break. We're not going to have a ton of time. And I do need to check on the animals and stuff. The old dog is wandering. And so I want to check on him. He's needing a little bit of extra attention right now. Last couple of days have been really hard on him. It's starting to hurt him to go out the dog door. So I'm trying to be able to go open the door for him and things like that when he needs out. So I will be checking on him, but I should be back in just a few minutes. All right, guys, going to very slowly not jump scare us back. Everybody's good. The dog got a little break outside. It's a nice sunny day, and I'm hoping that's going to start to help. He has got osteosarcoma, and so that's in his bones. And it got real cold and rainy over the last couple days. And, it's something I can relate to being a little older myself. So sometimes when the weather changes, you feel it in your bones and your joints and things like that. So that's kind of my suspicion about what's been going on with him is just, he was hurting a little bit more because of that situation. But we are on the path to summer, and boy, there's nothing this old dog likes more than to just lay out on his own. He's got his own lounger that he hangs out on and just kind of, like a big old lizard, just kind of melts into it. I'm sure it feels real good on him. So hopefully things will be in the type of condition soon where he'll be able to do that again. And I think that'll be comforting. So I wanted to go back through and check and see how we're actually doing here. It looks like we've actually made it through about 16 of the motions so far, which is pretty good. That means we've got 11 left to go. That bodes well for getting it done today. However, I do think that a lot of what we have gotten through so far has been the easy stuff, things where there isn't really a significant argument, things where, he was able to group it together categorically. And so some of what we still have to talk about is going to probably take some time. The AT&T stuff, the text message stuff, like there's a lot of these where there's just a lot of individual things at issue. The self-authenticating records, for example, there's, a list that's pages and pages long of what the state has, what they want to offer, whether they have a certification or not, what the status is. I don't know, hopefully, if we're going to have to go through all that. Same thing with the 911 call and the text message exchange. There's a line by line analysis from the state of like exactly, whether it's hearsay, if they're saying there's a hearsay exception, what it is, and all that. So I don't necessarily think we're going to have to go through all of that in the courtroom argument. But I don't know. It might matter. It might be a situation depending on kind of how the judge signals from the bench. They may decide that they need to do that in the interests of completeness or something like that. And then what else do we have? The motions to preclude the death penalty, those are probably going to take some time just because they're making a record. Not likely it's going to happen. Just being frank, these bases are kind of above Judge Hippler's pay grade. The motion to strike it due to his autism spectrum disorder is very much the type of thing that is the judge is not going to decide it because it would be essentially a change of the law for him to do that. That is for a higher court to do and to decide. But she's going to want to make her record so that they have the best position they can have when they go forward, should it be necessary in an appeal process to make that argument. The expert testimony, same kind of thing. There's a big list and it's kind of piece by piece, whether there's a problem with any one of these people. And if there's a problem, is it a curable problem? Is it not a problem? Did the state have an obligation to produce? Did the state not have an obligation to produce? The state, of course, is saying it's fine. It's really all they said in their response. It's fine. We've complied. So there just seems to be a little bit of a difference of opinion about what's required and whether that has been satisfied or not. The Amazon click. The Amazon click is going to have, some, maybe some new information. I don't know. Maybe one of these days it's going to be spelled out real clearly. What's that about? What's the, knowledge that he purchased a K-bar. Okay, so we did learn now, I think, it seems like, from the motion about excluding Bryan's family from the courtroom, wasn't them that told police, yeah, he bought a K-bar. He bought it on a household knife. It was shipped to the house. No, it didn't have a name on it, but we knew it was him. You know, it's not them. It's not them. Police haven't interviewed them. And they're not interested in cooperating. They're not gonna volunteer to assist. So until they get under subpoena, they're not under any compulsion to talk to the police. So who is the witness with knowledge that Bryan purchased a K-bar according to the state? It's a mystery again. You know, is it the Amazon guy, Mr. Cox? Is it the FBI, Douglas, Special Agent Douglas, the guy who is the financial? He's like a financial expert. Who's the witness with knowledge? I don't know. Maybe they'll tell us. Maybe they'll spell this out so it can be a little bit more clear, you know, what their basis is for this argument. But I'm also not entirely sure that they will, because it's not critical to the motion. I think the motion is really the click data, whether there's been full disclosure, and based on that, whether the defense has had a fair opportunity to be able to evaluate that and present their response. So I would say, you know, non-zero chance that we'll get done today, but I'm not necessarily holding my breath. I do think there's probably a decent chance that we'll need to come back tomorrow to at least wrap up some of these issues that we may not get to today. While we wait for the court, let me just first off make sure we're ready to go back once we get there. Yes, we are. Okay. I did see another couple comments have come in. Michael Muddragon, I'm under the impression they're allowed to lie to you. What, if any, are the limitations? Can they lie with your attorney present? Can they lie to your attorney? The answer to all of this is yes. Yes, they can. They can lie to you. They can lie to the public. They can lie to your attorney. They cannot lie under oath to the court. They're like everybody else in that regard. But yes, in the interrogation room, or just even in any sort of investigative, you know, capacity, phone call, you know, nothing formal, police can and will lie to you. That is part of the technique, you know, particularly in Reed, that police are often taught in the United States. The idea is that if you think they have more than they do, you'll think that you're caught. You know, if you're guilty, you'll think that you're caught. So you'll just go ahead and fess up. That's kind of the theory behind it. Does it actually work? Not really. Not really. And the main reason why is because if you didn't do it and the cops are lying to you about like evidence that they have that proves that you did, that doesn't get you to think, you know, oh, I better fess up, because you in your mind think I didn't do it. But what it does do is it makes you wonder, well, am I crazy? Am I crazy? Because that's not reality as I remember and know it. And so if you don't know and like take for granted that the police could very well be lying to you, because they're lying to you about whether they can lie to you or not, like we saw with old Jerry Holman, lying to you about whether they can lie to you, then you're going to wonder, well, how could they have that? They shouldn't have that evidence against me because I didn't do it. Is it possible that I did do it? And that's the crack. That is the crack that the Reed technique is looking for and then exploits. Is it possible I could have done it? And then they feed you all of the different ways that maybe it's possible you just did this. Maybe it's possible you weren't the primary person, but you did something. Maybe it's possible that you just did this little thing. Maybe it's possible that you had the best of intentions, but it just blew up. Combine it with things like the minimizing techniques, where, you know, what you did isn't really that bad. It's really not that bad. And I understand, I sympathize. It could happen to anybody. And it's just the way that they encourage you to make these concessions. God, am I crazy? I guess maybe I could. I guess maybe it's possible I did sleepwalk and do it. I guess maybe it's possible I don't remember it, but it happened anyway. Really good example of this in action is the Central Park Five. And you kind of look at all of those different interrogations and the way that they pieced it together with each one of those individuals to try to break them down and encourage them. It wasn't really you, it's probably this other person. They've already, you know, other people have already told us, and that you were just there, you didn't necessarily do anything, or, you know, encourage them to make a minimal type of admission. And then that's what they do. They think, you know, well, I'll make it better for myself. They say they have all this stuff. Everybody else has already turned on me. So I'm going to get busted for something. So I'll just say, well, I didn't rape her, but I maybe touched her, you know. I didn't do this, but I did something else. And then they just use that to build the case. So no, there are really no limitations on the ability to lie. Frazier v. Cupp is the U.S. Supreme Court case that you want to look at to better understand this particular context. They've said it's not a due process consideration. Now, is there a point where it could become coercive? Maybe. I mean, I think there's a good argument psychologically that it's inherently coercive, but the courts don't see it that way. So, no, there's really no limitation on their ability to lie to you. That's why attorneys will typically tell you, even if you didn't do anything, don't talk, don't say anything. Just don't participate in this process. It is not going to help you.
The video's running. All right.
And we are back.
Bushy eyebrows, I think, is next.
Bushy eyebrows
This
is
a
next.
defense motion.
DM is considered an eyewitness. And eyewitness testimony is some of, if not the most impactful testimony in a trial.
It shouldn't be.
The testimony must
but it
be
is.
subject to close scrutiny before its admission is allowed. We seek that the use of the descriptor, bushy eyebrows, be excluded from use at trial because the witness with this descriptor is completely uncertain of what she remembers, and her description is derived from seeing the intruder for only a second. Whether this court applies Manson-Biggers, which I would say is not completely right on point because there wasn't a photo lineup and there wasn't a show up, or the court considers the science behind memory. The criteria you must look at is what factors influence the accuracy of the memory and make the testimony reliable, because reliability is the linchpin in determining the admissibility of identification testimony.
Yes, allegedly.
Between
Melanie,
Manson-Biggers and the science of memory, there are several factors that are consistently
They can't act
considered,
on
and
that
I'm
if they
going to
don't.
go through a few of those. Factor
They can
one,
absolutely
what was
lie
the
to you about it.
opportunity to see? This is also known as first phase of development of memory, or the acquisition phase, and distance, lighting, and duration of exposure are important. DM is uncertain about the lighting. The stairs to her left were not lit. The kitchen may or may not have been lit. And the twinkle lights in the living room may have been lit. She described seeing the person for, quote, only a second, end quote. The person may have been 3 feet from her, or he may have been walking to exit out the back sliding glass door. The back door is further than 3 feet from her door and is not visible from where she was standing. We submitted 2 pictures as our exhibits to show you the vantage point of where she was standing in her bedroom. Her opportunity to see supports unreliability. Factor 2, the witness's degree of attention. This is where amount of alcohol has a significant impact on the analysis. She described herself as, quote, probably very drunk, and given the amount of alcohol she told law enforcement about consuming the entire day, that makes sense. She started with champagne mimosas in the morning, then White Claws 9 to 10 throughout the day. Then that night before she got home, she was involved in a drinking game and drank Borg, which is hard alcohol and flavoring. Her degree of attention, given this, supports unreliability. Factor 3, the accuracy of the description. Her description is that she saw a person wearing all black, not insanely tall. She doesn't know if she saw lips and nose. She is certain he is white. She never mentions eyebrows herself initially. The person who asked about
5
eyebrows
interviews.
was law enforcement. In her second interview, Detective Mowry asked her if she saw eyebrows. She never said anything about bushy eyebrows. Then in her third interview with Detective Gooch, she said she didn't know what the eyes looked like or the color of the eyebrows. That's for the first time that she mentioned bushy eyebrows. This lack of accuracy supports unreliability. Factor 4, what is the level of certainty of the witness? In each of the 5 interviews, she says over and over again,
Might have dreamed
she
it.
doesn't know if anything she says is accurate because she felt like she was in a dream state, frozen shock, fuzzy and cloudy, like wearing blurry glasses, influenced by alcohol, and sleepy. She has an absolute lack of certainty. This supports unreliability. Factor 5, the science of memory looks to confabulation. When the acquisition of memory, the first factor that I talked about is impacted by emotion and stress. In this case, that is an important consideration.
Yeah.
Confabulation is defined as the creation or substitution of false memories through later suggestions that fill in the gaps of missing memory. DM expresses in each interview how she was afraid and did not know what she was hearing, and also contradicts this when she thought everything was, quote, okay, and XK was simply just passed out on the floor. Later suggestion under this definition of confabulation is Detective Mowry asking her about eyebrows and each law enforcement officer, then reinforcing that in each interview. She never used the word balaclava, yet Detective Gooch asked her if she had ever heard of one, explained what one was and that it's used to hide identity, showed her a picture of one, and then had her draw one. This is law enforcement filling in the gaps. This also impacts the last factor, which is factor 6, post-event misinformation effect impacting retained information, exposure to subsequent information. Law enforcement, upon initial appearance at the scene, did not ever break up all of the people that were there. They then go to the police station, and after that, on the night of November 13th, those that were at the house when law enforcement arrived stayed together in a hotel room. So the DM was basically together with other witnesses from the time that when they first called friends to come to the house, before they called law enforcement, all the way through the night. She was interviewed twice by law enforcement. That created this exposure to bushy eyebrows. And then that term was used in the probable cause affidavit, and the media seized upon it from the very beginning, causing post-event exposure, which affects how DM's memory is retained. This factor supports unreliability. When you look at all of these factors, or the totality of the circumstances, the way the state argues it, the linchpin, the reliability is not there. The state wants to bolster a person who admittedly has no clear memory with a photo of Mr. Kohberger to say, this is the person she identified. DM told police that she looked at Mr. Kohberger's arrest picture and did not recognize him. The state cannot run around her unreliability by entering into evidence a photo to show it's a person that she says she cannot identify, because the state's interpretation is that Mr. Kohberger's photo shows bushy eyebrows.
Bushy eyebrows.
That is misleading to the jury. It will confuse the jury. It will be putting words into the mouth of DM that do not exist. While they might not seek to do that on the stand with her by admitting a photo through her testimony off of his phone, if they make the argument in an opening statement that that description of bushy eyebrows is supported by a photo taken on his phone the next day, that kind of prejudice is beyond repair. The state also claims that because DM draws pictures of eyes and eyebrows, she is more reliable in her identification of them. But that
It's
is
more
not
the
the way
opposite.
law enforcement appeared to have viewed the artwork as they photographed it and reported on it. Given the science of memory and its acquisition, retention, and retrieval, this could be what is filling in her memory gaps as opposed to actual memory. When you apply the critical factors that a court must take into consideration for eyewitness testimony regarding identification, the words bushy eyebrows should be excluded. The heart of the issue is whether or not the witness is reliable enough on the issue to let the words be spoken to the jury when it comes to the description. DM said that she could not do a composite sketch because she doesn't think she saw a face. The court should enter an order excluding the words. Thank you.
Well, he's already told us he doesn't like excluding words, so I doubt they're going to do that. He's going to say cross-examine on it.
The defendant relies on the Manson-Biggers test. We just went through the 5-factor balancing test for their argument. However, that test is completely inapplicable in this case. Manson-Biggers has to do when there's a law enforcement-led identification process. The concern is that through suggestive techniques by law enforcement, it could lead to or create a misidentification. Well, that didn't happen in this case because it couldn't happen in this case. The male DM saw that night was covered head to toe. The only thing that was uncovered was a portion of his face. That does not lend itself to positively identifying any particular person. Therefore, an identification procedure was not used, and that Manson-Biggers test is inapplicable. Instead, on 4 separate occasions before Bryan Kohberger was even identified or arrested, DM gave consistent descriptions of the male she saw in the residence that night at around 4 a.m. Every time she described this person as being white, male, wearing all black, a few inches taller than her, she's 5'10", wearing a mask, skinny, athletic, tone build, and not a voice that she recognized. During 3 of those interviews, she then describes the male's eyebrows, and she describes them as being bushy. Obviously, there was some focus on the eyes or the eyebrows by investigators because this is the only portion that she could see. She never wavers in her description of the person that she saw. She's very clear about what she does remember and what she doesn't remember. Defense put the state of Mr. Kohberger's eyebrows into question. In an attempt to discredit DM's testimony or description, they wrote, Mr. Kohberger does not have bushy eyebrows, but the artwork on DM's walls and the way she draws eyes and eyebrows could be described as bushy, full, or prominent. So in response, the state attached a picture of Mr. Kohberger, and obviously that's a jury question, but it was taken only hours after the homicide, so the closest in time to when DM would have seen the smell. And we did this in order to, when we did apply the Manson-Biggers test, to show that it turned out to be accurate. Corroboration does not equal prejudice. The state doesn't intend to introduce.
What
they're
does that
correct.
even
We would not
mean?
introduce that photograph through DM. We would attempt to introduce that photograph and plan on laying the proper foundation and relevancy at trial. There's no grounds to exclude this testimony. DM's the only living individual who saw the person responsible for these 4 homicides. Her description of the male, including any characteristics such as bushy eyebrows, is relevant to the identity of the killer. It is prejudicial, but it's not unfair. A jury should hear this evidence, and the state asks that the court rule accordingly. Thank you.
$1 million question right here. Why'd you
I'll
only
be brief,
remember it
but
on
I
the
want to
5th
circle
interview?
back to where I started. To say that there's no grounds to exclude this testimony is completely inaccurate, because in fact, there is a large body of case law and a large body of science about how important this testimony is. And that's why this court must analyze the reliability, going through all of the factors that I expressed. And there is not certainty with DM in what she saw. And the court now has, over a variety of motions, all of the transcripts that you can look at to understand the amount of uncertainty that she expressed.
Thank you. I'll take that issue under advisement.
Under advisement.
Text message, pardon me, 911 call.
Judge, the state seeks a pretrial ruling that the audio recording of the 911 call and a transcript of that call are an exception to the rule against hearsay. The state submits that the entire 911 call should be admitted pursuant to IRE 8032 as an excited utterance. At 11:49 a.m., BF calls her friend and to come over and check the residence. The friend and a boyfriend show up to the residence. At 11:56 a.m., BF places a call to 911. Just 7 minutes later, this 911 call was immediately after learning that HJ had something was definitely wrong within the residence, and his instruction that the girl should call 911. The statements were before the declarants knew their friends had been murdered the night before. The requirements of IRE 8032 are met, as this was obviously a startling event.
This is so weird.
And two, the statements were made under the stress and excitement that it caused. And that's clear by listening to that audio. The defendant has proposed that their version of the 911 transcript be used, and the state has no objection to that. And I do have a copy of that transcript and the defendant's transcript if the court would like it. Thank you.
Well, I may ask you some more questions, because it seemed to me from the briefs that the defense focused in on 3 particular parts of the 911 call as
So we're evaluating
not falling
redaction
within
again.
the exceptions. So you didn't address those specifically, but let me see where the defense is at.
Your Honor, the best place for me to start is to probably provide you with some copies of the exhibits that we're going to want to talk about. The first set I'm going to hand you was actually filed with the text messages. It's an affidavit of Josiah Roloff and also, let me give you the extra copy. It has DM's messages broken out in bubble form. That's not all. I gave a whole separate copy for Giovanna. I think that's what I'm supposed to do.
This, to be clear, when we're talking about 911, but you're giving me text stuff.
We
related.
are, in our response to the state's motion about the 911 call, we referenced the whole copy of text messages. We just filed them with text messages, but they're appropriate here too for the court to consider. I have the additional exhibits that were attached to our response, and they are 1 and 1A. 2 copies. With those in possession of the court, I'll talk about the state's request. The 911 call is made 8 hours after whatever happened in that house happened, after the killings happened, according to the state's theory of the case anyway. The state wants to play for the jury the 911 call and give them a transcript of the 911 call as an excited utterance or a present sense impression. The context of all of what happened that night is captured in DM's text messaging. There's a separate text messaging exhibit for BF. But it's not that all of a sudden at 4 a.m. something starts to happen and then the 8 hours pass and they call their friends and are startled by finding out that their roommates have been killed overnight. There's a lot more that happens during that time, and to analyze whether they're under the influence of a new and startling event, the court should take a look at all of the text messaging, all of the use of Snapchat, all of the use of Instagram that happened. It doesn't start in the middle of the night and then just stop until noon. There is a whole lot more that's going on in that house. When you hear the 911 call and you analyze each of those statements, the only statement that could possibly be a present sense impression is that from HJ. And he really doesn't say a whole lot. The other statements that the state wants to capture in, one is attributed to a person with the initials EA, and that person is repeating what she's been told. She says one of the roommates is passed out. And then a bit later, under prompt from either DM or BF, she says, oh yeah, and they saw a man in their house last night. Those are not things that relate to an exciting event. She's reporting things that other people are telling. She's not somebody who observed any event in the house. If the court takes a look at Exhibit 1 that came with the 911 calls, it's a smaller transcript and it comes from the grand jury transcript. If the court will look at page 277, that's numbered in the top right corner, lines 16 through 24, EA did not see anybody in that house. She went in, went to the top of the stairs and went back out and she saw nothing. She never went back inside that house. Any statement attributed to her cannot be an excited utterance. She's repeating what other people have told her. Similarly, if you look at the grand jury transcript, this is 1A, this relates to DM, and I'm at page 187, lines 12 through 16. DM is not responding to any of the statements she makes on the 911 call to a startling event. She says that for a brief second, she saw XK, but thought she was passed out from the night before. She also wants to talk about what she saw at 4 a.m, and the dispatcher stops her. Looking at page 190 of that same 1A transcript, DM talks a little bit about that morning when she woke up after whatever happened in the middle of the night happened inside that house, that she reviewed the text messages between her and BF from the night before. She was busy from about 9 o'clock in the morning on her phone. She was on Instagram. She was on Snapchat. She was on Indeed. She was editing pictures sometime in the night as well. This is not somebody who was asleep and then woke up and was startled. She is actively reviewing things that happened on her phone and communicating with other people. Any statement she made on the 911 call is not the result of a present sense impression. It's not the result of an excited utterance. It is somebody who's been awake and thinking about whatever she and BF talked about the night before and communicating with a lot of other people before that 911 call is made. The court should not admit the 911 call as an excited utterance, and the court should not admit the transcript for the same reason. But if the court chooses to admit one, having both is cumulative. So it asks the court to exclude the 911 call.
I didn't realize that DM had said that she saw Xana and just thought she was passed out.
Judge, I think there's a misapplication
Things get
of the
weirder and
rule as
weirder.
well as the event that is causing the startling event, or the reason that they're startled. State agrees that this is somewhat of a culmination. There was definitely a startling event around 4 a.m. when DM opened her door and sees an unknown person in black in the house. She's not sure what to make of this, but that's obviously a startling event, enough so that she runs downstairs to her friend's bedroom.
Is that when she saw Xana?
Yes, a period of time elapses. She wakes up the next morning. The next startling event is the fact that when she wakes up the next morning, her friends, she can't hear them. And she's texting them, and that's what her phone records show. She's texting them, giving them time to respond, and they're not responding. So at this point, she decides to call over friends to come and check on the residents, remembering what happened the
hours
night
later.
before. Now adding to that she's not hearing the roommates above like she normally would, and they're not responding in the morning like they normally would. Then she calls her friend to come over. Then the friend comes over, discovers Xana, and then instructs them something is wrong. And to the point that they need to call 911. That's truly the startling event here.
So
Is
somebody
the confirmation that all of these
discover
things are
Xana.
coming together,
This
and
is
that there's
all
an emergency in the
disjointed.
house that law enforcement needs to respond to, which is the context of how all of these statements are made.
What do I do, or what's your response to it seems like some of this I need to take bit by bit. And so, for example, EA stating that one of our roommates or one of
They
the
did
roommates
not.
passed out and was drunk last night and she's not waking up.
No,
didn't
they did
witness it.
not. It's part of the weird
I think
part.
that falls under her present sense impression of what is happening at that time.
Her hearsay statement of what somebody else told her,
That's
she's
true.
not experiencing anything in that sense other than being there. And I think the case of, look at my note here, of Bemis is instructive.
Well, I would also argue that for this particular statement, we wouldn't be relying on it for that truth. So therefore, it's just not hearsay.
Then why does it need to come in?
Well, solely just for the context of the entire 911 call. But we wouldn't be asserting that what she was saying is true, that the roommate is passed out and she's not waking up. That's not the purpose, or that my friend's telling me that she saw someone in the house last night.
I mean, it's not offered for the truth. You better have a good answer about what the reason is other than the truth. And I'm not hearing one.
Mm-hmm.
Only that it's part of the substance of the entire 911 call. And that part could be redacted, which still, that doesn't mean that the entire call should be redacted.
So I'm addressing them individually. I mean,
Mm-hmm.
there may be parts that qualify.
Because if
and
you would
maybe
make
parts that
reasonable
don't.
concessions, we wouldn't have to do this.
I still
Maybe you
argue that
should
the
talk to
entire
Mr.
call
Nye
in
about
its
that.
entirety.
Well, so here's kind of the way that shakes out. If you offer the tape, you, as an initial matter, can't put in stuff that is hearsay. That's
Definitely not just you.
unaccepted hearsay. If they want to put in the context, if it falls under the completion doctrine, they can. If it's the other way around, in the defense first plays the tape and parts are hearsay are left out and you want to complete it, you can. But you don't get to complete with hearsay your own offered conversation or I think it applies outside the federal context to recordings and testimony.
Yes, that makes sense to me.
So when you say for the whole context, that sounds like the completion doctrine, which I'm not sure you get to rely upon. Well, I know you don't get to rely upon. And so when you say it's not offered for the truth, I'm not hearing something other than the completion doctrine that you're telling me about.
Her answer
I
is
think
state
that's
of
fair.
mind.
I mean, we only have certain exceptions to the rule.
So
If
give it
it, you know,
one.
I still believe that the entire call in its entirety and under the circumstances that the call was made,
You just lost.
the entire call could be considered an excited utterances by all declarants.
You just lost. The answer is it goes to the state of
Also,
mind
there's
of the
a
roommates.
statement by
Why they made the
EAO, and
call,
they saw some man in their
their
house last night.
motivations.
Yeah,
Not
it seems
whether
to
it
me
was
that you can be
true,
more
but just what motivated them.
removed. Again, it's a statement of a hearsay of somebody else, so you got hearsay within hearsay, and not by somebody who observed that and relating to the event that happened previously.
Sure.
So what non-truth purposes is that statement?
She is trying
Again,
so
I
hard
would just have
come
to
up with
say that the
something.
whole
Because
call is
that seems to
excited.
me to be even more concerning,
Right.
right? The first one, I mean, my roommates aren't waking up and we're going to have that confirmed through other evidence. The statement hearsay that the roommate saw somebody is perhaps more of a piece of contested evidence.
Agreed. I still,
Concern about being an offer for the truth is even greater there.
Mhm.
right. And the appropriate remedy, when there's not any grounds for relevancy for this, would be to solely redact those portions of the 911 call, not to exclude the entire call.
So maybe, if you had just conceded that before, we
And
wouldn't
based off of the nature of the call and
Had
the
to
fact that
litigate
the phone
this.
is passed around multiple times, and it's hard to determine who's speaking at what times. And obviously a lot of emotion in their voice, considering what's going on. It's not always clear to understand what's being said. So I think a transcript is a fair way also to convey this and should be allowed
that would
with
be
the audio.
demonstrative, not something that goes back to the jury room.
Nothing further from the state.
Transcript and testimony. In other words, you're essentially admitting the evidence of somebody who transcribed it to say this is what they said. So to me, there's two different questions. One, should the 911 call come in? And second, should I allow, if there is a disagreement, a transcript?
Well, the state has offered to allow the defendant's transcript that they had certified.
The fact it's certified doesn't make it otherwise independently admissible. It's hearsay.
Now the judge is just kind of being
transcript part.
argumentative. You're switching goalposts here. Which do you want to talk about?
Well, it's a transcript of the 911
Is it
call.
hearsay or is it contested?
I believe that it could be self-authenticating.
How could it be self-authenticating?
It has sufficient standards of reliability built into the transcript.
That's not about sufficient standards of reliability.
That may be one. 24 might be a hook. You haven't complied with the requirements of 24 at this point, but
No, but we haven't met our exhibit or witness deadline yet. So obviously we would have to lay the proper foundation for that and would intend to do so. Thank you.
Ugh, the secondhand embarrassment. That was not good. She's not very responsive to what the court wants. She's not a good reader. She's so busy trying to get her point out.
I think I need to take a statement by statement approach to this. I do think that the surviving roommates, surviving victims of the burglary were under the stress of the immediate events. But there are some questions about some of the other statements in there as to whether they would come in. So I think in general, much of the 911 tape meets the qualifications, but not all of it. I think there are concerns with some of them, as I've outlined in my questions. But I will write that because to give you more particular guidance.
So same thing. He'll just redact some parts of the
All
911
right,
call.
the text messages and testimony.
Thank you, Your Honor. Similar motion by the state asking to bring in the phone records for DM between 2:10 a.m. and 4:37 a.m. on November 13th, as well as related testimony around that same time between DM and BF. Again, the state submits that there are allowable exceptions to the rule against hearsay to allow these statements to come in. I broke those down in my motion and reply and the applicable rules for their introduction. This is a much easier piece of evidence in order to be able to present certain time periods and not put in non-hearsay. It's much easier than an audio recording where we would have to redact. But for the messages that DM sends and the messages that BF responds, I think all of those are allowable under the excited utterance, as well as the present sense impression exceptions to the rule against hearsay. If you have any questions about any specific messages.
I don't know that you've been helpful in answering his questions, so I doubt he's going to ask any.
Well, Your Honor has our exhibits already related to this, and then in the record were BF's phone activity. I don't need to quote extensively from those. There's a lot more to the text messages than the state has provided to the court, and the lot more makes a difference when you put all of these into context. We went through some of those in our briefing, and the court can see that there's even more when the court looks at the exhibit. I understand from the court's previous statement that the court would accept a complete copy of something versus just pieces of it. Well, I could offer
Qualifies for
it.
the completion document. If it's necessary to explain the prior admitted stuff and it's close enough connection in time and in subject matter. And so there's some questions there. It's not just automatic.
We certainly would understand that we'd have to present some information or cross-examine witnesses about that. The additional bits of information that are contained in that record, same time frame, though, provide a much better context when we're talking about other communications with social media, with saving pictures, creating new contacts in one's cell phone. right before the texting starts between DM and BF. And then subsequent to that, looking at pictures, editing pictures, calling family members. There's a much bigger picture than just this tiny little piece of texting between the two parties there at night. Further context about these messages the court should be aware that it's not just these messages. There's a lot more activity going on between these two people. And it's hard to tell what it is because there's telephone calls and those kinds of activities, as well as going down to one another's room, spending the time together, talking to each other, really take it out of an excited utterance because it's an entire transaction between the two people. It's not just a tiny little piece of context with this group of text messaging. And the whole is what matters here and takes it away from being excited utterances because of the other activities of the two people.
The activities that occur after. So for example, the texts between, at 4:18 or 4:20 or whatever, those aren't affected by the later activities of, surfing Instagram or whatever. And I'll be interested to hear the testimony of the two young ladies because my
We all will,
experience with
Judge.
that age group has shown that where you or I might phone somebody, others might check out their social media to see where they're at or what they're doing, right? And so understanding how they're using those apps is also important.
It is important, and I would refer the court to our affidavit from Mr. Roloff, talking about the Snapchat activity, talking about Instagram, and there's a way to tell if somebody's active on Instagram versus just having it open in the background of their phone. And those are things that were going on, as well as editing pictures. The picture editing happened in those overnight hours. Instagram happened later in that morning.
Wouldn't affect the excited utterance and present sense impression of the earlier 4 o'clock text, I guess is my point, because those are afterwards.
Well, she's
Those are
saying it
after
proves
they
they're not
went-
excited at
retreated
the
to,
time
the room together and, and what
because
happened
they
there
just went and
happened
got on
there.
Instagram.
Mostly, I agree. There were things that happened right before DM created a new contact at 3:51 in the morning.
Right, before
There-
anything happened that was of an excited nature.
If you accept the state's timeline for that, and we don't know that yet.
The foundation that will have to be laid, but that's their version of the time events, and that's then the jury's job to figure that out.
Shortly after the last text message, and I'm talking just minutes, DM and BF are doing different things on their phone that night as they get together that night. There's the period of time that they're together in that room, both before there's a break in activity. There's not really a break in DM's phone. That is pretty well continuous. And there is a break for BF, but it starts again right away. So I understand the court's looking at an isolated part of time, but I think it's important to understand what activity was happening leading up to that and what activity happened immediately after that when the two of them are together downstairs, to put it into context. One of the other concerns is the use of this text messaging, not just through the witness that's testifying, but to bolster each other's testimony or to bring in somebody else's statements through another person. So I think that it's important when the court analyzes if this is really an excited utterance to look at what's being said, as well as to understand the context right before and the context right after, not the next morning. The one's continuous, but right after.
Well, there are several things that I have to look at. One is, first of all, is it hearsay? Is it an assertion, right? So is it offered for the truth of the matter asserted? We get to those two things. Then we look at, is there an exception? For each of those two things, it generally means it's an out-of-court statement, that it's, unless otherwise definitionally excluded, hearsay. Unless there's an exception, then the exception being the excited utterance. And then we look at the surrounding events? Is it common or current
Well,
present sense
This is so
impression?
second year law
Look
school.
at the
It's a little
surrounding
hard for me
events,
to
what's said.
tolerate.
Much of it is
We shouldn't have to
not
be laying this
assertions
out.
necessarily, or I would imagine some of it not offered for the truth, but simply to establish a timeline. And so I'll look at all of those things, but I don't think I can just look at the whole thing in whole and say, well, because they later on were doing things that, 19, 20-year-olds do with their phone, doesn't mean that what happened earlier wasn't an excited utterance.
Understand. Our position is that those things that happen immediately thereafter impact the nature of those text messages that occurred between the two.
The argument is that they're evidence
Next
that
item
shows they weren't
is,
excited.
The demonstrative evidence.
Oh, I can't wait to hear why did we even bother to scan the house if we're just going to make a random model that's not to scale?
Thank you, Your Honor. In our motion regarding demonstrative evidence, we were talking specifically about, for lack of a better phrase, a dollhouse, a not-to-scale construction, a 3D
So we're gonna
model
make it
of the
look
residence itself. And as
real
the court can
fancy.
see from the materials that have been submitted, the configuration of this house is unusual at best. Certainly, we can use diagrams and floor plans, which we did at the grand jury. But it struck us as we were looking at this case that it would be particularly helpful for the trial jury to actually be able to see in a 3D sense how everything's laid out. What is on each floor, where the bedrooms are, how the first
Well, for
floors.
it to be demonstrative evidence, what's important is whether it explains the testimony of somebody on the stand and helps the jury understand it in relation to the testimony. And the concept of a demonstrative exhibit is that it's actually part of their testimony.
Yes, Your Honor, that's exactly what I was getting at. What we contemplate is the witnesses being able to use this demonstrative evidence to demonstrate where they were, where the rooms of their roommates were, where the entries to the residence were, what they observed, and where everything was located. So it's not intended as a standalone exhibit that has significance. It's only a tool for the witnesses, not just the roommates, but the responding officers, the officers who investigated the crime scene, to point out to the jury where in this 3-story structure certain things were that they observed. And so that is our intent on this. We initially contemplated offering a 2-scale model. And the defense, I think rightfully so, said, okay, well, give us the background information and data that would be relied on. And we requested that, and for whatever reasons, we didn't get it quickly. But as we revisited, we realized that to scale maybe is not what we want. We just want a demonstrative exhibit that witnesses can use, much the same as a sketch, or if they would take a flip pad and try to draw things to help illustrate their testimony to the jury. So that's where we ended up here.
You tried to blame it on the defense in your filing.
We look at the balancing test under 403 as far as relevance. We believe this will be helpful to witnesses in explaining to the jury and to the jury in understanding witnesses' testimony. As far as prejudicial effect, the state doesn't perceive any significant prejudicial effect. Now, I realize that the expert witness for the defendant talks about jurors misinterpreting angles of view and stuff. Well, that would be true if we were dealing with a 2-scale exhibit. And the defense is welcome to offer their 3D imaging or whatever it is that they want to, if they want to have a 2-scale presentation. That's not our intent, though. Our intent is just simply to have this as a tool to help witnesses explain their testimony and help the jury understand.
But to scale, it wouldn't. That's the whole point.
I think you understand this, but so that, it's clear. If it allowed as a demonstrative exhibit, it's not an exhibit in the sense that it goes to the jury.
Correct.
When they deliberate, it will not go back with them.
Yes, we completely understand that. We intend this to be something in the courtroom that is physical, that the jury can look at and the witness can look at and point to things so the jurors have the most complete understanding of what their testimony is.
I haven't seen it, so I don't know how visible it will be to, you've seen now where we're going to be, how visible it's going to be to the jury from where it would be presented. So I guess if I allow, we'll have to cross that bridge.
And that's understood. The last communication we had earlier this week, Your Honor, from the folks at the FBI is that it might be finished within the next 10 days. I'll be candid. I had proposed to the FBI, let us get this in front of the court and get a preliminary ruling from the court before you spend the effort to construct it, but they went ahead and started anyway. So that's neither here nor there. It is intended, as you can see from State's Exhibit 1 or S1 with the dimensions in there. It's a fairly significant size, 35 by 48 by 52 inches. So the idea of making it big enough so the jurors can see it's out in the floor in the well, and they can actually see how things are constructed and arranged. It can take apart floor by floor so they can see each floor individually and then how they are stacked back together. So that's the purpose, to assist witnesses and explain their testimony and assist jurors in understanding the testimony.
Your Honor, we request that you exclude the state from using this dollhouse model. As is everything we're talking about here today. We're talking about Mr. Kohberger's constitutional rights, and we're talking about the rules of evidence. In this case, though, Your Honor, this goes beyond that. This is something that came up in 2023, the fall of 2023. We were disclosed that a group was going to the house before it was torn down to construct a model. We promptly asked in discovery to receive information about this model so that we could start to understand it, so that we could work with our expert with it. And it wasn't until 2025 that we get more information about this. I don't think that calling it a demonstrative exhibit excuses what the state has done here. The state said they didn't have any of the materials. They didn't come forth with them. Their date to be done with discovery came and went. Their date for their expert disclosures in December came and went.
Demonstrative exhibits and trials are typically not brought to light in terms of being shown until oftentimes during trial itself. I mean, it's no different in some senses, as I'm hearing the argument, of sketching on a diagram on a pad.
It's completely different than sketching a diagram on the pad, Your Honor. This, if somebody's drawing something in open court, I can see them. Mr. Kohberger's confrontation rights about how that's drawn exist right then and there if they're drawing something on the board. This is an exhibit that's constructed outside. It's done in preparation for court. There were experts that took the 3D imaging to make this. There were photographs that were taken to make this. There's a process to construct this and to take it from to scale, which might have made some sense because things would be there where they're supposed to be. And by things, I mean walls, I mean doorways, I mean angles of hallways, I mean lines of sight. Those things would be there where they were supposed to be if we were doing this to scale. But to not do that and call it a demonstrative exhibit so they don't have to tell us about it is really misleading to the jury. And there's a lot of danger for the jury to be completely confused by that. I don't think this change excuses what the state did to sit on this information and wait until the last minute when we don't have any ability to investigate it or to look at it.
You had access to the house, right?
No. What, to the old house? Yes, but not to what they're doing now.
But you had the ability to create your own models, to do your own measurements, to come to an understanding of the layout.
Absolutely, we did. What we don't have the ability to do now is to test the state's model before it gets in front of a jury, before different witnesses use the state's model to say, this is where I was and this is what I could see. If a doorway is just off, the line of sight is just off. That can be completely misleading to the jury. This is an unfair surprise to Mr. Kohberger. To have this come in and have the jury look at this. It's not a PowerPoint. It's not a drawing on the board. This is going to be this big 3D model that's going to be pushed around the courtroom. It's going to draw the jurors' attention. They're going to put a lot of emphasis on it.
Mm-hmm.
A demonstrative exhibit that may or may not be accurate, that may have the walls and the lines in the right place or the wrong place, that won't have depictions of furniture or the way the house really existed that night. And the jury can place great weight on that. And it might not be actual. It could skew the testimony. It could skew the truth. And that's really important in this case.
Where cross-examination comes in?
Your Honor, how can I cross-examine a 3D model that's constructed outside of a way I know anything about?
Well, you had access to the house and you know what the house looked like and you have photographs.
I do have those things, but if there's a slight shift in this 3D model, it's going to be more difficult to depict that. And that's a lot of runs around to try to get our expert to take a look at this, to try to get our expert to pull the 3D picture that would show that this model's wrong, and to try to get the jury to want to listen to all of that, when the best and easiest thing for the court to do is just exclude it. This is not a model that will do anything but cause the jury to speculate. It could easily produce testimony that's not true. The jury might be relying on things, and likely will be relying on things that are not true. When you look at the case law that talks about demonstrative exhibits, you're looking at things like PowerPoints. You're looking at, that's in the Weigel case, whether or not the demonstrative exhibit should go back to the jury. When you're looking at the Masters case, it's an exact car seat. That was a civil case. It's an exact car seat, like was in the case at bar at that time. Here, this demonstrative exhibit that's going to be large may or may not be accurate. Conversely, I have the photographs, so does the state. I've been in the house, so is the state. There's 3D imaging that was taken by the state and by the defense. With all of the thousands of photographs and all of the people that have been through the house, there's no reason to take a chance on this exhibit that will be speculative and will confuse the jury. To allow this is allowing the state to ignore the discovery process. They're just slapping a new label on this model and saying it's not to scale, so we don't have to disclose anything to you. To allow them to rename this is a violation of Mr. Kohberger's constitutional rights to due process and a fair trial. This should absolutely not be allowed. Mr. Kohberger we have done everything we can to be apprised of what the state's going to do. And at the last minute to pull this out after we've asked in discovery for this and to label it a demonstrative exhibit, Your Honor, that just can't happen if Mr. Kohberger is to have a fair trial and if his due process rights are to be adhered to. We strongly object and ask the court to order this excluded.
Or in the I don't know if it's LiDAR or what they use, the 3D information.
I'm sorry, Your Honor.
You have the laser information,
As of March 4th or 5th, I think that we did receive that. We sent that to our expert. He wrote a declaration in support of our objection to this, to let you know how long it would take him to do the work necessary to even measure this, and then he'd need an on-site visit for this. And if the court allows it, that's what we have to do. But the court should be well aware that when the state does these kinds of things, these things mean taking their time and throwing things out long after deadlines come. There's a ripple effect that happens. We have to work with our expert. The expert has to carve out time in his schedule. We have to take time to understand what's happened and figure out how to respond to it. We are very close to trial, and those deadlines are important for a reason. All of the stacking up of things like this at the last minute outside of the deadline set by the court and outside of the rules further prejudice Mr. Kohberger and his ability to have effective assistance of counsel at trial.
If they can't reasonably prepare, then ineffective assistance is an issue.
Taylor's talking about might be true and applicable if we were offering a scale model. We made the decision not to. She complains about the timing of underlying FBI data. Well, that request from her for that information related to a proposal for a scale model. And we provided it anyway because she had requested it. In our view, it has no bearing on whether the demonstrative exhibit is acceptable and appropriate. The allegations that we've tried to sit on this and bury this, that's just silly. That's not what happened. We provided the information we received as soon as we received it. It was processed. I don't think that the defendant can point to anything to say otherwise than that. It's just simply a demonstrative 3D model to help the witnesses explain their testimony and help the jurors to understand the testimony. That's all we're asking for.
Take it under
Thank you.
advisement. Battle of the Dollhouses.
I will give you a written decision on this soon, shortly, but there is a significant distinction between demonstrative trial exhibits or trial models, charts, things of that nature, and attempts to use things for evidentiary value in and of themselves. The more complex, it's not particularly different than a drawing by a witness or something of that. It's not uncommon to get these very close to trial. Defense counsel has had access to the house, could have done its own diagramming if it had wanted to. It has now the information on the, I'm just going to call it the laser or LiDAR modeling measurements, whatever that was done by the FBI. It's April. Trial is starts in August. I think there's plenty of time for the defense to respond to an item that is not actual evidence. It is simply part of testimony that will be forthcoming at trial. And will not go to the jury. Jury will not have it in its presence when it deliberates. I don't see, frankly, the concern with respect to the use of a model in a case like this. So
It's the
I'm going to
ability
allow
to
it.
cross-examine on it, Judge.
The state will make it available to the defense prior to the pretrial conference and sooner if it doesn't sound like it's complete yet, but as soon as it's done and certainly as quickly as possible. And like I say, it's not going to be allowed for evidentiary value. It will be a part of the testimony. Whoever testifies is going to have to testify that it helps explain their testimony and that it's consistent with their observations. That's subject to cross-examination by counsel. If there are problems with the model in terms of view lines and things of that nature that they were able to put together through their own visits, through their own studies, through their own opportunities, including through their experts if they want to. So. All right, next I have self-authentication of records and reliance on 803. I'm not sure we're ready to argue this because I don't think the state has complied with the obligations in order to rely on the self-authentication issue.
Thank you.
If
It's
they haven't
premature.
provided the specific documents and certificates that they're intending to rely upon in advance of the motion at this point. So I'm not sure that this isn't premature.
Yeah, Your Honor, we agree. That's probably an accurate statement. And a better time will be after the exhibit witness list is due, and then the parties have to get together and determine what exhibits we have objections to, and then we can address this issue.
Part of my scheduling order is a meet and confer over the exhibit lists to determine whether there's a good faith basis for an authenticity objection or not. And certainly the rules on self-authentication are crystal clear as to what is allowed. And so if it meets those, then I imagine we won't have a problem. Add anything, counsel?
No, Your Honor, I won't right now.
All right, let's talk about alibis.
Let's talk
This is
about
the state's motion in
alibis.
limine.
Thank you, Your Honor. Excuse me. First off, I want just for the record to make a record of the corrections to the typos that I missed in our initial filing. I emailed Your Honor staff attorney and counsel over the weekend. There were dates that were wrong. Page 1, item number 2 of our motion. It should be July 27th instead of July 22nd on that particular court filing from 2023. We overlooked, and I apologize, the defendant's July 24th, 2022 initial alibi response, which, as the court can see, essentially wasn't a response at all other than we'll come up with an alibi at some point. And then page 2, item number 7, it should be February 29th instead of February 23rd for the date. And I apologize to the court again for those oversights. And they were certainly entirely my fault. This issue has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi.
You said your own data and
The
your
state's
own
position
witnesses.
is that
And then
to this
Siren.
date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders. The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from April earlier this year.
It's not really an alibi.
From earlier this year doesn't
Fair.
have anything new or different. Talks about partial corroboration of a partial alibi, which frankly, the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because his phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself. If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point. And to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their expert, cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was a significant time or a notable time before the homicides themselves occurred here in Moscow. There is nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone experts on the activity of the defendant's cell phone and what direction it was. But that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh, yeah, he was at my house at 4:06.
Yes, sir. Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration. Now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue. And I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on in 5, whatever it was, 4, so whatever.
They don't have anybody else. I think we already know that.
If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi. And a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, so as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video and 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513 subsection 3 that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify.
He doesn't have to prove he specifically was somewhere else. He just needs to prove he wasn't in Moscow, or he probably
The
wasn't
notion
in
of partial
Moscow.
corroboration of the alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
Well,
it's
why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness,
yes, sir.
or the alibi instruction likely is not going to be given.
Yes, sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Right.
So there's not going to be an issue with the cell data. It's literally just at 4:30 because that's when the state says the murders took place. Is anybody going to testify to where he was at 4:30? We agree. Right now, the only person who can say that is Bryan. But that could change because we don't know what's in discovery, and I don't think anybody does with 68 terabytes.
All right, let's talk about the AT&T stuff.
AT&T stuff.
Thank you, Judge. This should be fairly simple. The state seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you
phone.
say continuing to allege, I'm assuming you mean in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing
Is
is
it for the
what's
jury
at
to
issue.
decide?
And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for
Why
anyone's
didn't you
phone.
just say that initially?
We did do search warrants for other people's phones. We did a tower dump and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period. So the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window. So there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
The defense filed a document yesterday, and I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're talking.
You're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
I have nothing further. Thank you.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance
What
records.
evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific.
I read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
That is the problem.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for the time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022.
And we already
You've
know
absolutely heard that from AT&T. What you haven't heard is the other way that.
It's the other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once and they said, oh, no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit. It's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
So the 7 days that he's back home,
maybe.
I'll ask the state about those. If they receive those. I'm not sure their search warrant covered that time frame, but.
Your Honor, I would say that it did. And I would say their first search warrant was just a 48-hour period. It asked for timing advance records. But then the second warrant,
You would agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that. And here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked
You're giving
with.
me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay, but you've made some serious accusations against the state of hiding evidence. And yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
Because they were
records.
asked within 7 days of the date that they sought it. It was the tower dump from
He's
the
not
night of the
wrong,
murder,
guys. He's
asked
not
within
wrong.
the 7 days.
This was the problem with Cy's affidavit.
I understand that.
Okay. So where is the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't because they didn't know who he was.
You're correct. They didn't know who he was until I think about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What you're
them.
talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Ooh, Mr. Ray's conspiracy theory.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my attention
Our
more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you,
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
he is available to testify if the court wishes for him to.
It's his
There we go.
obligation and your obligation to establish that evidence
Well,
of
they're offering to do that.
that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put into any context. The state had indicated and provided AT&T's sworn testimony that they only keep him for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that was available to them,
No, you don't. You can
By the
just
time
ask
Mr.
and they can say it
Kohberger-
wasn't available.
was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do. And that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury
Thank you.
at the time of trial.
That will satisfy me. Thank you.
Okay. She kind of got off on that one.
And I'm not upset, but I just for Mr. Ray's information,
are
because
upset.
he wasn't here the first day I started this trial with you folks. I said, I don't want theatrics. I don't want accusations that aren't supported with evidence about supposed bad conduct of the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning. The kinds of accusations, if true, that would get people disbarred. And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't make me happy.
And to address the court's concerns of what's been raised, I think the only issue out there, I have the 2 search warrants. The state asked for the AT&T timing advance records in our search warrants. The state wanted that information from Mr. Kohberger. We did not receive it. I did not receive those records from AT&T. I do not have them. Thank you, Your Honor.
All right. There's not been a showing that those records were available. And I think it would be unfairly prejudicial to try to impeach the testimony of the agent that somehow he hid or didn't provide or didn't use records that he didn't have available to him. So absent some factual showing that he had them available, I'm not going to allow questions about that. And I'm not going to allow testimony about that. Now, if you want to voir dire him before he testifies in front of the jury, I'll allow that. And if you show a factual basis for it, I'll allow it. But you haven't at this point.
I appreciate the opportunity to ask the question outside the presence of the jury.
Well,
Thank
it
you.
is the state's motion, so. Oh, he got right to the problem, didn't he? The
All right.
problem was at 7 days.
The vague and undisclosed expert testimony, I think in part touches on this, but not entirely. So I'll let you talk about the other entirely part.
Yes, thank you, Judge. Then you'll get a break from me in a few minutes, I think.
I enjoy dialoguing with you, counsel. I appreciate it.
Well, good. I think we're going to have some time together over the next 6 months or so. Your Honor, this motion came after our hearing in January, and we're asking the court to limit what the state can produce with their experts here. I do have copies for the court, extra copies for the court. We had a specific request at the end of our motion. We called it Exhibit 1, and it went through all of the state's experts and basically described what we think the court should do with the state's experts. And so I wanted to provide that to the
So
court.
I did see that and read it.
Okay, good. Thank you. Let me get to my same page. I want to start though today with my presentation and my request with a little bit of history with this case. And as the other motions are, this motion our motion for the court to exclude all of the state's experts as outlined in our exhibit is based in Mr. Kohberger's rights to a fair trial, effective assistance of counsel, due process, and guaranteed by discovery rules and rules of evidence, and the court's own scheduling order.
It's rooted in Rule 16, which is kind of where the court looks at these issues.
Rule 16 it is, yes, Your Honor. This started with discovery requests very early on where we asked for expert information from the state. I'll skip forward to the court's scheduling order, which was very clear about what should happen and that we needed to have our expert disclosures in at a certain time. The state's date was December the 18th, and shortly after we received the state's expert disclosures, we filed a motion to compel. We wanted the rest of their disclosures. We had a dialogue in January about that, and the court asked me, why are you doing this? I'm going to make them abide by the rules, by the discovery rules. I really thought when we filed that motion, the state would say, oh, okay, and we'll just get you the information. Most of these are experts they've been working with all along. But that's not what the state chose to do. The state chose to say, nope, I'm going to dig in my heels, and we did plenty until the court said your job is not done.
Well, to be fair, and in the way I handle these issues with Rule 16 in the criminal context, the rule is not particularly broad about what is required. And the court has interpreted that rule fairly narrowly in other cases. I give the speech that I gave to you both in most cases where there are a lot of experts.
So now we're
to
backpedaling.
encourage sharing beyond that which is required, because I think it helps both sides. And I think it helps the experts be better prepared to testify because counsel understands their testimony better. I think it allows for cross-examination better. And I think it creates just a more fulsome picture of things that way. And that's why I invited the state to supplement. And I also invited you to be likewise broad in your disclosures. Now, at the end of the day, I am bound by Rule 16. And so that is my guidepost.
So, Your Honor, I believe Rule 16 references the Idaho Rules of Evidence. And I believe that the state's requirement is to provide at least the opinion that their expert is going to offer. And case law, it's the State versus Moran case, says that bare lists aren't good enough in this case. Your Honor, the state didn't immediately file and fix the issues that they had, but we filed our disclosures, and our disclosures weren't bare bones. They were exhaustive in method and analysis and opinion. And the state gained an advantage when it happened that way. The state then went from having their experts due on December 18th and really setting the bar. We have the burden of proof. This is what we're going to do. These are our experts, and this is how we're going to do it. They went from that place with their duty and their obligation to giving minimal, which were just lists other than a couple of their experts, and then receiving all of ours. And you can see in the next bit of pleadings that really shaped what they were going to do. When their rebuttals came due, they got an extension until February 17th, but that didn't see them fixing the problem that they had in large part. Some reports came in March 3rd, some March 14th. So the state has effectively given themselves months of additional time and the advantage of having our expert reports. And that just can't be when you're looking at fairness of trial, when you're looking at who has the burden of proof, when you're looking at due process. The state is to say, this is what we have. This is how we're going to prove this case. And for us to decide how to respond to that. And that got turned upside down with what the state has done here. They held back, gave us bare lists in large part, and then had the advantage of having all of our work, how we would anticipate we might rebut the state's evidence, and allowed them the advantage of deciding what to give us and when. It is extremely difficult when the state gives things just a piece at a time to us. It is extremely difficult when we have a deadline and we have plans, we have our experts, we have our schedules with our experts so that we can continue to prepare as we head towards trial. To have the state act in this fashion, to hold back and then to give things little bits later without even giving a full expert analysis in some cases. The court has the duty to ensure that we have a fair trial and that Mr. Kohberger's due process rights are adhered to. And the court should exercise its discretion and apply the rules and limit what the state is able to produce as far as their experts. I'm going to talk a little bit about the different experts here. They are outlined in Exhibit 1. I don't think I have to go through every single one. We tried to be pretty clear for the court if the court looks at that when considering our motion. But I do want to talk about a couple of them. And obviously, agent balance is the one I'm going to want to talk about. Your Honor has heard some things about this disclosure. I can't call it a report because it's a PowerPoint. I don't know what Agent Balance's conclusions are. And Agent Balance doesn't, the PowerPoint obviously isn't going to be complete. PowerPoints aren't designed to be complete reports of what happened and what somebody thinks has happened. We've had several different disclosures now. They don't help much. On March 3rd, for the last time, we learned that Agent Balance acknowledges he analyzed the last 7 minutes of data on the phone, but we don't know what his opinion is about any of that.
Allowed to give an opinion about those last 7 minutes?
I'm sorry.
Doesn't that just mean he's not going to be allowed to give an opinion about those last 7 minutes? I mean, I can't force his expert to have an opinion, their expert to have an opinion.
You can't. And we're here asking you to limit what they can testify to by surprise once we get to jury trial.
Yeah, so
Agent Balance is worth
an opinion
further
about 7
comment
minutes.
to the court. Agent Balance was co-located with investigators in this case from the very early days, just a couple of days after the killings took place. He is somebody that the prosecutors have had meetings with and have had ready access to throughout the course of the proceeding. So it's not like he's a stranger that they couldn't get his report from him. He has offered his PowerPoint with no analysis of these phone transactions, no analysis of the mapping that was done. And to understand that he conducts drive testing and he carries around a scanner when he does his drive testing, and that scanner will collect data about which towers are working at that given time. So you can get a lot more accurate information about where a device might be. The other way to look at what devices are doing is when you're looking at different cell towers and the phone transfers from one to the other as the phone might move around in a car. But the drive test data working with that shows you a place where there's a tower, all the places that there might be coverage. And then if the phone hands to the next tower, it'll show you that coverage too. So you can see limits, you can see gaps in where coverage is, and that helps you identify where a phone is more. Agent Balance hasn't analyzed all of the data he collected, nor has he told us what it means. So for Agent Balance, the court should preclude his testimony about the last 7 minutes, and the court should preclude the rest of his testimony, really. I think the state's initial disclosure was that he was going to talk about cell towers and how they work with cell phones. That might be fine. Anything else, they shouldn't. I want to tell you, though, while we're on the topic of that last 7 minutes, that it's more problematic.
That was part of the initial disclosure, correct?
The PowerPoint, I believe, was provided as a disclosure.
Did he testify for the grand jury?
No, nope. Officer Mowry, Detective Mowry testified before the grand jury. Agent Balance did not. So I don't have any of his testimony, but I want to tell you about the 7 minutes. And I want to tell you that those are problematic. when the phone's moving, when Bryan's phone's moving the last 7 minutes before it goes off the network, and you look at the locations of where the phone was, it places the phone in a place at 2:54.45 in the morning. And for Agent Balance to ignore that, there's a cascading impact on other bits of testimony that will come in. So it's imperative.
That's just impeachment.
Well, it's actually exculpatory to Mr. Kohberger, so it's worse than that. So
You're doing this in the frame of a motion related to the expert disclosure, and so his opinion is what his opinion is, and he's disclosed what he's disclosed. And let's just hypothetically say he can't opine about the last 7 minutes because he hasn't disclosed that, and I haven't gone through in enough detail to make that conclusion, right? Isn't that then just a matter of you putting on testimony from your expert about that 7 minutes and impeaching him about, you didn't even look at the last 7 minutes. You missed that. And
Or
what could
ignored
that
it.
mean? Couldn't it have mean as my expert, obviously your expert won't have testified by then, but impeach him essentially on his lack of diligence, as you would put it.
well, I anticipate impeaching for the lack of diligence. Here's the fear, though. I don't know what he's going to say about those 7 minutes, so I want to impeach him about that. I want to impeach him about a whole lot more too. But if I do, and he says, well, I did analyze it, actually, I hope the court's order stands and he's not allowed to talk about it.
You have to be careful about what doors you open, but
I
brother.
agree. And when the court said that, it made me think of that. Going back to what I'm asking you to exclude, I'm asking you to exclude everything that wasn't contained, and there's no opinion, there's no analysis contained in that original PowerPoint.
She's on to him.
There's just PowerPoints with a few things on them that he won't be able to explain because
they did supplement and explain, at least in some detail, more about what each slide kind of means, as I understand it.
well, Your Honor, that comes back to kind of where we started with the state waiting to see what we had. That's not how this works. In the adversarial system where the prosecution has the burden of proof, we can sit at the defense table and do nothing. I don't have to produce a thing. They have the burden always to prove the case. And what they've done is they've turned that upside down. They've essentially and figuratively shifted the burden by holding on to what they had, even though they have the duty, and said, show us yours first, and then we'll rebut your experts. And that's just not the way it works. And I think the court should look at their disclosure deadline. And they didn't go home from the January 23rd and 24th hearing when the court said, your job's not done. I'm not going to allow things in that aren't disclosed. They didn't go home and say, we got to get this done now. They trickled things in bits at a time. And that is just not the way the system works. And that's in violation of Mr. Kohberger's rights. And we're asking the court to limit it. What they gave us on December 18th, that's what they get to talk about. There was no opinion in there, no real analysis in there. And that's our position. And that's the way to bring it back and keep the burden at the table it should be and protect the due process rights and the right to a fair trial at the table it should be. In our filing, I won't read it all to you. We had a lot to say about that with Agent Balance.
Search warrant application include the analysis of the cell teller information.
Did the search warrant application include the analysis? Let me think what the search warrant application said first.
That large, omnibus document that they used,
Oh, Exhibit 1 that was attached to all of them.
attributed to, if not the signatory, but the FBI CAS team.
Well, we're talking about a couple of different parts of the affidavit. There was the factual part of the affidavit that Moscow Police Department, various members of the police agency used it, the same affidavit or a couple different versions of that same affidavit. There was a part that I don't think Nick Balance ever signed it. I think he
My point is,
dictated it.
were you on notice of what the state's version through the CAS team of what that data showed?
If I look at the affidavits, there are a few things, yes, that I would be on notice for. They're not attributed to Nick Balance,
But
but
we
there
don't know
are a
how
few
they got to
things.
it. It's part of the problem.
Those are the problem areas, and I don't want to open doors that I shouldn't. I mean, I either need his analysis if I'm going to open the door, or he doesn't get to talk about it. And let me tell you what I
Talk
mean.
about the adversarial part. I also looked then in that case at what information you did have about what the state's case was. And so, it seemed to me that in general that cell analysis was part of that, because part of the motion on your part was the missing 7 minutes.
That definitely was part of the motion. And now for the first time, I know he actually analyzed it. What that affidavit, those two affidavits, I would tell you about 3 parts that could be attributed to any cell analysis. And then I'm going to tell you the problems with those 3 parts too. The first is that the phone went off at 2:47 a.m., which it did not. It did not. That's untrue. The other is that the phone was traveling towards Moscow when it went off, and that's absolutely untrue as well.
As I recall, the 47 said it was traveling southwest.
Well, that's what we say. That's what the record shows.
That's what the application said.
The application said that the phone stopped reporting to the network at 2:47 a.m.
Traveling southwest at the time, southwest of Pullman.
That's not when the phone stopped reporting.
I realize that, but it's not like they were representing that it was at 2:47, halfway to Moscow or traveling to Moscow. It said it was southwest of Pullman, which, as I understand, the 2:52, 54,
70.
7 minutes later, indicates it was traveling southwest of Pullman.
None of the search warrant affidavits have anything about 2:54. It was.
I understand that. My point is, the time was wrong, but the point that the direction of travel is the same.
There are paragraphs in the affidavit that talk about the phone traveling towards Moscow. There are slides in Agent Balance's PowerPoint that have an arrow, and that's not true.
Well, there is a, in the search warrant affidavit, I think as part of the PowerPoints, I don't remember the language it used, but basically the believed route of travel or something like that. In other words, their opinion of what the travel route was. And so that was disclosed, what that alleged travel route was.
Cell phone records would indicate something different than they said. So and I see what the court's doing. The court's saying, okay, you have this PowerPoint. What else were you on notice of? I'm on notice of things that the records contradict, the records being the AT&T records that we received from the state. And those records contradict those things in the affidavit. I'm also on notice.
Allow for supplementation of expert disclosures to correct errors, to provide new information, to make them fuller. I mean, the rules allow for that.
That's not what they've done.
I understand that's what you're saying. That's what they haven't done.
That's not what they've done, Your Honor. And
that's why I'm looking at what did they actually say beforehand, because I think part of it is a notice issue to you.
Well, I'm on notice of things that the records don't support. I'm on notice of a PowerPoint that doesn't have any analysis or opinion in it. So those are the things that I'm on notice for with regard to Agent Balance testifying. So it asks the court to not allow him to testify beyond the December 18th very limited disclosure. We have the disclosures that still have some vague language in them. And we talked about this back in January, where it's imperative to not let people offer opinions based on this vague language that they can change their opinions. That happened a lot with lab people. There were some additional disclosures with lab people bringing in CODIS. That came in the
That's not an opinion. First of all, it is an explanation of why they didn't submit evidence to CODIS. I'm not seeing how that's an opinion. That's just a statement of what the facts are.
Your Honor,
It's not expert testimony. That's, here's our policy. Here's when we submit stuff to CODIS and here's when we don't. And this has been raised as an issue. Why didn't this get sent to CODIS? And this is why. I don't see that as an expert disclosure issue. That's purely a factual issue.
So the protocol allows the individual, a certain analyst, to make that decision. That's what the protocol says. The why of that decision has been something that we learned about for the first time in the February 17th disclosure. That was curious.
My point is, I don't really view that as expert testimony. That is simply the underlying factual happenings. It's like, why did you then make a phone call to this person? Well, because. I mean, it doesn't make it an expert opinion. In my expert opinion, I thought it'd be good to call this person. These were fact people on the ground making decisions about the investigation. Now, in today's world, and as the state pointed out, there's an over disclosure of fact witnesses as potential experts so that they're not caught in the situation the lawyer was with the drug recognition expert with the state police when it was determined, well, he was offering an expert opinion about something in that regard. And so you get a lot of fact people disclosed in expert disclosures, but I'm not sure how, because there was a lot of briefing back and forth on that, how the decision whether or not to send the sterile DNA to CODIS is an expert testimony. It's just basically lab protocols.
I think as long as it doesn't tread into an expert opinion about that, we can.
What would that be?
I don't know. I haven't read one. I don't know. I mean, if they're having some opinion about what those spots on the handrail and the wall look like, I guess.
Well, I mean, I wouldn't expect to see at this point an opinion that, it was the DNA of Y person, right? Unless there's been newly discovered evidence.
Well, I don't have any of that today, but I understand there's more for me to pick up, but I don't know what it relates to. With regard to the lab personnel, I think the best thing to do is keep them to their lab reports and the disclosures that are explanation but not opinion. The concern that the defense has with a lot of the lab personnel is some of the loose language about the ability to testify about other things. And as long as they're kept to those opinions, I think we're informed on most of those. Again, not going through everyone. I do want to talk about Dawson, though. Dawson was an expert that was disclosed in rebuttal, but there was nothing to rebut. He's an expert that talks about toxicology. And we are.
Didn't you produce an expert who said that that there wasn't it would have required two people to commit the crime?
What does that have to do with toxicology?
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. That
Dawson
doesn't.
testimony about the degree of intoxication goes to the what I'm assuming was, given that degree of intoxication, the ability to fight back. In rebuttal to your experts, as I understand it.
I think that's what the state says. I don't think that's proper rebuttal. Well, because we didn't talk about intoxication, because the state's medical examiner talks about defensive wounds anyway. So this would seem to be contradictory with other testimony that they intend to put on. We are not contesting the intoxication level of any of the deceased.
I understand your argument.
Thank you. Again, Your Honor, I think that our exhibit stands on its own, and I just wanted to highlight a few of these. I do want to talk about the cell phone and third-party data, digital data disclosures. We have a little bit more in the way of opinion now, but not full opinion. And the state said that we didn't give them enough to rebut, and that's because we don't know what opinions their experts are going to come up with. They still haven't disclosed full opinions, and so we want to highlight that for the court.
What haven't they disclosed?
Well, in the Barnharts, they said they were going to talk about habit evidence. I don't know what that is. Most of the rest, there were three, Mowry, Urig, and Tanzola, that looked at the digital data and the cell phone data. I don't have any idea what they're going to talk about, except Urig is going to say that there's no connection between Mr. Kohberger and the others. That's the only actual opinion that's been disclosed. And that the last one I wanted to highlight for the court is the Douglas, Special Agent Douglas's testimony. That seems to have shifted a bit from he's going to talk about bank records and debit purchases, and it's become bigger without any opinion. I don't know what his opinion about anything will be. That needs to be limited. I think he can come in and talk
Through the financial records and say, this shows a transaction with Mr. Kohberger's credit card to purchase a Amazon gift card, and that this Amazon gift card was used to purchase a knife.
if he can say all of those things. I think that his ability to talk about receiving the bank record and looking at it and saw a purchase history, I think that's fine. But to provide an opinion about what that means, that's not disclosed. Well, Your Honor, I don't want to wait to find out. I'm asking the court to.
My point is this, I'm not in a position to exclude their testimony because they haven't shown me that they're offering something beyond what they've disclosed.
Your Honor, I respectfully believe that the court is in a position to limit what hasn't been disclosed and would ask the court to do so. The state has had a lot of time to provide these disclosures to us. And what they've done is taken the advantage of having our disclosures and bit by bit giving them to us. This is challenging to prepare a case of this magnitude in any event. And to have things piecemealed out just delays our preparation time. And it's also in violation of the discovery rules. It's in violation of the court's order, and it violates Mr. Kohberger's rights to a fair trial, effective assistance of counsel, and due process. And it is within the court's realm to say, you're not going to do any more after this particular date. There's no opinion written down for certain people. It can't be offered now. And we think that's what the court should do. If we wait until we take it as it comes during trial, that's better than nothing, but it's very difficult to prepare, and it eats into what limited time we have to prepare, and it will waste a lot of jury time to have to take these things up again and again and again. The state knew what their duties were. They've done this for a long time, and they chose this course of action, and the court should limit what they can do and issue an order limiting their experts.
You're saying they're not offering it, so I'm not going to tell them they can't offer it even though they haven't disclosed it, which doesn't make any sense.
Defendant makes a lot of assumptions about what has occurred. However, I can tell you the state didn't wait to see what the defendant was going to disclose first. That would be an incredibly risky game for us to play. And that's not what happened. We know what happened. As laid out in the state's response, the state filed our initial disclosures on December 18th, 2024, disclosing 25 experts for the guilt phase. And then at our last hearing on January 23rd, the court addressed this issue. And Your Honor stated and issued a word of caution, instructing the parties that the disclosure should cover over disclose. We should really go back to our experts, lay out, and you talked about the amount of work that this would take well in advance of trial to go through everything that they intend to testify to and put that into a disclosure. And that it doesn't go as far as the civil rules, but that you didn't want to have these issues coming up at trial. You were very clear in that you directed to the state that our work was not done. We took that to heart. You did not set a specific deadline, but instead instructed both the parties that supplements would be reasonably allowed. In response, we did immediately go back. We went back to all of our 25 experts and asked them to review their testimony. We had to have several meetings to discuss what their testimony was going to be, and they supplemented their disclosures. On March 3rd and March 14th, the state filed the supplemental expert disclosures. I submit to you that the state has complied with Rule 16. We have a continuing duty to supplement. The defendant has filed expert disclosures past their deadline. The state has allowed that. We are trying to be reasonable in this.
Sure,
and
you
in
were.
fact, in that stipulation to allow them more time to disclose, we stated it serves the interest of the parties and the court for there to be reasonable flexibility to facilitate the development and exchange of relevant information to assist the trial jury. That's where we're at, and that's what we're asking for. Thank you.
So submit it's not
If we
reasonable.
were talking about one expert of the states, that might make sense. We're talking about wholesale not complying with Rule 16 and with the rules of evidence regarding experts. When we realized that the state hadn't complied with the rule and provided us very little in the way of understanding how their experts would frame the issues in the case, we sought an extension to prevent the state from having our work first so that we could try to respond to what their expert disclosures were with our experts. That wasn't something that was given to us. That was denied. So we filed our expert reports. For us to have a couple of experts that came later when the state has done their job as they've done their job, that is really a hollow way to say they did it so we can too. The state did not comply with Rule 16 or with the court's order, and the court should limit what they're allowed to produce at trial.
All right, I'll take that matter under advisement. I want to,
Of course.
I did invite the parties to supplement. It takes time to supplement. I'll
3
look through
months?
to see if there's any significant new additions. Well, first, I'll look to see if there's, what is given is adequate. If there are concerns. Secondly, if there's anything that was provided that wasn't shaping and as I've said, making more fulsome, making more whole, making more clear what opinions there are. The defense I know was given, and as I explained, the defense has the ability to supplement as well in response to the state's supplementation. Part of the reason the discovery order is as early as it is to the trial date in this case is because in my experience in cases of this, we have this problem always of ongoing continual supplementation and disclosure. And And so I wanted to accommodate that within the time frame within the several weeks to months in advance of trial. And so I'll look at it and I'll get you an opinion. All right. Amazon click activity.
Judge, this issue really ties into what we've just been discussing and I think is illustrative of the problem. So when motions in limine were due, we had notified the court that we didn't have expert disclosures on opinions on Shane Cox, who was going to be their Amazon expert, and Michael Douglas, who they had listed also as having information about Amazon. So when we raised the issue with the court about incomplete disclosures, like Ms. Taylor was talking about, we still didn't have those at the time that it was time to file a motion in limine. So our motions in limine. So the motion in limine related to Amazon Click and Amazon Records has to do with a lack of disclosure. When we filed the motion in limine on Amazon Records, we then got supplemental disclosures on Shane Cox and Agent Douglas, but not with any opinions.
Are they expert opinions or witnesses, or are they just fact witnesses to say, here's what the Amazon records show?
Well, I'm going to explain why it falls under expert opinion and what we've come to learn in trying to figure out what this data is. And I'll
There
talk.
might be some rebuttal stuff in there based on your disclosures in terms of why.
What does the
Amazon
data mean,
as I understand
Judge?
it,
And how is the jury to know
saying
that?
shouldn't be relied upon or admissible because AI made me do it.
Well, I think it's a broader explanation than that. But the
Understanding the
issue is
fact,
that we had
they require
received
experts.
this data and without expert opinions to explain what the state intended to do with it, it left us in a spot of trying to figure that out.
How was it vague what they were trying to do with the Amazon records? It was pretty facially evident what the relevance of those.
They're not facially evident, Judge. We have an Excel file that has a ton of names with metadata, and then we have what is known as an Amazon click packet that the state has produced, we think from Shane Cox, that has a sheet that talks about specific purchases that include the knife, include things like the gift card that you were just talking about, but without any context. And our hope was that with expert disclosures, we would understand, was there going to be testimony from them that somehow there was information on computer searches specifically from computer examination, or the context of what metadata might explain about the ClickPay documents that they got. We now have some information because we have got an Amazon expert who has explained to us what we have and what we are missing. Obviously, the evidence is important to the state's case related to the Amazon information. And given the court's direction about its intention for us to call experts today, which Mr. Howell is available, we went ahead and submitted a declaration when the court said that you were disinclined to allow testimony, and we sought leave, but we didn't get a solid answer. So you've now got an affidavit in front of you, declaration.
Typically in motions in limine, I'm not being in a position to make factual credibility findings and the like. And so the testimony on paper is more than adequate to guide the court.
Okay, I appreciate that. So I'm going to explain then what the basis is for where we're at. The other issue that of course the court knows is that we sought to seek suppression of the Amazon records because the warrants were extremely broad. We expected to be getting significant data or have data that we hadn't yet reviewed. The court denied that suppression issue. And so what we know that we have now is the list that I explained, but it's without metadata. And so for the purposes of what we've got going on here, there is, pursuant to Rule 106, a whole level of context that's really important to the Amazon data. And it's not just AI technology. It has to do with machine learning. And I think a lot of this is something that pardon?
Isn't that AI, machine learning?
No, Judge, it's not.
I think that machine learning,
No,
I'm
educate
definitely
yourself.
not an expert on this, Judge, but
Machine
I've
learning is the
provided you
AI
with
teaching
a
itself how to
declaration.
learn.
And if you want me to put Mr. Howell on to testify about
That's
the
not
difference
important.
between, he's far more articulate at it than I am. It's a combination of both with what happens with Amazon, because in terms of machine learning, one component is that when there's a household account where there's multiple users with multiple cell phones and multiple laptops going into purchases, there's machine learning and cross references there. In terms of the way that Amazon works as a company globally and artificial intelligence, they're doing all kinds of things to understand what consumers and purchasers and sellers are trying to do to actually prompt people to buy certain things. So in this instance, with regard to these purchases, we have very limited data regarding Mr. Kohberger's purchases without the metadata and the context. And that's the reason that we are seeking to exclude it. Now,
Well, you got
Pardon?
what they got, right?
not really, because what we have is we know that they're going to draw conclusions and that they're going to draw conclusions about intent. But the way that they've presented it to us in data is that this relates to Amazon clicks. Well, Amazon clicks makes it sound like to me and you, someone goes on and actually, with a mouse, clicks, opens a document, takes it into a cart, purchase it, and it's a much broader term than that.
And the state's testimony from their person who will testify that this is what the Amazon data shows, is that Amazon data shows that
So we're back to it
Mr.
being
Kohberger,
expert
at
now?
least
Are we on
his
the same page
name,
about that?
purchased the knife sheath
facts?
and cleaning thing, a knife sharpening, equipment. And looked as anybody who orders on Amazon does, where's it at in delivery? And then later on that same account, after the homicides, looked at knives again. Now, I understand the defense's position and evidence and expert to be that, well, it's a shared account and anybody could have done that on that shared account. I don't know that that's a matter of exclusion, though. Isn't that a matter of just impeachment and cross-examination and your own experts?
They're explaining why.
That if the
data
court doesn't
matters.
exclude it, then that would be the remedy and the approach that we
Would
would
it ever
take.
be the remedy of exclusion?
Judge, if you don't exclude it, then that would be the alternative, I
What
guess.
basis would I have to exclude it?
I started with that we did not have expert opinions at the time when we had to file a motion in limine regarding this data. And it's misleading that the way that you just portray it, that because there is a purchase in a household account, that is automatically attributable to him, and that there's somehow
Purchase in a
intent.
household account. It's attributable under his particular name in the account, as I understand it. Now, could somebody else in the family get to it? I don't know. I suppose your expert will tell us that. But I'm not sure how that is excluded, and I'm not sure how that's expert testimony. I understand you have an expert to say, well, all these other factors come
Is
into
the jury
play and all these
supposed to
other things
just
could
look
have
at the
happened.
Amazon
Okay.
raw data?
You can
and
put that
interpret
on,
it?
but I'm not sure
Of
why
course
that
not.
excludes the state's.
That's why it's
Evidence.
expert.
Well, it would be extremely misleading given the declaration that we've put before the court about everything that goes into the way that Amazon
You're
functions.
asking me to be the fact finder again. I mean,
I'm not asking you to be the fact finder. I'm telling you that when we don't have complete disclosures and we're playing a guessing game of what this information means, and we have deadlines where we have to file motions, then we end up in this circular situation right now. Right? Because we had to file a motion about this without knowing what the opinions are and what we're lacking in data. Now I have an expert who's explaining it. We've asked you to exclude it. You're indicating you don't think it's an expert opinion. And so then the next logical step would be our expert comes in and we're allowed to confront the evidence. But you also just proffered that, that based on the information that you understand, that equates to a purchase. And I've put a declaration in front of you from an expert that says that Amazon doesn't work exactly that way. And that's the problem, that when it is represented as a click, that indicates to the average person that he sat at a desk and clicked and made a purchase when there's a lot more to them.
and maybe I'm completely out to lunch, but as I understand it, to buy something on Amazon, you got to put it in your shopping cart and hit purchase. Am I wrong about that?
That is a step, but how it gets in your cart and what items get in your cart really has to do with the whole model and the ecosystem of the way that Amazon works. Right. And so the state wants to apply in an argument, they will apply intent to purchase a K-bar to get to November 13th, 2022.
The evidence to argue at closing arguments.
But we still have to have testimony that explains those things in between.
Welcome to put on testimony that implies that Mr. Kohberger was not the one that hit purchase, or that he purchased it for a benign event, or that here's the knife, I have it. I don't know.
And based on what you're saying, that the Mr. Cox you think is a lay witness, then I'm assuming that also extends to him not being able to testify beyond what the disclosure is as a lay witness. No other opinions, and including Agent Douglas, who's given us no opinions whatsoever.
I don't know what they're going to say beyond that. And if they say something beyond that that is an expert opinion that hasn't been disclosed, then the state's going to have a problem with it.
Okay. That's why we're having these arguments, Judge. They take a lot of work. It takes a lot of energy. It keeps us from 68 terabytes of evidence. Well, if everybody would just disclose, we wouldn't be having this back and forth.
The problem is you view it as a more complex issue than the state does.
Because it is.
Well, that's not their worldview. Okay. And that's the factual dispute that the jury gets to decide.
Are you resolving the fact of that now, whether it's
so what we're trying to do is make sure that their myopic worldview is what they're held to, because there is a much bigger picture to this evidence. Okay.
She's pissed. I knew this was going to be Ms. Jennings.
Judge, this is pretty simple.
He purchased a knife.
Shane Cox and Mike Douglas, since he gets brought up, they're fact witnesses. They're not going to have opinions. They review records. They're going to testify to what those records show. Shane Cox's testimony is laid out in the supplemental amended disclosure. This is exactly what he's going to testify to. And what he's going to say, he's very careful in what he says that he's going to say. That's what we're anticipating. There is no grounds to exclude his testimony. We applied for and we were granted a search warrant for Bryan Kohberger's Amazon.com user activity. The search warrant was narrow in scope to items related to the homicide and evidence related to the seizing of knives. In this case, it was knives and knife accessories. It directed law enforcement to see certain items: his customer click activity pertaining to knives and accessories, his payment methods used, details of items in cart, including all items added to the cart or removed from the cart or wish listed or in a shopping basket, all suggestions made to the account, all records regarding reviews by other Amazon users, advertising data, devices used to connect to the account, and all accounts linked to the account. The state requested the data between limited time periods, March 20th to March 30th, and November 1st to December 6th. Those were the relevant time periods. And in response, we got responsive data, and that's what we plan on presenting to the jury. Amazon's use of AI is not a basis to exclude, and it's completely irrelevant. AI doesn't click on things for a user. There are no legal grounds to exclude this. We ask that you deny their motion. Thank you.
Thank you. So I think there's a fundamental, just different worldview as to the relevance and impact of the Amazon data. And the defense is entitled to challenge the data in terms of, does it really show who bought it?
I think it's with what experts are.
What else did they buy? In what circumstances? I understand the state's not really going down that apart from what the data shows, which is the purchases that have been laid out in the report. If the state tries to go beyond that without having disclosed those, or without a rebuttal disclosure to some of the things the defense has disclosed on that, then they're not going to be allowed to testify to it. But there's not a ground for exclusion because you have an expert that thinks that the evidence can be explained in a different way. That's just simply a fact determination for the jury based upon the conflicting evidence. All right, let's take 10 minutes and then we'll see if we can't bring this home.
Okay, here's the thing, guys. Here's the thing. He's really having it both ways with, are they expert or are they lay? The question is their testimony necessary to explain these records? If the jury can just look at the records themselves and make that determination, they can see, oh, here's the purchase and it's Bryan's. And he did it on this date. And, it was delivered on this date, etc. They don't need somebody to testify to interpret the data to tell them that. They need somebody to interpret the data and tell them that when it is not just an obvious fact that somebody can look at the record and ascertain for themselves. If that's all it was, it would be another one of these self-authenticating records. That's all that they would need. It's on the list. It's on the list of their self-authenticating records. It's because they are not facially obvious that you need somebody with special training and expertise, knowledge about what these records mean, that they're going to then tell the jury what they mean. The jury can see for themselves what they say. So that's why it's expert testimony and not lay testimony. That's how I understand it. They're not here to just read out what the records say. They're there to tell the jury what they mean. That requires an interpretive step, and it requires special knowledge that the jury doesn't have. They can't just do it for themselves by looking at the records with their own eyes. So that's why it's an expert witness issue, and it is not just a fact issue. Does that make sense? Seems very, very straightforward to me. But the judge is very, very slippery. He's very slippery and really moves the goalposts. Because, yeah, if they're just lay witnesses, they shouldn't be able to offer opinions about it at all. The documents should speak for themselves, and that should be the end of it. Do we think that's going to be the standard that gets applied at trial? I'd be kind of surprised if it is. If these witnesses can just get up there and read the Amazon records, why would we need two of them to do that? Why would we need that? We wouldn't need that. So it's not going to be the same standard when we get to trial. Oh, that was pretty aggravating. Let's backtrack. Let's backtrack. I didn't really take issue with the position on the alibi. I think that's pretty straightforward. Yeah, of course, somebody has to testify if there's going to be evidence about where Bryan was at 4:30 a.m. Somebody with personal knowledge of that has to testify to it. And if they haven't disclosed another witness with personal knowledge of it, it's got to be Bryan. If it can't be ascertained from the phone data, such that an expert would be able to do it, then it's going to have to be Bryan. I mean, gosh, we've done a lot since lunch already. Oh, the bushy eyebrows, the shower selfie. He's going to take that one under advisement. He's going to allow it. He's going to allow it. We can already see from all of his comments. We know that. He's going to allow it, and he's going to say, you can cross-examine, and you can bring up all the inconsistencies, and you can bring in an expert to testify about the memory problems and suggestion and confabulation and all of that stuff. You can do all that to undermine the bushy eyebrows, but he's absolutely going to let her say bushy eyebrows. I don't think there's any question about that. So I don't know why we're taking this one in particular under advisement, but we are. 911 call, I think he's doing the appropriate thing by looking at the statements individually. There are multiple statements by multiple people. If this was just one person making a phone call, like, probably most 911 phone calls are, and not as a bunch of people all passing the phone back and forth to each other, then it might make more sense to evaluate it just as a singular kind of comprehensive statement. But it's not. It's a lot of people making different statements for different reasons with different bases of knowledge and so forth. So I do think that that's important. The more I hear about the 911 call and what was going on the night before and what was happening in the morning, it's like I get more questions instead of fewer. I get more questions instead of fewer. Now somebody saw Xana on the floor. Did I hear that correctly? Somebody saw Xana on the floor. When did somebody see Xana on the floor? I am going to have to assume it was in the dark, because otherwise, why did we think Xana was it not obvious that Xana was dead? Given how this crime has been described, that just seems unlikely. And now I've heard somebody went upstairs and saw Xana and thought, there's a problem, you should call 911. How did that happen? And your call to 911 is still, she's passed out. I just am having a lot of time. I'm having a lot of difficulty squaring all this. Now, let's please bear in mind, I am somebody who will give pretty much every benefit of the doubt to people who are in stressful situations. I don't expect them to be reliable. I don't expect them to accurately perceive things. I don't expect them to accurately report things. But I'm going to want to hear an explanation. What did you see that caused you alarm, but still left us with she's passed out and not waking up? I'm going to need to hear more about this. Obviously, we already know there's a lot of activity going on with communications and so forth. We're only going to get so much detail about that right now. I have to assume we're going to get more detail at trial. There's a reason why Anne is specifically calling out. I mean, I think why she's specifically calling out creating a new contact and working with pictures, doing all these things with pictures. Why? What contact? What pictures? I don't know if this is just to show. It's to try to show, well, the activity was kind of casual and normal. It doesn't reflect, oh, I just got stressed out by something that scared me, that I made a bunch of excited utterances about. Again, I think that didn't get clearly communicated. No, the later stuff doesn't change the nature of what happened before. The later stuff is simply evidence as to what the nature of the thing that happened before really was. It makes it more or less likely that they were actually excited when those things happened based on their pattern of behavior. That's how I understood kind of what the general gist is of what the defense was getting at. But they didn't really, I don't think, made that clear. A battle of the dollhouses. Really? Really? We're going to have a battle of the dollhouses, apparently. And we still don't know why. Why did the state decide, I guess we don't need to do this to scale at all. We can just sort of slap a sort of general thing together. If you're going to the trouble to build it and the expense to build it, why are you not doing it accurately? I mean, in many ways, it seems like it would be easier to do it to scale because you have all these scans and stuff that are going to give you a blueprint, and you don't have to make it up. You can just rely on what you already know the design is. So this is very, very strange to me. Do they think that question's not going to get asked at trial? I mean, they probably won't, if they don't know the answer, of course they won't ask it, but they're going to point out you could have done it to scale and you didn't. It would have been more accurate had you done it to scale, would have been more helpful to the jury if we were sure that it was accurate, but you chose not to do those things. That's how that cross-examination is going to happen. So I don't know why you wouldn't just make it to scale. So it's opening up an opportunity for a defense argument that you're trying to be misleading, that you didn't have to do. That's an own goal. You don't have to give them that kind of argument. Just make the model accurate. And then none of this is an issue. I did very much like Ann Taylor's response when Judge Hippler said, oh, well, it's no different from sketching a diagram in court. She says, yeah, for confrontation purposes, it is, because I'm watching it happen. I'm seeing how it's being done. And that's the entire point that the defense is making on this, is they don't know what sorts of decisions are being made with respect to, does this align with the scan at all? Are they even using the scan? Are they just eyeballing it? We don't know. It's going to come in and it's going to look real fancy. And because it's going to look real fancy, it's going to naturally lead to an assumption, oh, this was made very carefully. It's probably really good. That's what they're getting at. The jury is going to give this a lot of weight because it looks more significant than it is. So yeah, if you knew it was to scale, that's going to solve a lot of that issue when it comes to confronting the witnesses about how this was made, how accurate it is, what you relied on, why you chose to do it this way. So we get a battle of the dollhouses. You can make your own dollhouse. He literally said you can make your own dollhouse. You know, I was never really that, I wasn't somebody who was really alarmed about the decision to demolish the house. I kind of already figured that the evidentiary value of the actual house is pretty much gone. You know, it's had so many people go through it. The condition has been so changed. Almost certainly anything that there is a value to be gotten out of it has already been gotten. And as long as they have this type of information to be able to recreate it, it's not really a big deal. But now what? Now we're just going to disregard all that anyway. It's wild. It's just wild. So yeah, Battle of the Dollhouses. We're going to have you know, a trial of the dollhouse now on top of everything else that's really going to be at stake here. I don't really, like I said, take issue with what he said about the alibi. I think everybody's kind of really on the same page about it. Cy Ray is going to get to testify about the general morning stuff that's been disclosed. But there's nobody with personal knowledge that he was at Wawawi Park except him. So yeah, it's going to have to be him to testify to that. I don't think that's a particularly a problem. Now, Mr. Ray's conspiracy theory. Well, the battle lines have been drawn there, haven't they? Because what Mr. Ray did is basically dared the court to look at what's there, to take an interest in it, to be concerned about it. And the court said, nah, not going to do that. Now I understand exactly why. I do. The 7-day issue, it's a problem. And I know I saw a lot of people in the chat. I think I might have even starred one. Yeah, I did. I starred one. The 7 days doesn't apply to Nick Balance calling AT&T directly. We don't have a record to tell us whether it does or not. We don't know because it hasn't been submitted in court. That's how we need a record to be able to establish that. And all we needed to do was have it in Cy Ray's affidavit, if that's the case, that judge, the 7 days doesn't apply. That's all they needed to do. But they didn't do that. And that's why Judge is pointing out that silence is really telling. And I can't disagree with him. It is a problem. And judging by how Ann Taylor was handling that in those questions, it kind of does sound like they're conceding. She's like, this is new information to me. Well, you could have argued that, pointed out that the reason why we are suspicious of this information that we're being provided by the state and by the state's agents is because it keeps changing. Nobody said way back when this first came up, there was a 7-day time limit. In fact, the first explanation that was given was you couldn't get any of this until 2023. When defendants change their stories, witnesses change their stories, they call that consciousness of guilt. And they point out, oh, it goes to credibility, and you can't trust anything they say, and trying to hide something. When the state changes their story, I guess we're supposed to just overlook that.
All right, we are now at the state's motion regarding neuropsychological and psychiatric evidence, as well as then closely followed by the defense's motion with respect to autism spectrum disorder.
Thank you, Your Honor. I hate to sound like a broken record, but once again, this seems to be a developing issue. The basis for our motion when we first filed it was in response to the defendant's supplemental responses on experts, the declarations of Dr. Orr and Dr. Ryan. Each of those talk about mental condition. And each of their disclosures, right on the first page, said that this evidence is not intended as mental element defenses under 18-207. So our response was, well, then it's not admissible. It's just very simple. The statute covers that. What happened after that is that it morphed now into a new position from the defendant that there are neurobiological and physical conditions that are come into play. Not to the exclusion of the mental conditions that were alleged before, but Dr. Lewin talks about the physical conditions are predominant as opposed to exclusive. So that kind of brings us to where we are for the issues for today, and I'll try to be as succinct as I can. The first issue, what was initially raised by the defense, is they expressed concern about how the defendant's demeanor is going to present to the jury as the defendant is just sitting in the courtroom at counsel table like he is right now, and assert that they should be able to offer evidence that the defendant has autism and these other disorders that make him appear, I guess, arguably in like he's not involved or something in a negative fashion.
And you have a problem with that
the defendant
because
cites no authority
the
for
jury
this.
should draw
Indeed,
that inference?
I'm not aware of any authority. We can't find any authority to say that the defense can come in and even before jury selection say, okay, ladies and gentlemen of the prospective jury, here's this expert testimony that our defendant has this developmental condition, this autism condition, and so he might appear different in court. And so please don't hold that against him. There's just simply no basis for that. And we looked for that. It's irrelevant to any of the factual issues in this case. It's irrelevant to the elements of the offense. Frankly, all it does is confuse and try to play the sympathies of the jury, which is exactly what Rule 403 would prohibit. And we cited to the Schuler case where it talked about in the context of prosecutorial misconduct, it talked about the defendant's courtroom behavior off the witness stand is irrelevant. I think it stands for that. The defense argues that the Samuel case expands all of 18-207 to include mental conditions that don't directly relate to an element. And that's simply a misreading of the case. Samuel dealt only with subsection 4, which deals with the state's ability or right to request independent examinations. And the Supreme Court said that applies to any mental condition evidence the defendant opens up. It doesn't change the first sections of 207, which limit the defendant from presenting mental condition evidence.
Is the stream getting glitchy or is my Wi-Fi getting glitchy? See what's going on here. Looks like it might be my Wi-Fi, guys. I believe it's my Wi-Fi. Mm. Okay. Are we back? Sorry, guys. My Wi-Fi was disconnected, but I got it reconnected. So I don't think it's that. I think it just booted us off. And now we're going to buffer. Yep, this is the joy of having a new stream system. Is this stream now past the capacity of the court's new website? I don't know. Maybe. Well, guess we'll give it a minute here to wait. Here's the thing. Mr. Thompson seems to be, taking grave offense at this idea that the jury, shouldn't be evaluating Mr. Kohberger and his demeanor in the courtroom. And that's kind of the whole point of presenting this evidence, is to point out, hey, you shouldn't draw any conclusions about Mr. Kohberger based on how he's behaving in the courtroom, because it doesn't mean anything. And you actually probably shouldn't make those assumptions in general. So there's no authority to do it. Well, you don't have to have a case. You don't have to have a case for every single thing that you ever want to do during a trial. I bet you don't have a case that says you can bring on some guy from Amazon to testify as a fact witness about purchase records when he's got to interpret them to explain them to the jury and tell them what they mean, instead of just sponsoring them or just admitting them as a self-authenticating record. I'll bet you don't have a case that says that either, do you? Not every single unique situation that comes up in a case gets litigated and produces case law. So this you don't have authority to do it. It's not particularly persuasive to me. Is there a reason to do it? Would it be helpful to the jury? Yes, it would. It would help them follow that instruction if they're going to be instructed not to take his demeanor and so forth into account, which I kind of don't think they are. All right, I'm going to try refreshing because I'm hearing it's working now. Still not working for me. No, I'm just getting a frame by frame now of what's happening. Let me try something else here. Yeah, I'm still not getting it to play. So let me try this again. Make sure my own internet is connected. Guys, I have been refreshing the whole page. Okay, I should be connected. I cannot get it to play. Okay. It almost did. I did, guys, try opening a new page. What I'm getting is that it will play for like a second and then it will freeze. So, do y'all really want me to shut everything down and try it again? I can definitely try that. I guess as long as Jeff is still here, it won't kill the stream. So let me give it one more shot here to see if I can just get it to load with a new window. No, but I am going to share just because it's particularly funny. Look at Judge Hippler. Just look at him when I get him up. Look at this. Look at this. I mean, that's a little crazy. Okay. Law and crime is having it work. So we're just going to switch over to law and crime. Let me get that up. Let me get us back to where we are with Mr. Thompson. We'll just start over kind of in the middle of his. I'm going to get us sped up a little bit so that we can catch up. And now let me get it shared. Okay.
Counsel table like he is right now, and assert that they should be able to offer evidence that the defendant has autism and these other disorders that make him appear, I guess, arguably in like he's not involved or something in a negative fashion. The defendant cites no authority for this, and indeed, I'm not aware of any authority. We can't find any authority to say that the defense can come in and even before jury selection say, okay, ladies and gentlemen of the prospective jury, here's this expert testimony that our defendant has this developmental condition, this autism condition, and so he might appear different in court. And so please don't hold that against him. And there's just simply no basis for that. And we looked for that. It's irrelevant to any of the factual issues in this case. It's irrelevant to the elements of the offense. Frankly, all it does is confuse and try to play the sympathies of the jury, which is exactly what Rule 403 would prohibit. And we cited the Schuler case where it talked about in the context of prosecutorial misconduct, it talked about the defendant's courtroom behavior off the witness stand is irrelevant. I think it stands for that. The defense argues that the Samuel case expands all of 18-207 to include mental conditions that don't directly relate to an element. And that's simply a misreading of the case. Samuel dealt only with subsection 4, which deals with the state's ability to right to request independent examinations. And the Supreme Court said that applies to any mental condition evidence the defendant opens up. It doesn't change the first sections of 207, which limit the defendant from presenting mental condition evidence.
Oh no, on crime is going to get glitchy on me too. Let's not do this. Is this just when it got glitchy on them?
07, and we're
Okay, I think maybe we just missed some
expands
stuff.
Now at the
No.
We are not planning on.
Yeah, this is law and crime messing around. Okay, getting the stream fixed. That's not my sound, right? That's theirs.
With that, at the
Okay.
risk of going into assessing credibility,
We're
so I'll
going
touch
with
this very
this.
quickly, Your Honor, is
We
what we
missed a
already
minute.
have from
It is
defendants
what it
experts,
is.
particularly Dr. Orr, is she talks about the developmental disorder impacts being limited to in the past, page 16 of her declaration. She said the motor problems have not impacted his functioning significantly in many years, page 19. She said she observed the defendant manipulating items effectively during her evaluation, which would be contradictory to what the defendant argues, which is not in Dr. Lewin's report. The defendant argues that he's physically incapable of committing these crimes.
Are you asking the
whatever
judge to be a
extent,
fact finder, Mr. Thompson?
That is irrelevant. We
Shouldn't
submit
you just
on the issue of guilt.
present your own expert?
It's appears to us that what Dr. Lewin has to offer largely relates to the penalty phase. Indeed, he wasn't disclosed as an expert, and we aren't going to play hardball with these deadlines, but his disclosures came out as we were moving into the disclosure for penalty phase experts, not guilt phase experts. So the state's position is twofold here. First, we'd ask that the court enter order prohibiting the defendant from offering evidence about trying to explain the defendant's demeanor in court when he's not on the witness stand. It's irrelevant, it's immaterial, it's certainly prejudicial, it's going to confuse the jury, it invites appealing to the jury's sympathies. And then the second thing is we'd ask on this issue of the motor skills that the court simply reserve a decision on that until the door is opened and we have specific things that the defendant's experts might wish to rebut, whether through experts or through cross-examination. So that's the state's position, Your Honor. Thank you.
Judge, the court should consider as an offer of proof on, as it relates to this issue, the initial expert report that was provided in the fact phase of Dr. Orr and Dr. Bryan, and Dr. Lewine's report was attached to our reply for the basis of substantiating that our argument is that this is a neurological, biological disability. We are not taking the position that this is a mental condition. Clearly in the state of Idaho, one of the guiding cases regarding mental condition.
Is there an inconsistency there? Because it seems like on the one hand, you're arguing that his autism spectrum condition shouldn't be used as an aggravator as a mental health condition. I mean, yeah, it shouldn't be used as an aggravator as a mental health condition. On the other hand, you're arguing is not a mental health condition under 207.
So I think that it's really important. I know that you group these two arguments together. This issue that I'm talking about right now has to do with the fact phase, the guilt phase of the trial. Everything related to aggravator is at a different phase.
Are you taking the position that it's a mental health condition as it relates to aggravation and not a mental health condition as it relates to guilt phase?
I don't think we've said anything about it being a mental condition as it falls under, 18207. We're talking about this being a neurological, biological disability. My understanding, just so that we're really clear about what constitutes mental condition in court on a mental health condition, is the Diaz case, which is pretty extensive about what you're talking about. That's not what we're talking about here. We're talking about a neurological disability that has to do with his brain and is a biological condition. The reason that this is important in the fact phase, there are a couple of reasons. But as we talked about with earlier about the juries judging him, the minute he is sitting in a courtroom and the first time that a jury starts to look at him, they are going to be evaluating his physical presence. They will be judging his facial expressions, his posture, his movements, his interactions with counsel, his responses to evidence that is up on the screen, his responses to emotional testimony, and his eyes. The jury will be studying literally everything about him. We must, as his attorneys, be able to tell the jury in opening statement that he has autism spectrum disorder and that they will hear testimony that it is a neurological and physical condition or a developmental disorder. Studies show that jurors pass judgment on the physical presentation of the accused. One study in particular related to autism was in 2018 by Katie Morass, Imogene Marshall, and Chloe Sands. They did a mock jury study of 160 jurors, and half of the jurors were told about the accused autism spectrum disorder and the other half were not. And what the study found is that when the jurors understood what autism spectrum disorder was, they were inclined to be less judgmental regarding the physical presence of the accused. While first impressions of autistic adults are less favorable, studies like the one that I just referenced show that informing of observers of the ASD diagnosis results in significantly more favorable consideration. There are several cases for guidance to this court. State versus Spur, 921 AD 1335, a New Jersey court from 2007. The conviction was reversed and a new trial was ordered in a murder case. The court held the evidence would have educated the jury about oddities in behavior that defendant might exhibit in court or were described in the testimony of witnesses. The testimony is equally relevant to defendant's effort to have the jury understand any unusual demeanor or mannerisms he may have as a result of ASD and to explain his asserted shortcomings in perceiving and reacting to basic interpersonal cues when engaging in social interactions. He must be permitted the opportunity to present at trial evidence that tends to prove that he has a medical basis for such behaviors in order to explain himself and his condition and thereby to lessen the chance of being misunderstood by the jury. Another case out of Missouri, State versus Boyd, 2004. A Missouri case was reversed on appeal with the exclusion of expert testimony about autism. There were many similar issues as the case here, and it actually was also a stabbing case. The appellate court that the failure to allow expert testimony at trial had a prejudicial impact on the outcome of the trial. There were issues of clumsiness, awkwardness, and motor skills. Another example, State versus Suber, a 2008 Minnesota case. In an unpublished opinion, the Court of Appeals overturned a DUI conviction because the court, who conducted a bench trial, inappropriately weighed the evidence by ignoring expert testimony related to autism. Odd behavior and dexterity problems were at issue. Another case, a Ninth Circuit case, U.S. versus Cottrell, 2009, was not published in West Federal Reporter. It's a California case. A conviction for aiding and abetting arson was overturned because the court excluded expert testimony related to autism on the issue of specific intent. The court held it was an abuse of discretion to exclude the evidence. There's also a brand new law review article out of the University of Alabama, March 4th, 2025, by Jenna Hayes, published, called Autism, Culpability, and Sentencing. It was just recently presented at the American Psychological Law Society conference, and it addresses many issues related to autism spectrum disorder in the criminal justice system with strong recommendations that expert testimony at trial is critical. The jury needs to know from the very outset that they will hear testimony about Mr. Kohberger's autism spectrum disorder generally and how his physical presentation in the courtroom should be considered. For example, aside from his flat affect, piercing stare, stiffness, holding still, when emotional evidence or picture evidence comes in that a neurotypical person will react to, he will not react. And that is only because he has a physical disability that prevents a neurotypical reaction. It would be unfair for him to be judged for that given his disability, or at the very least, the jury needs to have some understanding of why that may be. As for issues that relate to state of mind, it does depend on what the state offers. We agree with the state on that aspect. If they stay away from the issues regarding cleanliness and a missing shower curtain and speed in which the crime occurred and wearing gloves or showing him at various places wearing gloves with some sort of negative attribute that he is doing that to hide DNA as opposed to what's going on with his autism, it's our position that that opens up the door to the opinions that the experts have expressed. As it relates to...
I didn't understand the reference to speed at which the crime occurred.
Well, there's the state, there's a disclosure by the state of one of their detectives.
I understand the detective's statements, and you have in the report a reference that he has a historic fine motor skill issue, and you have no expert testimony that he would have been incapable of doing this.
I don't know that we would seek to offer an opinion that took it that far into the jury province about no capability to do this. But in terms of his fine motor dexterity issues,
disclosed is a historic issue with some fine motor disabilities, like not being great at tying his shoes.
Well, I disagree that that's all that the expert said. The expert indicates he has problems with dyspraxia and went into great detail about the issues that what she saw with fine motor dexterity as it presents to this day. He did absolutely have those issues as a child, and there are still things that are present in him. And you know, to the extent that that's an issue, the best person to explain that to you is not me, but perhaps a more of an offer of proof beyond this, outside of the presence of the jury. So what you would know the testimony would be that we would offer on that issue, or giving us direction to specifically go get information about that issue that we might try to elicit. But I don't want my representation to you as a non-expert, as a lawyer making this argument, I'm not qualified to tell you what's going on with his exact dexterity issues. He has fine motor skill issues. He presents odd physically, and it is a different presentation with what he's got than someone who might be sitting in a courtroom, perhaps with missing a hand, for example. Another significant issue that is impacted by his ASD is his decision and ability to testify. The Burr case is instructive because part of the basis for the reversal was that Mr. Burr was encouraged not to testify out of fear of how his autism would come across to the jury. Because of his ASD, because of Mr. Kohberger's ASD, decision-making is already very difficult for him. If we cannot let the jury know about Mr. Kohberger's autism, the decision about his testifying will be nearly impossible for him and for us as we guide him. We need to avoid misperceptions of the jurors, and the only way to do that is to inform them. The cases I have referenced discuss how the constitutional right to due process is violated when a jury does not get to take into consideration this specific type of evidence. There's one other way that I want you to think about this, one other frame of mind. Imagine if you do not let this testimony in phase 1 of the trial and the jury convicts Mr. Kohberger. How angry and misled might those jurors feel when they learn in mitigation, where without a doubt this comes in at mitigation, that he has this disorder and it has them second guessing themselves. We must avoid that possibility. We ask for an order to allow its admission. We are not asking for carte blanche ability to lay all of that out in opening statement. This is something where we have no problem, where we take a step-by-step approach, but we've got to be able to tell the jury in opening statement that he has ASD. Thank you.
So what we've just heard from the defendant still begs the question of what's relevant and irrelevant in Idaho. And I think the case law is clear to the extent there is case law that the defendant's appearance when he's not on the stand is not relevant. I think that the court, if it has concerns about that, could add language to the ICSI 202 that talks about the type of evidence the jury can consider, to say the jury may not consider the defendant's demeanor as he is seated in the courtroom if the court feels that's appropriate. I'm not sure it's necessary because 202 specifically lists what jurors can consider, and the defendant's demeanor is not part of that. In response to your Honor's question about, or observation that there's no evidence from an expert here that the defendant is incapable of committing these crimes, the response from the defendant was, well, yeah, that's right, which is exactly our concern, because the defendant in his filings took what little was in the expert disclosures and then stretched it out to this conclusion that the defendant is incapable of committing the crimes when the experts don't say that.
Well, yes, that's
they are
because
essentially
that's
creating
argument,
an opinion
and it's
that
for the
doesn't
jury
exist.
to decide.
So, Your Honor, our request stands. Certainly the evidence that's being proffered about his demeanor is not relevant. It shouldn't be admitted. And if there's an issue that comes up about the defendant on the stand and his appearance there, I think we can address that as it comes up. Likewise, if the state opens the door to questions about the defendant's behaviors, which we are not intending to do, we can address the issue at that time. So we'd ask the court to defer any kind of ruling on those hypothetical situations. Thank you, sir.
You know, if we didn't have 2.5 years of media coverage to know how Mr. Kohberger's physical presence has been perceived, the state might have a little bit more credibility with that argument that it's not relevant. But we have extensive media coverage that refers to him as evil, as an incel, as looking like a monster with very dark eyes. And it's all based on their analysis of him sitting in the courtroom. Pardon?
None of that is an autism spectrum, what you just mentioned.
But his physical presence is what the media has been judging, which is the same thing that a jury is going to do. So my point is that for the state to say that it's not relevant, we actually have in this situation the ability to point you to the fact that that is not true. Because what the media has done, I mean, there are, even before the cameras were cut out of the courtroom, there were all kinds of zooming in and and stories with experts doing body language studying about him, including the fact that this is how he holds his hands And there's details about that. So it's disingenuous to say that he's not going to be judged by his appearance. That is exactly what jurors are doing. They're judging the evidence. They are staring at the accused. They're looking for an accused to be remorseful and emotional at evidence that makes everybody else feel bad. And he is not capable of doing that through no fault of his own. And there is, I just explained to you that there are studies that have been done and there's case law on this, that it's important that the jury be informed.
There's also a case law that says that none of what happens except in the testimony is relevant. So how do I square those two things?
You're
When I
helping
give
the jury
instruction that specifically
understand
says, don't
they should
judge this
not
case based on anything except that
give
you hear on
undue
that
weight
witness
to
stand.
it.
And then if I do this, what you're asking me to do, I'm basically telling them, but that's okay.
Well, the state's asking you to give a jury instruction that says that. We're asking you to let us put
Part of the standard
testimony on.
instruction is that the jury may not consider as evidence anything other than the testimony and exhibits admitted in the trial.
But Judge, I just quoted cases to you where we don't get to live in a state of denial, right? We can pretend, but that's not what exists in society.
I
So
have
we
to live
don't
in
get
a
to live in a
state
state
where
of
the law
denial.
is my concern.
My opinion.
I have to live in a state with what the current state of the law is
And
in
I just,
Idaho.
well, I just gave you
You gave
examples.
me no Idaho cases.
But Judge, you can have the courage to be the first one to set it right here then,
no,
because autism
no.
spectrum disorder
That's it.
is
It's not gonna
very
happen.
real in our society. 1 in 59 people have it.
It's helping the
Four
jury
times more common in males.
follow
I'm
the
not
rules.
in any way trying to downplay the those that may be diagnosed on the spectrum. I'm trying to figure out how do I do this where I have settled legal precedent that I'm supposed to follow that says the jury may not consider as evidence anything other than the testimony at the witness stand. They can't consider, they're not supposed
Because
to
you
consider the
understand they
demeanor
might anyway.
of the witness. Now, I will say, having seen Mr. Kohberger over numerous days now, I haven't seen anything unusual in terms of his demeanor. But, I'm not, scrutinizing him on YouTube the way maybe others are. But I understand your concern, and I'm not trying to downplay it. I'm just trying to understand how I get there in light of the legal requirements that I'm supposed to tell the jury.
You're not
don't
asking
consider
the
any of
jury
that.
to pay
Maybe the way is
attention
to
to it.
say,
You're asking the jury
the way
not
the
to pay
parties
attention to
appear,
it. Here's
what
why.
happens at council table is not evidence. You shouldn't be concerned about it, and it should play no role in your decision. Would that do it?
Judge, the proper way to do this is through testimony. I just went through a litany of cases where that's what the courts have said in other states is
I
the way
haven't
to
read
handle
this.
it.
I don't think those cases were those cited to it.
They're not Idaho cases, no. But then it's an issue of first impression here, right? And so you get to make the decision and you can get it right. You can allow the testimony, right? I mean, if it's an issue of first impression and you're looking for guidance around the United States, then do what other states are doing. That's the solution, not a jury instruction.
I'll take the matter under advisement. The council cited cases that weren't cited in the briefing, so I'll need to look at those.
It's not going to give it to him. That did not go the right way.
Let's talk about the motions to strike the death penalty regarding the same issue.
All right, focusing now to a different phase of the trial and why this should be a grounds to not even let Mr. Kohberger be considered for death. There's too great a risk that constitutionally protected mitigation can be reliably assessed by a jury. The impairments cited by the United States Supreme Court in holding that the death penalty is unconstitutionally reliable for juveniles and people with intellectual disability apply with equal force to people with ASD, and specifically to Mr. Kohberger given his deficits. Courts are expected to apply general legal principles from Supreme Court precedent to new facts. The United States Supreme Court just reiterated this in Andrew versus White, a 2025 decision decided January 21st, 2025. The general legal principle here is that the Eighth Amendment and its requirement of heightened reliability in capital sentencing applies. Unreliability exists when a defendant has an inability to present mitigation evidence, which creates a unacceptable risk of wrongful execution. The 4 impairments in Atkins, which apply here, are A, less able to give meaningful assistance to their counsel; B, demeanor may create an unwarranted impression of lack of remorse for their crimes; C, typically poor witnesses; and D, mitigating evidence of ID can, quote, be a two-edged sword that may enhance the likelihood that the aggravating factor of future dangerousness will be found by the jury. All 4 of these impairments apply to ASD generally, and to Mr. Kohberger in particular. As to less ability to give meaningful assistance, extremely rigid thinking, he perseverates on specific topics, processes information on a piecemeal basis, struggles to plan ahead, and demonstrates little insight into his own behavior and emotions. He may understand the definition of mitigation, but he has no ability to assist us and understand if what might be mitigating and why. The impairments that he has go all the way back to his very young years, where he walked on his tippy toes, rocked on all fours for extended periods of time, could not engage in imaginative play, wrote his 5s upside down and backward. He was provided with extensive supports in school. He was evaluated for ASD, but not properly diagnosed, and bring that to current time where he is at age 28, where he has few personal relationships. He does not have any insight into things like the fact that he once volunteered at the Special Olympics is mitigating, or that he helped save someone's life on the job, and that's mitigating. He can see the logic in the word mitigation, but he has no ability to understand and help us develop a case for him for mercy. His demeanor, he has a limited range of facial expression, odd eye contact, and intense gaze with subtle rocking, sitting very still. This is important because of the impact that jurors assigned and give tremendous weight to perceived remorse or the lack thereof. So again, I'm talking about not phase 1, but if we get to phase 2, this perceived remorse and their decision about the death penalty. As evidenced, as I've explained, by the media demonizing his appearance. As a poor witness, he has difficult picking up on nonverbal cues. Tone and cadence are abnormal. Affect is stiff and language is disorganized, repetitive, and oddly formal. He really struggles with making decisions, such as, like I expressed, the decision to testify. He needs instructions repeated to him. He's easily distracted on what is happening around him, or so focused that he's lost in the big picture. He perseverates on unimportant details, and these are symptoms of his disability that will either unfairly keep him from testifying on his own behalf, or alienate him from a jury and make him easily trapped on cross-examination. And the double-edged sword applies as well, because the stoic affect and incongruent facial expressions may be seen as a lack of remorse, an inability to react to emotional moments that call for emotion, which is often an aggravating factor for juries. Mm-hmm. Studies in our motion related to striking the death on page 22 to 23 cited the bias towards people with ASD. Again, the media coverage has repeatedly described him as soulless and evil. I want to address the issue of national consensus because the state pointed that out. First of all, the national consensus standard is not something that is required if you make an unreliability finding. But even if you determine that a national consensus is required, there is one because of the factors analyzed, in Atkins all apply to ASD as a class of person that society wants to protect. They are the same vulnerabilities. ASD individuals like Mr. Kohberger are labeled protected handicap students, below basic academically, unique thinking and reasoning make intellectual function difficult to summarize, poor fine motor skills, not comfortable speaking or overly verbose, can't make eye contact, require repeated instructions. Those were all specific statements in his school records. The Supreme Court has not established a clear
Doctoral program?
Pardon?
Is that before his doctoral program in terms of his academics?
Yeah, the school records that I'm reporting here were definitely for him as a small child, but I wouldn't say that that there weren't issues that were derived as when he was in undergraduate or his master's degree program. And the other thing that's important is that it's really inappropriate, based on what the experts say, to put more weight on someone's IQ and less weight and make that IQ overcome adaptive function issues. The Supreme Court has not established a clear methodology for determining when a national consensus exists. The court has looked at state legislators, but also medical and psychological research, international standards, and there is a rapidly increasing awareness of ASD across society, including in the legal system, as outlined in our briefing. As a society, there is a consensus to protect this class of persons. And if you don't agree that any of those arguments are convincing, then some court needs to have the courage to be the first to declare a consensus. And that should be you. Thank you.
It won't be. And there really isn't a consensus because prisons are full of people with ASD.
Your Honor, I want to start with the Atkins decision because the U.S. Supreme Court are the experts that this court is bound by. And that court specifically found in Atkins that there were two reasons why the individuals they were contemplating could not be subject to death. And it was sub-average intellectual functioning plus significant limitation in adaptive skills. What the defense is asking is to eliminate that first critical component and look only at adaptive skills. And the defendant's not the first to try that. In Idaho, the Idaho Supreme Court has rejected that argument in Dunlap. Now, it wasn't about ASD, but the argument was the same, that mental illness has some of the same conditions that were talked about in Atkins, and therefore the Eighth Amendment prohibits execution. I would note that the Idaho Supreme Court did not even entertain that argument sufficiently to do a symptom by symptom comparison between the mentally ill and those who were found to be intellectually disabled in Atkins. Instead, the court cited, by my count, 10 other courts that had rejected similar arguments and said, we agree with them. I don't know how you can read Dunlap in any other way than the Idaho Supreme Court has said it does not violate the Eighth Amendment unless and until the U.S. Supreme Court extends it. And they haven't done that, and they still haven't done that. Now, on the national consensus issue, national consensus is a critical part of an evolving standards of decency claim. It's at the very heart of that claim. That's what it means. An evolving standard of decency requires some kind of national consensus. And the critical place you look for that are the actions of state legislatures. Not a single state has said that someone with ASD cannot be executed. They cited to 2 states in their brief to support their claim. Neither of them have laws that preclude this. In fact, their laws, both passed within the last 5 years, did add to the list certain mental illnesses, but they did not add ASD. That means those legislatures considered which mental illnesses should we add to this list and rejected the idea of adding ASD. So that's not the national consensus that the defendant would need for this type of claim. Based on Dunlap and the plain language of Atkins and the complete lack of any kind of national consensus, we would ask this court to deny the motion. Thank you.
Yeah, he's going to deny it.
I addressed the issue of national consensus initially, so I'm not going to repeat why that is something that you don't need to find. But I do want to point you to another resource that is really informative, because what we are asking is that you make this finding on the unreliability principle. And Scott Sunby has an article titled "The True Legacy of Atkins and Roper, the Unreliable Principle and the Unraveling of the Death Penalty." And that explains the court's pathway on how Atkins and Roper is focused really on why society protects people with vulnerabilities and why people with vulnerabilities like ASD cannot properly be reliably mitigated in front of a capital qualified jury. And that's why you should strike the death penalty in this case. Thank you.
Thank you. I'll take the matter under advisement and issue a written opinion. Let's address what I have is to be the last item, which is the motion to strike the death penalty regarding discovery.
Your Honor, we are asking the court to strike the death penalty as well as issue some additional rulings in this case as it relates to the discovery issues. Your Honor, we're asking the court to look at this not as a Brady violation, but as a due process violation. And it's important to understand a little bit more about the discovery to do that. First, I'll start with defense counsel's obligation. In any case, defense counsel has the obligation to meet its constitutional requirements of effective assistance of counsel, and that means that we have a duty to investigate any of the state's claims and review the state's discovery. There's a heightened sense of that responsibility in a capital case. Death is different. That's been said time and time again throughout the United States and state courts as well. So we need to be able to review all of the discovery. We need to meet that obligation, and we cannot. 68 terabytes in our briefing. I won't repeat it all here, but
I don't have a clue of what's in there in some senses, because I don't know how much of that is music, how much of that is
they don't either, Judge.
video in movies of personal
That's the problem.
devices, how much of that is things that no reason to look at.
You always
well,
have
the
to look
problem
at
is,
it.
Your Honor, there is a reason to look at it. There are tons and tons.
Why didn't you bring a motion earlier asking for intervention to have me do other things, and rather waiting to tie it to the death penalty at the end?
I'd say that's a bit of a mischaracterization of what's happened.
The first time we met, you told me about having received the state's discovery and the number of terabytes. And the first question I asked you was, have you looked at it? And you said, no, you hadn't yet looked at it. And we talked about the trial date, and I moved the trial date back a little bit for that. And I haven't heard a word since then that you haven't had enough opportunity to review the discovery or to do the discovery.
Well, I'm here to
Well,
tell
more
you
now.
now that we haven't reviewed all of the discovery. Over the course of the case, there have been multiple emails and letters back and forth with counsel about discovery. We've had motions to compel discovery. When I first met you, I was very candid with you about the size of discovery and that our team had not looked at it all. Since that time, we've continued to receive additional discovery. And probably most importantly, that brings us to now, why now? I think that's a fair question. Since we began with the expert disclosures, and I'm not going to go all the way back through that. I talked about that exhaustively, but that was a real turning point for us, that when you're moving along with a schedule and a pace, and in this case, especially with the sizable amount of discovery, and I want to tell you what's in there in just a second too, but we're moving along at a specific pace, and the expert disclosures, we've talked a lot about that, and those were not adequate. The court told the state to do a better job. We've talked exhaustively about that, but that disrupts the flow of everything that we're doing when that happens. We had worked diligently to get motions filed and to get our other motions that were being heard in January prepared and to meet our expert disclosure. And now in the time since January 24th, we've had repeated meetings with experts with new information here to find out what it means, new information there to find out what it means. And it just hasn't allowed for enough time to focus on the discovery. And that's not all. We have these motions in limine. We've talked quite a bit about the dollhouse and the issues with the dollhouse. That takes time. Everything like that takes chunks of our time. We don't have all the discovery reviewed. That discovery consists of thousands and thousands and thousands of pages of police reports. I know the court has a little bit of a glimpse of that. The court asked the state to give them Detective Mowry's police reports that he authored. I think it took him 10 days to get them all gathered up to the court. That's one officer. That's just one officer. We have, I think, over 15,000 photographs.
4 years in the fall,
No,
the homicide,
no. It's 3 years in the fall since the homicide. Mr. Kohberger was arrested.
fall of 26 is what I was referring to. So 3.5 years.
The homicides happened in 2022, November. So we are 2.5 years since that happened. We're in 2025.
Oh,
Would be
yeah.
3 years in November of
Lord.
2025.
Happened in November of 2022. Oh, you're right. Never mind.
It's been a long day, Your Honor.
It's been a long day. I'm off it by a year, and I feel a
Yes,
lot
you
older
are.
than that, than having aged more than just a year in this hearing. But regardless, at what point
Thought you were enjoying
Are
the
you ready?
dialoguing.
does that mean that in no case where there's a lot of data, can we have the death penalty?
Your Honor, that
Took on a new death penalty case since you came onto this case. Why would you do that if you were not having enough time on this case?
well, Your Honor, when I agreed to take that case, we had a certain pace going in this case already. And then things have happened since that point in time in this case that have set us back.
The skeptic would look at this and say, well, this is what Judge Boyce did when there was a last minute discovery issue. This isn't a last minute discovery issue. And it seems like this could be viewed as being calculated to try to be a method to get the death penalty off the table by waiting until the end to bring to the court's attention the contention that you can't get through all the discovery.
They've said
I'd
that
ask
for
you
a
to look
long
at the
time,
things that have
Judge.
happened since I would say our status conference, the first time we met when I was hopeful that we could get through a number of the things that we still had left to do. There are things that have occurred that have taken an extraordinary amount of time. There are a lot of things that we haven't had a chance to look at yet. We continue to go through discovery as rapidly as we can. We're just not going to get through all of it by the time we get to trial. Part of that is the way that it's organized. And that's why part of our request is to have the state give us the documents they rely on. And
With giving hot documents is if they don't point out a document that you later say, oh, we should have known about that one. Now somehow they're culpable for not seeing the document the same way you did. And so that's why courts are very hesitant to employ that remedy, because it makes the state kind of do your job for you.
Your Honor, I would let the court know how we've received discovery in this case. And this has been a topic between counsel since the initiation of the case. The discovery goes to the police department, and then sometime later, the state gets it, and then they get it to us. So there's a delay already, but the documents don't come in any organized fashion. When you received all of Detective Mowry's police reports, those would have been scattered over probably a year for us to get. We litigated the video 1112 King video. We litigated that for about a year before we got the full copy of that. Those are all things that take time, and we are now months before trial with the cumulative effect of what's happened. And we now are faced with the issues with expert disclosures. Hearing the state today, I don't expect they're done trickling in expert disclosure after expert disclosure. At what point is it enough when we can be counting on that's it, we can get ready? The court's discovery deadline came and went. A lot of additional discovery has come past that deadline.
Fairfax.
At what point is that enough?
Fairfax.
I'm picking up more
Norfolk.
discovery today if I can meet up with the prosecutor.
Discovery ongoing while trial's happening.
Penalty-based discovery?
I don't know. I haven't seen it yet.
That's part of my problem is I don't know, because you're very vague about what it is you haven't been able to do.
Well, let me tell you
Look at
then.
all the discovery.
There is surveillance video from all of the university, all of U of I, and there's probably some pretty critical places where that discovery or where that video exists. I haven't watched that. I've sat down to watch it on several different occasions, and other team members have sat down to watch parts of it too, to try to see what's there. The way we've received it, it's not labeled in any fashion at all. I can open up a folder and I can look at something and figure out what date and time that's from. And there's multiple cameras and multiple days. There's no index, there's no guide to what it is. So I haven't looked at all of that. There's a couple of additional video footages that I haven't looked at. Now, if we want to start talking about cell phone data and third-party digital data, I have an expert who said it would take 3 years for him, an expert who knows how to do this, to go through every single piece of that. Now, he's been through a lot because we've had a little bit over 2 years to work on that. Not a full 2 years because we haven't had that discovery for the full 2 years. But there's quite a bit that I haven't looked at. I don't have an expert giving me even a report. We're not completed with that. I think I've read most of the police reports in this case, but I haven't read the thousands and thousands and thousands of tips that came in on this case. Don't think they're all not relevant though. Recently, we came across a tip just in trying to work through some of these issues. We came across a tip that would appear to be an alternate suspect. And we're trying to work through that as rapidly as we can. It was quite a surprise to come up with that. There's got to be more in there that I need to know. We were disclosed a bunch of email communication between different law enforcement officers, different lab personnel. I probably have read about half of those by now, and different parts of our team have read different parts of it, but we don't have it completed yet. Those are some quick examples that I can give you. I've looked at every picture, and I believe I've read every police report. There's a lot left to do that could have things that are favorable to Mr. Kohberger. In January, I had to stop doing that because I had to start worrying about the expert disclosures that we didn't get. I continued that through February. We've responded to the motions in limine. We've responded to the dollhouse. We've met our deadline with our mitigation experts. We're meeting the deadlines that are set out, but there's only 24 hours in a day. This is what's happened here is not satisfactory. That the discovery is not in an organized fashion. It's not in a searchable fashion. We've encountered documents that have been locked, most critically, the entire DeSales record for Mr. Kohberger's education at the DeSales University. Those were locked documents. They were a complete mess. It took one of our team members probably 10 days to get them in an organized fashion where we could understand what document went with what other type of classroom or assignment or other event. I will tell you about the motion in limine we didn't discuss today, the self-authenticating records. When we received the state's initial list, these are the list of things that we want to put in with a certificate. We went through those discovery folders, and those didn't contain just one document. They didn't even contain a document that made sense about what the state was trying to do. That took me personally about 10 hours to go through all of those folders of discovery so that I could write a response to that. The state replied, abandoning wanting to use about half of those right out of the gate after I'd spent the 10 hours. And we come today prepared that the court was 100% right. Those pleadings weren't ready. There's not a packet with a certificate of authenticity for the court to make a decision on. The court was right. But that doesn't mean that I can't be prepared. Those things take time. And when we're talking about the amount of discovery that's left outstanding, everything that happens like that eats up those minutes. In this situation, Your Honor, it's not that we saw what Judge Boyce did in Vallow and thought this is a great idea. We are at the end of our rope doing everything we can. And I know about what Judge Boyce did. And I have to come to you and say, you need to do this too. This impacts Mr. Kohberger. I can't not bring this motion because somebody might think I was waiting to the last minute. I can tell you we weren't. We weren't. We've been working as diligently as we possibly can work on this case. We have understood the court's.
Have you gone to Judge Monson to ask for additional resources?
Well, Your Honor, we do have an additional resource. We recently added our attorney, Ms. Barlow, to
A team of another 5 or 6 paralegals, for example, to go through stuff.
I can definitely do that. I don't know how that puts the information in my head fast enough, but I can definitely do that.
Of having litigated many very large cases, you have staff to tell you, here's an important document. And then that comes to your attention from the, as you pointed out, the gigabyte or terabytes of probably pointless video cameras that nobody's ever going to rely on, that don't show a thing.
If I'd had a team of 5 more paralegals that understood the case already, that would be one thing. I certainly can ask Judge Monson for additional resources. I certainly can try to get somebody to understand what the issues are. I don't have a problem doing that, but that doesn't change where we are now. That doesn't change the things that have come up that have impacted our ability to prepare. I understand that the court has said this is the trial date, it's carved in stone. And I've done my best to adhere to it. And I'm here now saying that the death penalty needs to be struck so that there's fairness to Mr. Kohberger. The remedies for the court are to strike the death penalty and to have the state give us a list of Brady documents and the documents that they want to rely on. This is a huge amount of discovery, and we don't have the same resources of the state.
I'm going to get a list of the documents here in terms of exhibits in the next few days, I would imagine. I'm not sure. April what is that date?
Well, it's just a little over a week away. Ours are due the same day.
Well, but if there's things on there that you didn't anticipate, this is a process where there's the ability to add things by your part. If there's things that you didn't add, if you discover something else in there. The point is, you will know generally the universe of documents that the state's going to rely on in 2 weeks.
I will know those. I will know those. And when I produce mine, the state will know what I can rely on, but I don't know what I don't know yet.
It sounds like you would never know what you don't know, given what you've told me it's going to take, 18 billion years to get through.
Well,
Well,
I don't
whose
think it'll
fault
take
is
18
that?
billion years, Your Honor. I
Person with the
think that
duty to review it?
Several
or the
decades,
person
as
who
I
dumped
recall,
it
is
all?
what you'd said, or several hundred years.
I can promise you I won't take several hundred years, but
You see my point? That's what you said it would take to get through that, an individual. I have a hard time taking that at face value because that's not a realistic answer.
my realistic answer, Your Honor, is that we were working, and we still are working diligently, but the discovery was one of the biggest things that we were doing methodically, going through that discovery so that we could understand everything that the state had given us, even in its disorganized fashion. And that changed with the things that have come up over the last few months. Our entire plan, our schedule has changed to be responsive to everything else. And that's not Mr. Kohberger's fault.
Complex litigation generally, when you're in the expert phase. I mean, that's not unusual.
I guess, Your Honor, I think it's unusual when
Maybe
deadlines
if
are
all you're
blown by the
arguing about
state
is money.
or not
Judge.
adhered to by the state, and our client pays the price for that. So I do think it's unusual. I think it's unusual to receive discovery where you might get 23 pages of a transcript, and then 4 weeks later, you get the rest of that transcript. We have had to match up discovery every step of the way. I don't think that's usual. I think there are things that have occurred in the path of discovery that are not usual at all. And I think things that have happened.
I guess my point is if the discovery is being provided in that way, this is something I should have heard about in September.
I advised the court that we were not
But you had not yet gotten through things, but you didn't advise that the pattern of the way you're getting discovery in terms of, incomplete here and incomplete there, et cetera. That's all new.
I agree that that's new to Your Honor. I know that we discussed a sizable amount of recent discovery we had gotten. Those issues came up prior to this court taking the case over. We had talked about the way discovery was being received early on in the case. We filed discovery request after discovery request, in addition to talking about the mismatched way discovery was received. That has been put on the record. My hope was with the state's discovery deadline, with that cutoff date, that we'd be able to pull it together. My hope has been that until these new things have happened to shift us off the course that we were on. And I'm here to tell you about it today. I think it would be a lot worse if I stood up at jury trial and you said, is the defense ready? And I said, no, we haven't read all the discovery. So this is my opportunity.
Right, that would make me happy.
Well, this is my opportunity to let you know. We filed this motion several weeks ago. So the prosecutor and the court's been advised. We have been diligently trying to get through it all. We can't. It wouldn't matter if I had 10 more people right now, given the shortness of time with that. But I know that there are remedies the court can take. I understand I'm going to get their exhibit list. The court can order them to tell us what are the hot documents, where are the Brady issues. It's not enough just to give it to us in this volume of discovery. We need it identified, especially given the short time. But our position is that the court should strike the death penalty in this case. It will take the heightened level of pressure down, and it will allow us to focus on the trial phase only, rather than the mitigation phase as well. There is precedent in Idaho. The court knows. The
Circumstances were completely different, though, counsel.
I'm not saying our circumstances are identical, but it's a due process issue, just like was analyzed in the Ballo case. That was analyzed as a due process issue. because counsel didn't have the opportunity to be prepared. And that was grounded in other case law. That was Riviera versus Clementi, Grover versus Florida, and Lopez versus Matthews. And those apply now. We do not have an opportunity to meet the state's discovery, even though we've diligently been trying to do so. And this is the appropriate remedy. And we're asking the court to make the orders for the court for the state's disclosures and to strike death.
Oh boy, Ms. Jennings.
Judge, in this case, the state has made every attempt to try to comply with Rule 16. 7 days after defense counsel entered her notice of appearance, she indicated she wanted everything that we had. And we started the discovery process. This was continued routinely throughout this case. Generally, documents such as police reports, lab reports, et cetera, were bait stamped and then turned over, and essentially turned over in the same way that we received them, in the same order as they were done and turned over by various investigating officers or whoever. We put a bait stamp on them. Photographs were done in the same fashion. Larger files, and I could say that, for example, most of the files that come from the FBI tend to be larger files that can contain a multitude of different things. Those were placed in an AV folder and discovered.
Next. Were they meaningfully indexed?
I can tell you for FBI documents, the defense was provided essentially an index for all FBI documents because they requested everything that was on a shared drive for the FBI, and that was turned over with a searchable index.
Mention of a problem because of the password protection of documents.
Yes, and we addressed that. Actually, we first heard of that in, I believe, April of 2023. And Mr. Thompson wrote a letter to Ms. Taylor saying that he understood that some of the PDFs were locked, but advised counsel they could get around password protection by hitting print to PDF and then saving. And that allowed those documents to be searchable. They were advised of this over 2 years ago.
It's not over 2 years ago.
It's true, there's a large amount of discovery. There was a 6-week-long investigation prior to a substantiated tip that led to Mr. Kohberger's arrest. So yes, there was a massive amount of discovery. We extracted cell phones for anyone that had any kind of connection to the victims. We gathered surveillance video for weeks, if not months, of random places throughout Moscow trying to figure out what happened. So to answer your question, there's a ton of discovery, and the majority of it is completely irrelevant.
Are you aware of any Brady information that is in the the cameras that are not the ones listed in your route of travel? And
No, Your Honor, I am not aware of any Brady material, any exculpatory material that's within those videos.
No, because they didn't get those ones. Isn't that what we
The defense
established?
is right. All
earlier
discovery
hearing?
was routed through MPD. We have a central location for collecting all the evidence, all the information, and then it was sent to our office. And then it was primarily reviewed by myself and Mr. Thompson, given approval, and then immediately sent over to defense. Files were kept in the same way by our office as we've discovered. That's how they've been maintained. And the parties are just on equal footing in this regard. Defendant's motion is just replete with these mischaracterizations and just completely false assumptions. For example, they say that there's so many investigators involved on this case. While that might be true that there were many investigators involved on the investigation, those investigators don't help us in the administrative task of organizing and sending out discovery. Further, we do have a PBK case management system, but it is not at all the way that it is described in the defendant's motion. For example, we don't have this global search function. We don't have the ability to just generate reports based off of witnesses. Agencies can't just directly upload into our system. We just don't have that capability. The reality is we rely on a self-created spreadsheet. Throughout the case, defendant has filed over 20 separate requests for discovery. There's been 400 itemized requests for different items, and the state hasn't just simply responded with whether or not we complied. We directed them specifically to where they could find that specific item, if it existed, the location, the description, and the date that it was discovered. I would just go back to that massive dump that we were talking about of the 50 terabytes of data. Defense has had that for over 2 years. It's hard to, I guess, rebut a lot of the allegations because there's no specifics. They just talk in these general terms about all of this data. And I'm not totally sure how to respond other than we've given over the data as we've received it. And they've had the majority of it for several years. Most importantly, defendant has not specifically pointed to any particular piece of evidence that has been withheld or any actual prejudice suffered, and instead just points to the vast amount of discovery, which we have absolutely no control over. The state has in good faith complied with our discovery obligations, and there's just simply no basis for a sanction. And so we had asked this court deny their motion. Thank you.
Got that? 50 terabytes is fine if it's been 2 years.
This motion is not about withheld discovery. This motion is about discovery in the format it's in, the vast amount of it, and what's happened over the last few months that have taken us off track and our inability to be prepared. And that remains true. The 50 terabyte server that we received sometime in April of 2023 is the one that contains the U of I footage, and it contains a lot of footage around the town. We have been able to go through most of the footage other than the U of I. When the court asked the prosecutor,
Counsel, is there any known Brady material in the U of I
How would she know?
surveillance cameras?
Not to the state's knowledge.
Your Honor, I think you'd have to watch that at various relevant times to know if there is or not. I think when you're thinking about Brady material, when we're thinking about video surveillance, and we'll go back to what we talked about the vehicle before and how Special Agent Immel's going to testify, there very likely are vehicles, light and color, white or silver, on all kinds of different cameras. Those could be Brady depending on what he has to say, but they should certainly be looked at. We're trying to look at that as quickly as we can to understand that. We've watched a lot of the video that's contained on that server. Also on that server are vast amounts of bank records, vast amounts of cell phone for all of the people that Ms. Jennings mentioned, the deceased and people close to them and other people.
They've indicated that their experts have examined that and found no connection between
Can't
Mr. Kohberger
take
and
their
the
word
deceased.
for it, Judge.
I'm grateful
You
to
have
have
a
recently
duty
learned
to
that. I
investigate.
mean, that's what we believed.
He doesn't
But
understand
that was in that
defense
March
counsel's job.
disclosure when they said that they'd examined those, and those were computers, the 7 computers, I believe. It's that kind of thing that takes a lot of time. In addition to that server, there's all of the other information that comes in different ways. I'll give you an example of the delay. we received a lab report that was dated March 30th. The state received it March 30th, and this wasn't this year. This was obviously not this year. It wasn't even last year. We didn't receive it until May 8th. So the delay going from Moscow Police Department getting it, the prosecutor getting it, to getting it into our hands, that's well over a month. That's a long time for delay for the routing process. I think it's important to realize that the FBI index we have, you can't push a link and get to the document, but I do at least have that index. When we're talking about locked documents, the print to PDF, that's the problem. That's the steps, the additional steps that it takes when we're talking about thousands upon thousands of pages of documents. I think it's hard to imagine that there's not material somewhere in there that isn't favorable to the defense in some way. We recently found that, and we found a pretty good lead that we're trying to follow up on. And that is really what it comes down to.
Whew.
This is not
Come on.
organized
Let's get it
data.
done.
It's not easy to go through. We've made
Let's get
substantial steps. The due process requires that something be done, and striking the death penalty is the thing that must be done.
All right, well, I will take,
You know you're going to take it under advisement.
with respect to the witness, with the exhibit list. Now, I will say the exhibit lists need to be specific and detailed, not Exhibit 3 video, not Exhibit 3 video from X bank. It's Exhibit 3 video from X bank, minutes 25 through 27. Detailed, specific. I would also look at as a issue whether it might be appropriate to require the state to certify that it is unaware of any exculpatory material that it views as exculpatory, that it would, for example, feel it would have the obligation to bring forward if the defense were unaware of it, that has not been identified by the defense throughout the motion practice and discovery and their exhibits and witnesses, et cetera. I will look at the issue and issue a written opinion on the matter, because I think obviously at a minimum for appellate purposes, you'll want that. So with that, I don't believe we have any other motions
For
to take up
appellate
today. Did I
purposes,
miss
they'll
any?
want it. Well, didn't that just tell us everything?
We wanted to approach the court in regard to the review of the jury questionnaire and whether that can be conducted remotely, and when the court would like to do that.
Yeah, so I haven't had a chance to look through your responses to my proposed jury questionnaire. I will do that. Keep that just as a tentative. We can do it by Zoom or WebEx or something like that remotely. There's no need to travel down here to do that. And it may be that I simply just need more time and we'll tell you, let's take it up at the pretrial conference. I think we'll have time if we get it done at that time. So
Thank you, sir.
I didn't anticipate that I would actually get to the point where I would have given you my draft of what I think it ought to look like by this deadline. So that's part of the reason I had calendared it. So.
And I can tell you, we very much appreciate that the court was able to provide us with your draft, because I think that simplified the issues. And as you review them, there are just a handful of things that are potentially in dispute.
All right. Anything else from defense?
Your Honor, with regards to the exhibits, because they're now scheduled to be due the same day, we'd actually like to see if we could have an additional week.
I will give you additional 1 week after the state's exhibits are due.
Thank you.
All right. I think with that, we are adjourned. Thank you.
What a long day. Okay, here's the issue. Here's the issue with the death penalty motion, guys. I mean, there's a lot of issues with it. I do not have a lot of confidence after hearing Judge Hippler's comments about this that he appreciates what the duty to investigate is. You don't get to take the state's word for it. The entire case is an allegation by the state. You don't get to just take their word for it. You have a duty to investigate it, and you are ineffective if you don't. So this idea that we can just ask the state, well, do you have anything? Is any of that important? Are any of the tips substantiated? That's not investigation. They have to review it themselves. They have to make their own independent exercise of judgment. And there's so much case law about this that you can reasonably restrict your investigation, but only to the extent that you have a basis. You have a basis in reason for being able to do that. Not just I didn't have time, not just it didn't seem important. And the fact that this is a capital case and it's a heightened responsibility is extremely alarming. But here's the thing that's worse. You have a right to effective assistance of counsel in non-death penalty cases also. You also have a right for your attorney to be informed about whether you should be convicted or not, regardless of what the penalty is. So if trial counsel isn't prepared to be able to meet the evidence and make a case, and that's in the record now. This is in the record. They have made a strong record. We haven't reviewed everything. And we can't, and we won't. That is now in the record. That goes to the validity of the conviction just as much as it goes to any penalty that gets imposed. So, I mean, it's a mess. It's a mess. I don't know what you do about this other than continue the trial. I really don't. You can't have a case go forward to trial where defense counsel is telling you, I'm not prepared. I don't have time to prepare. Here's a record of what I haven't done. Because anything in there that could help, you've now given them a post-conviction issue. It's really, really not prudent to do that. Maybe he's willing to gamble on the state's word. It sure seems like he is. But the defense can't. They're not allowed to. Very explicitly, not allowed to just take the state's word for it. Take the state's witnesses for it. They don't. They have to look at it themselves. They have to make their own determination. So, yeah, I'm really not thrilled with what it kind of sounds like here as far as Judge Hippler's understanding of defense counsel's roles and obligations. When Ms. Jennings was talking about the defense's motion is just replete with these misrepresentations, where was the outrage about that? Wasn't that the type of accusation that we said we weren't supposed to be doing? But it's not a problem. It's not a problem if the defense, if the state gets up there and impugns the defense counsel's litigation of their issues. You can get up there and say they're misrepresenting things, and that's okay. No, they're advocating. You can say they're wrong about certain things. They're mistaken. But you're up there calling them liars to make their point, and where's the outrage? That's only for Mr. Ray? That's only for Mr. Ray? I really would like to see some of the same energy being shared, doesn't seem like that should be, a real egregious expectation. Is that hard to treat both parties the same? If you're going to get all upset about him doing it, shouldn't you at least tell her, Ms. Jennings, I just told you guys not to do that kind of thing? No, it's just, completely gone by unpassed, no comment on it. And guess what? Because of that, she's going to continue to do it. It's a habit that she has. She likes to call the defense liars just as much, if not more, than they have called her one. So just maybe pay attention to that, Judge. Just maybe pay attention to it. Oh, that was a long day. I'm kind of flipping back through my notes to see if there's anything else here that we haven't kind of already recapped that we need to. He's absolutely not going to give them, the issue of autism spectrum disorder should take the death penalty off the table. It's above his pay grade. That's not for him to decide. That's just, it's a novel issue. It's an issue of first impression. Because of that, he is not going to be the one to say yes. He's going to say, if I'm wrong, the Court of Appeals can fix it, or the Supreme Court can fix it, because that's within their pay grade, not his. So I'm really, not expecting anything along those lines. And I just also find it, a little bit telling. I mean, I described the judge as slippery, and he is. And part of the slipperiness is the shifting of the goalposts. When you don't like the defense asking you to take account of certain facts, you characterize it as, well, you're asking me to make a factual determination. That's for the jury to do. But when it comes to, I don't like the way the law is going, you'll bring up the facts to suggest, that should drive your decision. And I'm pointing specifically to, well, but, the historic fine motor skill issue, like that should drive. If they're not testifying, he doesn't have any capability to do the crime. He's not supposed to decide any facts about whether there's a motor skill issue or not. That isn't his role. He's already said that in other contexts that it isn't his role. He knows it's not his role. So why would you bring it up as if it's your role? Very, very difficult to pin down. And, I hate to be a little bit cavalier, but he does have a background in complex litigation. We know that his background is defending doctors and hospitals, med mal types of situations. Those can be complex cases, but they're about money. They're about money. They're not about, are you going to put somebody in front of a firing squad? So the standards are a little different. And the significance of what you need to do, what your obligations are as an attorney to do your job, are a little bit different. Whether you're malpracticing as a civil attorney is quite a bit different than whether you are providing effective assistance as a capital defense lawyer. And I don't like that he seems to be conflating these things, trying to make them equivalencies. They are not equivalent at all. I don't care if your hospital gets a judgment for a couple $1 million that, by the way, their insurer will pay for anyway. I don't really care about that. It's not that big of a deal relative to somebody getting stood up against a wall and shot and killed. That's kind of important. And this is why I often just don't love. I don't love when civil lawyers end up presiding over criminal cases, especially serious criminal cases, things like death penalty cases. They don't have the background for it. And they also rarely have the humility to recognize that your experience defending hospitals and doctors does not translate to defending somebody who may be put to death. It's not the same thing. Well, that was a lot. I'm surprised they got through everything, but he really ground it out, didn't he? He really really pushed through and got it all done. Oh, I should have kept track from my Substack. I mean, of course, we don't have the actual rulings yet. I think we got a pretty good idea the way that they're going to go. But I did put out all my predictions for how I thought he was going to rule on them, and so I'll be interested. I'll of course be interested in seeing my own record. How well have I read this situation in this courtroom with this court? Kind of have a feeling I'm going to end up pretty close, but of course I think that. Of course I think that. And I guess we'll just have to wait and see till he gives us all these written decisions that he's been promising. But by and large, I think he's not going to grant most of the defense motions. He's going to let in most of what the state wants to let in, and maybe reserve somewhat on some of these other issues. But I guess we'll just have to wait and see. Well, let's see what comments you guys have left for me in the meantime. Papa G, Appa P inverted. How is the state going to put the tip to Kohberger without the IGG? Well, that's the $1 million question, isn't it? I mean, the state has given these kind of examples of how they want to characterize it. They want to say, oh, we got these thousands of tips and none of them bore fruit until we got this one about Bryan Kohberger. Well, I'll tell you something I don't like about that either. That's putting it in the same kind of category as all these people that phoned it in. Somebody phoned in a tip or emailed in a tip. It came from a person with some sort of like factual suspicion or theory. And that's really not what happened here, is it? It's not that same kind of, we got a phone call on the tip line, and so we went and checked it out, and it happened to pan out. That does not put my mind at ease as far as the possibility that the jury is going to speculate about the source of this tip, what the tip was, where it came from, and why. And particularly if we're in a situation where part of what the jury is going to be hearing might be other people involved. It's just such a natural place for their minds to go. I wonder if it was that person, if it was the accomplice, right? Because it just gives the state an easy pass there, an explanation for all the things they can explain, right? The DNA that doesn't match, et cetera, et cetera. Well, that's just the accomplice, the guy that phoned in and pointed them at Bryan Kohberger. So I don't know how they're going to do this. They're going to have to try to come up with something that, isn't misleading. And, that seems pretty straightforward. It was not anything for Mr. Thompson to get butthurt about like he did. File a SIR reply. So I don't know what this means about falsely. Well, I do. I understood exactly what that meant. You're giving a wrong impression about the source of your information. It needs to be clear. Why wasn't there a sketch drawn like every case? Because DM said that she wasn't able to. She didn't see enough of the guy to be able to prepare a composite sketch. And this to me makes perfect sense. It makes perfect sense because when people are afraid of something, you tend to engage in avoidance behaviors. And one of the most common avoidance behaviors, you look away. It's potentially aggressive and challenging to look someone straight in the eye, look them in the face. Takes a fair amount of confidence to do that. So if you're scared of somebody, you're way less likely to do that. You're much more likely to look away and, don't pay attention to me. I'm not any threat to you. So that's what I would expect somebody who is scared of an intruder in their house. That's honestly how I would expect them to behave. I would expect them to not really see the person very well, because I wouldn't expect them to be staring that person down. That would be aggressive. And most people aren't going to challenge somebody that they're afraid of. So bottom line, she didn't see him clearly enough to be able to describe enough to produce a composite sketch. Me, myself, Andrea Burkhart, SCOTUS will hear Karen Reed's petition conference on 4/25. Is it a good sign there is conference scheduled, or is it a nothing burger? It is normal process. Basically, since the state filed their notice that they would not be filing any kind of briefing on the petition, normally when they set the petition for conference, it's like, certain length of time after they get the petition or get the answer to the petition. And I want to say that's somewhere in the ballpark of like a month. But it can depend on a lot of different factors. So since they got the notice that the state isn't filing an answer, they're able to do it sooner. So that's really all it is. They're going to meet and decide the petition. This means it's been circulated. It'll go to the court. They will conference. If they get 4 votes to say review it, it will be reviewed. If they don't get 4 votes saying to review it, it will not. And we'll find out at some point after this conference date what that decision is. So just a pretty normal procedure on this one. She can't say yet how the girls are involved. I am not, convinced that the girls are involved. And I've said many times it would be extremely imprudent for her to even suggest the girls are involved unless she can really substantiate that, because the jury is going to be very sympathetic to these girls. They're going to be very, very sympathetic to the surviving roommates. They're going to put themselves in the shoes of those young women and imagine what they would have thought and felt and experienced under those same kinds of circumstances. And they're going to project all of that onto them, frankly, whether it's, deserved or not. And so it would not be a good idea to go down that road unless you can really, really back it up. I'd be surprised if we hear anything about that at trial, quite honestly, but we'll see. I don't know. Duncan, Idaho, why is this judge doing the Joe Biden whisper? I must have missed when he did that. We did have a couple times where the sound cut in and out. His mic seemed to cut the sound. So maybe it was that. Maybe he's tired. I don't know. Wish I could tell you. Lil Har Oak. Wouldn't Bryan be in the 3,800 people from the tower dump? If not, doesn't that present some element of exoneration? Not if his phone is off. If his phone is off, it's not going to be connecting to any tower. It's not going to be producing timing advanced data or any kind of connection at all. So he wouldn't be expected to be in the tower dump if he turned his phone off and then went there. So that's kind of part of how the state is arguing that the turning the phone off is consciousness of guilt, right? That he would know he did it deliberately to try to conceal the ability to track him. Critical Darling. I don't know how this came up. Hitler doesn't even understand it. So yeah, they need someone to explain it. I guess this maybe has to do with the Amazon data. I talked about that. If it needs interpretation for the jury to understand it, it's expert. It's not just fact witness stuff. It's expert stuff. So if they don't need that, you don't need the witnesses. Just give the jury the records and you can be done. But I suspect it's not anywhere near that simple. But it still remains opaque exactly what this is, what's going on with it, what the information is. So I tell you, things really just keep coming, going like real back and forth with this case. It's a little bit of the roller coaster. Like he first gets arrested, and everybody's like, "Great, he did it, so glad." And then we start getting more information about what they don't have, and then it's like, "Oh, maybe he didn't do it." And then, we get the state telling us, "Oh, he bought this knife," and then, was looking for a replacement knife right after the murders. Like, "Oh, that doesn't sound great at all. That really sounds like he did it." But then there's like all this unaccounted for blood that he's excluded from at the scene. Like this situation, it's a little bit of a mess. The more we hear, the more I think he's going to testify. I do. I mean, I just don't know how you don't. I really don't. I just don't know how you don't. If he wants the jury to know, I wasn't there, I was at Wawawi Park, he's going to have to be the one to say it. If the jury's going to hear you bought a knife, and by the time the police searched all your stuff in late December, early January, you didn't have it anymore and you'd been looking for a new knife, you're going to have to explain what happened to your knife. You're just going to have to, if you don't want to be convicted. So I can understand the defense's perspective in terms of they want to have the fullest picture possible available to the jury about how that's going to go. Because it sounds like, from how they're kind of laying the groundwork here, they don't expect it to go well. They don't expect him to present well. So that is unfortunate. But that's just it's the reality of criminal work sometimes. You don't always get likable clients, just like you don't always get virtuous victims, so to speak. But it doesn't matter. You're not supposed to judge people or crimes or things like that on character. You're not supposed to not find that a crime happened when it's been proven just because you don't like the person, or you think maybe they deserved it. And you're not supposed to convict a defendant, even though they haven't really proven it was him, just because you're like, wow, that guy is super creepy, and I don't like him. I would say, out of all of these motions that we heard today, the one that probably concerns me the most in terms of how the judge is going to rule on it and what the implications of that are, is the one about, can we bring in the fact that he's got this autism diagnosis in the guilt phase? I think it is very much putting your head in the sand to ignore the fact the jury is going to be, like the defense has argued, inspecting him from the moment he walks in the courtroom. I really appreciated the study, the mock trial that they presented, that suggests, hey, just let the jury know this is an issue, educate them about it, and they won't be so judgy. They won't sit there, oh, he's probably guilty because I don't like how he sits and stares, at the witness. He's probably guilty because I don't like how he sits there and fidgets in his chair. He looks nervous. There's just all these interpretive things that people can do, and then you start to run into confirmation bias with that as well. Once you start to form your opinions about the case, if you start to think, well, maybe he did it, then you start looking at him through that lens. You start looking at his behavior through that lens, and you start interpreting it through that lens. So I feel like it was a missed opportunity. I really wish the defense had pointed out, we're not asking the jury to pay attention to his in-court demeanor. It's actually exactly the opposite. We don't want the jury to pay attention to his in-court demeanor, and this is giving them the explanation for why they shouldn't. You shouldn't do it in any case, but even in this specific case, it's not significant. So I feel like that should be fair ground, but you know, I'm not convinced they're going to allow it. But when it comes to other issues that may come up in trial, if the state is getting into behaviors to suggest this is consciousness of guilt, he was wearing gloves. He was wearing gloves when he was bagging up the trash when we raided the house at his parents' to arrest him. I think that's going to open the door for the defense to say, yeah, he has autism, and as part of how that affects him, he wears gloves a lot. He's got a kind of fixation about that. He's germophobic. I think that's going to open the door. So this idea that the state is going to run a completely clean trial for 3 months, that's not going to open up any sort of door like that. I think it's very, very unrealistic, not likely to happen. John Beattybot, I don't understand why mentioning IGG is a problem. Well, it's not necessarily a problem. It's just that the state doesn't want to bring it in themselves because they don't want to open the door for the defense to be able to point out, you got up to all these shenanigans with the IGG. You did all this rule breaking with the IGG. You got into the database you weren't supposed to get into. You went and made the arrest that didn't meet your standard under your policy for making the arrest. They don't want to open the door to that. The defense doesn't really want to bring it up because, my suspicion anyway, the defense does not want to concede that the DNA on the knife belongs to Bryan. They want to litigate that. But bringing in the IGG, it's almost like it corroborates. It's a different pathway to establishing that that the DNA on the knife belongs to him. So that's why I think they wouldn't want to bring it in. It just makes it, you know, look that much more like identifying him as the contributor is the right decision. Is that a wise strategy? I don't know. I don't know what all they have. I don't know what all is in the discovery, what they have to work with, what their possible theories are. To me, it does not seem like the best approach to try to challenge the DNA as being his, but they may not have much choice. You know, if he's buying a K-bar now, right? This is the issue, the stacking of the inferences. How many coincidences do you have before they're not coincidences anymore? It's circumstantial evidence. And so if they got both of these things, you got his DNA on this type of knife, and you have him buying and owning this type of knife and then no longer having it after the murders. I really think that's going to be too much for the jury to say, well, it could just be a coincidence. So if they can't attack the knife purchase, they're going to have to attack the DNA. They just can't allow both of those, coincidences to stand. I don't know if they're going to be able to, but we'll have to see. John Beattybot, do the Cy-Ray and AT&T affidavit dates do anything to explain his not addressing the 7-day issue? I don't think they do, because they just kind of kept talking past each other. The AT&T affidavit only talked about the GLDC process. The affidavit was from the Global Legal Demand Center guy, and it went to that way of getting the records. Cy's affidavit went to this backdoor method that he says the FBI has available to them, or used to have available to them. So it's not covered by the same information that's in the AT&T affidavit, but he didn't specifically address this argument that there's only a 7-day retention of these records. So I don't know whether there is or not when you're talking about this backdoor. That is a problem in terms of their factual record that they've made on this particular issue. It does seem like a very easy thing to address. And so the fact that it wasn't addressed, The fact that it doesn't seem like it was an oversight, it's not like Ann Taylor said, "Oh, you know what? It didn't occur to me. Let me get a supplemental affidavit from him." It doesn't sound like anything like that. So, yeah, that's the issue. That would explain the difference between why they got some timing advance data, even if they have to use the back door that they didn't initially disclose or want to talk about, but they weren't able to get this timing advance data. It wasn't requested within the required time frame. So we'll see if that goes anywhere further, but I kind of suspect this might be the end of what we hear of it. So a little surprising to me. I guess we'll see though. We'll see if Cy Ray's got a surprise for us at trial. I don't know. Well, guys, that was a long one. It's 8 hours and 50 minutes on the stream now. I'm getting a little hungry. I think it's time to check out. And yeah, here we have 12 new Americanas, little chicks over there that the dog is periodically barking at, because that's what she does. She likes to charge the chicken coop, the chicken yard, and bark at them, try to freak them out. It's very exciting to her. This is what you get with a bird dog. I would have loved to be able to have the dogs and the birds coexist. It is just not possible with this dog. Maybe the breed as a whole, I don't know. If anybody's got a Vizsla that you have managed to not eat chickens, that I would love to know like how you pulled this off. But I don't see that being a reality in our household. So we have to be extra protective of the chickens, but nevertheless, the dog does enjoy her little fun there, getting the scare out of them. But I'm going to go start handling them, in the hopes that they might grow up to be somewhat friendly chickens. You can always have some hope. I don't know when we're coming back yet on this case. I know we have the pretrial conference next month. Of course, I don't remember the exact date for that off the top of my head too, but it's not imminent. In the meantime, we're waiting for Karen Reed's jury to be seated. We're waiting for that jury to be finalized. I saw Christina Rex reported yesterday that according to Karen, they're expecting opening statements to be next Tuesday. We'll see. I'll just continue to follow it. And as soon as they're ready to do openings, I'm going to plan to start watching that. And we'll be watching that one again through to the bitter end, see how long it takes this time for them to get around to trying to prove that John O'Keefe was hit by a car. Will they wait until like day 20 something like they did last time? I don't know. We'll have to see. I've already talked a little bit about the Richard Allen stuff and why I don't intend to specifically go back and cover that. I've already talked about these videos. Definitely encourage you to go back and look at that trial coverage if you're so inclined. But I don't really have anything to add to it. It really pissed me off back when I saw them the first time, and I'm really glad that finally now, almost 6 months late, everybody else is finally getting an opportunity to see what I saw and to make your own decisions about it. I've never, purported to be any kind of authority on reality and like whether this is good evidence for the state, bad evidence for the state. I mean, I'm giving you my own opinion, but opinions can differ. And I'm not an authority on deciding that. So everybody gets to decide for themselves. Does this sound like Bridge Guy? Does this look like an innocent person? Is there anything wrong with this process that would make you call into question whether he's the guy that did this or not? I said back when it happened, this to me does not look like a guilty man. It just doesn't. I've seen a lot of interrogations. This does not look like the guilty man. Doesn't look like how they behave. But people can draw their own conclusions about that. So that's pretty much where I'm going to leave it at this point. Of course, people, if you've got questions about what happened, or anything like that, you can definitely let me know. But I don't intend on doing specific coverage of that at this point. I'm just kind of, as far as Delphi goes, I'm kind of waiting for the appeal process to get moving, so that we've got court stuff that we're able to talk about. So that's where I'm at with that, guys. It's been fun. I've enjoyed our dialoguing, as the judge might say. Oh, what even was that? We're not here for you to be amused at the dialoguing, judge, or for you to be entertained. Like that's just what the court process is. We're all here doing our jobs. One more comment coming in here. Anonymous nobody. Defense, dog ate my homework. I was sick. I didn't understand the assignment. I need more time. It never worked for me either. Well, I'm willing to bet you haven't ever defended somebody who might be put to death by the state. So I would expect that that's probably why you've never been in that position. The reality is, yeah, defense attorneys don't have anywhere near the resources that the cops do. The reason why there's this massive volume of discovery here is because there were, a couple hundred, maybe, if not more, cops working on this case, producing all this information. And they've got like 5 people to be able to go through it all and independently review it and make sense out of it. So it's a major discrepancy. And that's pretty standard. That's part of how the system is. So I would hold off on deciding on what works until you see how the whole thing pans out. And by that, I mean, not just the trial, but we also got a whole appellate process to get through and stuff as well. All right, guys, I'm going to go ahead and log us out now. Thank you once again. As always, thank you for being here with us. Thank you for your contributions to the chat. I get a chance to kind of watch it scroll by a little bit more when we're watching a court hearing. And one of the things that I love seeing is that it's not an echo chamber. This is not an echo chamber. We got people with different opinions over here, and that's totally fine. We like debate. I think that's an important part of the process. It's what the jury is going to be doing. People with different perspectives, different interpretations, coming in, trying to make sense out of what they're hearing and trying to come to a consensus about it. So I like that the chat, in at least some small way, kind of mimics that process. And other than that, guys, it's a beautiful day. Let's not forget, what's really important. Yes, these cases matter. Society at large matters. Current events matter, but you matter. Your well-being matters. And sometimes just taking a nice sunny walk outside, maybe holding a chicken, can really do a lot for your well-being. So thank you all once again. Really appreciate all of you and your tuning in. We will be back when Karen Reed gets underway with the opening statements. I will keep you posted on when that happens. So in the meantime, thank you again, everybody, and we'll see you soon.